The first matter is for final hearing by arbitration. One institute minority education institute is at crisis because high tension cable is passing. Already exchange, DVD has been exchanged by only final hearing is pending.
Hand over.
And the other is one contractor agreement was illegally terminated. He filed the petition in 1 year back.
Wait for some time. Yes. Pardon, what? Hand over. Yes. Application hand over. Yes.
No order has been passed. You found my passport, but the authority they have blocked my passport. Therefore,
Yes.
So I have purchased a truck on loan. I have given all the entire amount, but they are asking for a huge parking charge. Parking charge, car parking charge.
Wait for some time. Yes.
Well, I am a hospital, my lord. I have filed this case challenging the order of a regulatory commission. Clinical is, my lord, the difficulty is the department is not granting me the West Bengal health scheme to avail because the patients are coming, but they are not able to avail because of this pending matter.
Not being able to?
Because I have to enlist under West Bengal health scheme. The patients are coming, they are not being able to get this.
Hand over.
Scheme.
Yes.
My lord, in regard to item number 107, 108, 109 and 110, your lordship was pleased to fix the matter on 8. On that day, it was appearing at item number 59, and I have mentioned the matter, my lord, in both the matters. Your lordship, my lord, asked me to, my lord, mention on Monday. And my lord, there is a great urgency in the matter. And my lord, your lordship was pleased to pass a direction that no affidavit is required. Other side also consented.
What is the nature of it?
My lord, this is an interpretation of a single clause of a contract, nothing else.
Very well, hand over. But it upgraded list. Yes. Yes.
My lord, may I be permitted to mention, my lord, some matters which are appearing before your lordship?
Some matters.
Not yes, my lord, analogous matter. 82. Analogous matter. My grievance is this, my lord, that work order has been issued, my lord, in favor of the petitioner. Petitioners completed the work within the stipulated time. My lord, the first study bill, my lord, they have already sent, my lord, but after deducting some amount regularly.
Please wait for some time. There are more urgent matters. Sorry.
Next week, my lord, I will tell.
My lord, mentioning item number
83, my lord. I'm praying for indulgence for putting in the top because the overhead high tension line is lying on the courtyard and upon the building of the residence. Respondent authority not taking any action.
And the word as upgraded matters.
And give you obliged.
My lord, email.
What is the urgency?
It's my only source of income.
Can you be a bit louder, please? Yes.
It's my only source of income. My medicine shop, my.
Thank you. Only source. So many sources of income are stalled. I mean.
Not renewing my license. I have my shop for 50 years.
Excise license?
No, medicine shop license, drug control department.
Please wait for some time. No, not now.
But our notice to my other side,
yes,
I'm mentioning item number 252 of the monthly list. But in a maintenance proceeding, my lord, the husband, after facing an order of maintenance, there is a complaint as against the wife and his family members that they are Bangladeshi nationals. My lord, police causes an investigation, nothing found. Now, my lord, all their Aadhaar cards, voter cards have been suspended.
Hello.
But kindly, my lord, takes it up as an upgraded.
Upgraded it, yes.
And my lord,
my lord, mentioning item number 126.
14 application bill service act is pending more than 1 year.
Hand over. It upgraded it.
The list as per application.
Application, please hand over.
Mention for inclusion. The urgency is that my lord, the petitioner.
Please hand over. Hand over. Yes. Upgrade very well. Yes. This should take some time, Mr. Dattu. Is it in the list? In the list? Hand over, let it appear as upgraded. Let it appear in the upgraded list. It'll upgrade list tolar dike diye do. Yes. No, him. Yes. Use from whom? Hand over. Yes. Thank you. What is the urgency? Not urgent, not now. Not right now, not right now. Yes. Application handover, yes.
New connection, my lord. The shopping, my lord, running, my lord, for my lord, last 15 years, my lord. For the last 1 year, my lord, you get to the connection of this country, my lord.
Wait for some more time, yes.
The urgency is that the on-site of the petitioner's devices by irrigation land is there. The irrigation land by the private respondent is constructing the unauthorized construction by without permission of the authority.
Handover. Yes. Yes, Mr. Bandhavat.
An urgent unlisted motion, my lord, to remove that PPA. Urgency is, my lord, the demolition notice was there under the state highways. My lord, 13th was date, my lord, my advocate, my lord, had given a, my lord, therefore it has been deferred. My lord, today it can be demolished, my lord. So it was time was, my lord, 13th.
Oh, the demolition order was passed against you.
Against me.
Very well, 2 p.m. at leave the other. 2 p.m. today. Yes.
For upgradation, this petition on 21st December 2022. The stop of the petition is going in track by the default of Metro Rail. The petition made a representation. The Metro Rail announced the 24 parts of competition. My number is 11, but did not competition till today.
Please wait for some time. Compensation, wait for some time. Yes.
May I renew my prayer after 1 month? What happened? I executed a power of attorney. I wanted to revoke that power of attorney, but you have another registered document. The register is not allowing. The difficulty is, my lord, they are merely executing dates by misusing this power of attorney. Kindly appreciate, my lord, each and every deed I need to challenge thereafter.
Handover. Yes. Please handover.
May I have your lordship?
Yes, Mr. Bhattacharya.
Item 519 of the combined list. My lord. On behalf of the railway, my lord, this is a matter your lordship has been pleased to grant stay of the, my lord, award of contract for outsourcing of the railway catering system at hospital. And your lordship granted stay up to 31st August. And until further order, whichever is earlier, and the next paragraph, my lord has stated until further order, the railway authority is not to take any steps. So I have already filed an application for vacating the interim order. Immediately I get knowledge of this, my lord. Your lordship kindly.
Vacating application, please hand over.
Man, I have, it is appearing in the list 519 along with that.
Application whenever it is taken up, Mr.
Let it be placed under the heading application, my lord. That is.
Oh, acha.
It is appearing with the.
Please give some sort of a slip giving the item number. Application heading. It will appear as an application, Mr.
May I be permitted to mention
application heading? Applications I take up Fridays. Today it's wrongly appearing. I'll take up from the top matters. Fridays contempt application.
This will be shifted to Friday, my lord. This matter will be shifted to
Friday. Yes, under the
any Friday subject to your lordship.
My lord, may I be permitted to mention item number 476 of my lord's monthly list, my lord. I'm renewing my prayer, my lord. The Debt Recovery Tribunal has, my lord, passed in direction on the pre-deposit. Lordship will appreciate, my lord, there has been substantial change in the law. And my lord, 18% interest has been awarded, my lord, for the last 2 months, my lord. We are, my lord, for our
2 months is nothing.
My lord, but we, my lord, we are facing the execution proceeding.
No, Ms. Ghosh, yes. Yes.
Lordship, Lordship, I'm praying for your Lordship is very kind. Leave your Lordship. What has happened on 11th of August, your Lordship, the health department has issued another notification whereby your Lordship, the zone-wise division given to facilitate the beds, your Lordship, with regard to the petitioner, the
hospital beds,
your Lordship, with regard to the petitioner was authorized by the Pollution Control Board to operate for 20,000 beds. That is to be reduced to 15,000, and the other respondent who has been facilitated is authorized to operate for 30,000 beds. That has been increased without any reason to 38,000 beds. That is to be made effective from the 18th of this month, your Lordship. The notification is of 11th August. Lordship, I'm praying for leave to file, your Lordship.
No, file it and give the number. Today itself, file it and give the number.
Lordship,
this will appear as upgraded matter on.
Lordship, this is not appearing, your Lordship. I'm praying for your Lordship.
This will appear directly under the upgraded heading.
Lordship. Lordship, another matter, your Lordship. This is
no other matter. Yes.
I file a writ petition, my lord, for the registration of my DIN number. My DIN is cancelled by ROC. Contrary to section 58 of the company.
In numbers, please wait for some time.
No, it was pending for 1 year, my lord. I'm unable to.
I
carry on-
appreciate, but nothing doing. No,
I am not
yes.
carrying on my business, my lord. My business is
Sorry,
suspended.
Miss Trivedi, no, not right.
With your
Yes.
lordship's kind,
I just made appear.
Yes.
with your lordship's kind, your lordship, one hotel, one residential apartment, huge cost incurred for restoration of the same due to an event of act of
Your
God.
family quota is over today, probably.
No, your lordship will kindly
Yes,
note
your
that-
family quota is over.
Your lordship will kindly know. I have mentioned this matter at least 3-4 times, your lordship.
No, no, no. Your
Lordship,
family
kindly-
quota is
kindly
over. Come back on the next day. No.
Your lordship will kindly consider.
What is urgency?
The urgency is our survey report has not been provided to me, and I have been running from pillar to post in stoic silence, nothing on there.
Not right now. Not for family. Ordinarily, on ground of urgency. No. Yes.
I am mentioning the matter, item number 431 of the combined list, my lord. My lord, I have participated in the tender, my lord, tender terms and conditions that you have to make objection within 48 hours. I have made the objection within 48 hours. That has not been considered, my lord. On the other hand.
Ms. Ghosh, you are over done with. No. Your quota is over to no, no. No. No, please continue. Yes.
On the other hand, my lord, the work order is given to the others, my lord, violating the terms and condition of the, my lord, tender. My lord, for that I am suffering, my lord. If the work is completed, my lord, then the agreed application.
Where do you hand over? Yes.
My lord, this matter was appearing from the 4th of August as a fixed matter on the 8th. But suspiciously, my lord, from 7th up to 7th, it was in the list. But from the 8th, it is not in the list, my lord. It is a question of bread and butter of the petition.
So what is the reason of the suspicion? You are sure it was not called on for hearing?
No, my lord.
এটা তো দেখে আমাকে বল report দেবে তো একটা. I'll check up if there is really something suspicious. It will appear in the list definitely.
My lord, it was not appearing. It is not appearing.
উনি সাসপিশনটা কিসের বলছেন আমি বুঝতে পারছি না. Yes, what is the suspicion about?
My lord, it was appearing till the 7th. The matter was fixed on the 8th of August.
It was fixed on the 8th, miss. I directed it to appear, it to be fixed on 8th.
On the 8th, my lord directed to appear it on the 8th of August. From the 4th till 7th.
এটা চেক করে আমাকে বলো তো, এখনই বলো, বলে তারপর অন্য মেনশনিং নেব.
You're right, sir.
No.
Let it be a fixed
Let me clear the suspicion first. Yes.
My lord, I have
কি ডেট দেওয়া আছে? Yes. হ্যাঁ, ডেটের ম্যাটার তো এমনিতেই কল হবে ওই দিন, উনি ঠিক বলছেন। ডেট ফিক্স ম্যাটার হলে তো কল হবে।
It was not in the list on the 8th, my lord.
No, my officer's explanation is that it was not called on up to that matter. It was directed to appear on 8th. It was not fixed on 8th. It was directed to appear on 8th because you had asked for that. But I could not reach till then.
No, my lord, it was not in the list on the 8th, my lord.
It is in the combined list. Very well. It will list it. Very well.
Let it appear.
It will appear on day after tomorrow. Yes.
Day after tomorrow.
Yes. Serve the copy. Yes. Urgency. What is that?
Urgency is that, my lord, in the tender, my lord, called for by the horticulture. I did not participate. But my company developed by the company that another 3 years you will not participate.
Ultimately, didn't wait for some time.
My we were blacklisted where I did not participate.
Wait for some time. Wait for some time. Wait for some time. Yes.
9th is the last date, my lord. My
9th last date for what?
9th, my lord.
9th is the last date for what?
9th August, my lord, last date for inclusion in the list. If not stayed in this case, my lord, mine will not be in the list, my lord. Not into agriculture product, my lord, I manufacture, my lord. All over India, my lord.
You have been blacklisted already.
Blacklisted.
9th is the last day for what?
Blacklisted thereafter the agricultural product company name included by the government. My name is not
The
appearing.
list will be published on 9th.
Published already been, but till 9th, my lord, it is time of rectification. my lord.
9th of September.
9th of September.
Wait for some time. No. No.
Directed to, my lord,
Next matter. No.
earlier,
No, please. No.
District magistrate to dispose of my section 14.
Hand over. এগুলো upgrade দিয়ে দাও. Yes.
Withdrawal of the.
My lord, since the monthly item number 69. My lord, the competent authority under the West Bengal Apartment Ownership Act, my lord, passed an order violating its own act and its bylaws. My lord.
Please wait. Yes. Please don't mention today. You are speaking unnecessarily. Please don't mention today. I'm speaking to you. The line behind you won't mention today. I'll not take up the mentionings for you. Yes. Yes, please continue. Yes.
My lord, the competent authority under the West Bengal Apartment.
Are you still feeling difficult in standing? Yes.
My lord, competent authority under the West Bengal Apartment Ownership Act passed an order, my lord, violating all its laws and its bylaws.
Yes.
My lord, my petitioners are the senior citizens. My lord, the BOM has stopped all the services and maintenance.
Hand over. Yes.
May I have your notice kindly to
Mention from there. Yes. Whatever position you have mentioned. Yes. Finish the do away with the mention. I cannot continue forever. I'll take up for 5 minutes and then call the list. Yes.
May I have your lordship's kindly to mention item number 76 of your lordship's list, my lord.
What is the urgency?
Urgency is, my lord, I am a secretary of a private aided institution. The local complaint committee terminated me without hearing me. Here is an internal complaint committee, my lord. Order not communicated. Only the school authority intimated me on first.
Not right now. Wait for some time. Yes.
I will be terminated.
No, not right now. Yes. 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 Next, please. You have already mentioned. Yes, that's it. No, you have already mentioned. Yes. Hand over. What is the urgency? You don't have any urgency. What is the urgency?
And without informing me, that date do not get that there is the respondent authority sent the amount which has been sent back by the bank.
13 steps have been taken. Section 13(2) step has been taken under the SABYASACHI Act. NPA after that is the next corollary. What are you challenging?
Without informing me, I think that
You are challenging the NPA classification.
my account suddenly closed, Lord, without informing me, Lord. I mean that
Account has been frozen or closed.
closed.
Nobody else can close you apart from you. You are not ready in your matter. Yes.
One matter, passport withheld by the authority. Last commission 27 July, I mentioned it. Your person accepted and I could say that no requisition is sent.
এটা আলাদা করে রাখো তো আমি এটা তোমার সঙ্গে কথা বলবো I'll check up and definitely requisition will be sent even if not sent. Yes.
Past order will not be that.
Yes.
Lordship, I need to mention two matters. After filing of the instant repetition, the respondent bank has merged with another bank, and a necessary can has been filed. So a date may be fixed for the hearing of the can and the repetition.
No. Can. What is the can about? What is the prayer in the can?
For making necessary amendment in the book.
No, I'll take it up with the not right now. No, that's why. No, not right now. Yes. Why?
Application, but they have not really answered my proper answer.
No, not right now. Yes. Yes, please.
My lord, upgradation of the matter, the allegation of this acquisition is siphoning of funds. Now, in between what they have happened, they have passed a resolution to encash the corpus fund, and the matter has been fixed on 3rd as the final hearing. Equities are all exchanged.
Hand over, please. Yes. It upgraded. Yes.
My lord, this is a matter for upgradation from the monthly list. I am an adoptee in search of my birth parents in consonance with the CARA and the regulatory bodies have not been cooperative with me.
Hand over, please. Yes.
My lord, may I seek a leave, my lord? What has happened? My lord, the PWD is constructing a toll plaza in front of my property, thereby preventing my ingress and egress to the property. My property does not fall under any acquisition or requisition proceedings, my lord. I have the ownership right, my lord. Suddenly they come up on
It is
Friday.
being constructed on your property.
It has been constructed, my lord. There is the main highway, that is the Taki highway. There is a small gap, and thereafter my shop starts, my lord. They have started digging.
Your
from the
right
gap.
lies before a civil code, not before a writ code.
My lord,
No urgency, no. Your right lies in a civil code. They are constructing on public land. They have a right to. If your right of
preventing
ingress and
the
egress
ingress and egress,
are being disturbed, you have a civil right. No. Yes.
Restoration application.
Hand over. Yes. Please goes no. No further mention. No.
My lord,
No. I've given you once. No.
my lord, this 337 of the combined list matter, my lord, the Chittaranjan locomotive work is suffering badly because the National Commission for Scheduled Caste and Scheduled Tribes harassing for last more than 1 year.
The commission is harassing.
Yes, by sending summons to the top officials of the company, my lord. And your lordship's pleasure was to hear this matter once, and it is in adjourned motion 2. So, lordship, kindly any date, if your lordship it suits your lordship, lord, I will be.
Very later upgraded. Please hand over. Yes.
My lord, under
May be permitted to mention, my lord. The contempt.
Contempt application hand over. Yes.
My lord, may I be permitted?
Yes.
May I again lordship seek to mention a matter upon notice for inclusion in the list. My lord, it relates to a registered society which runs an educational institution in Malda. Its registration was cancelled, my lord. Despite that, it is being in operation and it is accepting funds from the students to run the institution. My lord.
How are you affected?
My lord, I am an active member of the society. Previously, I had come.
No, not right now. There is no such urgency in your matter. Yes, next matter, please.
Give 100 of daily list, your lordship, my lord, it's a tender matter, lord, my lord, any day work order will be issued.
No, not right now. No further tender matter. Yes.
For upgrades and loss in spite of maturity of the amount. Postal authority not.
Hand over. Hand over.
My. Matter of summers will come. Line has been disconnected.
It is in the list. Hand over, please. Yes. Yes, you.
There is probability to make item 100 of mother. Tender matter. Matter so of your protective and interim order, matter cancelling the instant tender without cancelling the instant tender, new tender has been. My right has been affected.
No.
Cause of action.
Have you filed any application? No, not. Yes. Cannot. Yes, Mr. Banerjee. Let me hear the other one. I'll choose between two. Freezing of account, please hand over. Ombudsman, please wait for some time. Yes. You've already mentioned two. No, Mr. Haldar, you're sufficiently briefed. No further mentioning today. Yes. Mr. Haldar, don't engage somebody else to mention on behavior. I'll be keeping watch. Yes.
One of the Armenian army. There is a group that he stop maintaining quality, the authority can.
Hand over. Yes.
Lordship, it is in the list, Lordship. I am-
Upgraded the other. Upgrade. Yes. Can application for what? What is the prayer in the application? How is that related to your cancer? No. Yes.
Application for obtaining a certified copy has been turned down by registry.
On what ground?
On the grounds that apparently they don't have the record.
Hand over. Yes.
Your lordship had earlier allowed the mentioning and the matter was been running since the month of June in the list. However, it is now shifted to the monthly list. Your lordship, I have a jewelry shop. I'm a jewelry shop owner in Park Street. My shop has been shut since November 2022 without any further reason. I just issued it.
Shut by which authority?
By the private respondents.
Not right now, ma'am.
Your lordship, it is a season for
Yes, I appreciate, but wait for some time. No, not right now. Jewelry shop has to wait for some time. I'm sorry. There are more urgent matters for common people. No. Next matter. Yes.
Passport issue, my lord. The
Passport seized.
yes, my lord. Actually,
What ground?
he is seized for the ground that he has been married to an Indian national, and previously he was from outside, but he has got the passport and he was working outside.
Hand over. Yes.
Your lordship, I beg to mention a matter. I've been mentioning the matter on the last few occasions. It's an electricity matter, your lordship. So, your lordship, around 41 tenants are residing along with their families.
Hand over. Yes.
Gratefully.
Lordship, may I be permitted to mention a matter? Lordship, the matter was supposed to appear on 7th of June, but it did not appear on the returnable date. My two vehicles challan has been issued, and I'm not being able to use a commercial. Those are commercial vehicles, and I'm not. That is the only.
For some time, no use adding. I can't take up matters already in the list. No, not right now. Yes.
Grateful, Lordship.
Lordship, I'm a senior citizen who has been thrown by my daughter-in-law from my own property. My lord.
You have a relief under a different law.
No, my lord, I have filed petition under the Maintenance of Senior Citizens Act before the SDU. SDU has rejected on the ground that the matter is civil in nature. The DM moved an appeal before the DM. DM has also rejected, and in the meantime, my lord, I am deciding at the relative's place at the mercy of my relative.
Hand over. Yes.
My lord, petitioners are the senior citizen and they have purchased the land properties long back, but despite the payment of several stamp duty and registration fees, the petitioners have not received the original deed of conveyance till date.
Hand over. Yes. Yes, Mr. Pandey.
My lord, my
petitioner is running the security guard agency, Your Honor, due to non-renewal, refusal for non-renewal of the license I am getting. My workman is also sitting idle. And there will be chances of multiplicity of proceeding.
Right now, I cannot add Mr. Pandey. No use. I can't hear.
My lord, item
Yes,
number
next matter.
315.
May I have your lordship's kind leave for upgradation, your lordship?
Yes.
I have received retrenchment compensation, and after receiving the same, my bank accounts have been frozen on the alleged ground that the employer's account have been declared NPA.
Hand over. please.
I'm deeply
Yes.
obliged.
Yes.
May I be permitted to mention this matter for upgradation? I have a gold loan. My gold loan, I want to pay all the amount and take back my gold. They are forcefully without.
Jewelry shop refused, so gold loan also
No,
refused.
why not? I want to pay the full amount of.
Not right now.
No, they are.
Pay it and get it. If out of court, you can. No, no, Mr. Gupta. No, no. Not right now. Not right now.
Yeah.
Not so urgent. Definitely not so
No,
urgent.
yes,
Yes,
yes, my lord, because they have issued a letter. They are going to liquidate those gold
not right now, Mr.
without any surface.
Not right now, Mr. Gupta. Yes.
The item number 26 withdrawal. I want to withdraw.
Because you're wanting to withdraw, you'll be pushing people behind in front of you.
Old man sitting there.
If an old man can push you, you don't deserve to mention. Yes. Hand over, please. Withdrawal to be mentioned. Thank you. Yes. Collection of? Hand over. Hand over. Yes. If it was admitted, Mr. Arifin, it would not be needed to be mentioned. Not right now. Yes. No, not only inclusion. Yes. No, Mr. Arifin. Yes, please. Consideration handover. Yes. Yes. Handover. Yes. Other? Not right now. Yes. Yes. You had mentioned from that side. Not you. Very well. Yes. Sorry. Yes. Choose one of the matters and mention what is the most urgent. Yes. The person died. You are not getting the claim. Hand over. Hand over. Yes. Upgradation. Upgraded list. Yes. The last person. Yes. Hand over. Yes. It upgraded. Yes. It will come directly under the upgraded. Yes.
Mentioning for including the list, it's a matter of livelihood. You made an application for the post of marriage register, which is pending vacancy.
Marriage, several marriage registers have allowed. No, wait for some time. No. No, not right now. Not right now, Mr. Hassan. Sorry, no. No, Mr. Zaman, not right now. Yes.
Petition was filed when the technical bid of prohibited.
Please be a bit louder. Yes.
My lord, this writ petition was filed when my technical bid was rejected, but my lord, they have moved to final financial bid, and that has also been opened, and L1 has been awarded, and LOI would be.
Wait for some time. Wait for some time. Sorry. Yes.
Lordship, in spite of several representation for outstanding payments, no payment has been made, along with my security and interest money has also been stopped. Lordship.
You are a contractor.
Yes.
Please wait for some time. Yes.
My lord, here I am praying for an original stamped arbitral award. I am a party. The arbitration award has been passed.
You have to go before the arbitration court.
My lord, here I'm just praying for a copy of the original arbitral award.
Do I have jurisdiction? I have my doubts. Anyway, hand over. Yes.
My lord, non-prosecution.
Electricity matter for upgradation. The petitioner seeks not to provide electricity in the 5th floor in G+3 building sanction plan. The CSC will proceed to.
Wait for some time, please. Yes.
Upgradation, your lordship, attended issued by his IOC the element manner to specific view petition and others with similarly
companies are not allowed to participate in the selection process, Your Lordship. To end the tender process, Your Lordship. Last date is on 19th of August.
Hand over. It upgraded. Yes.
This is a non-prosecution.
Non-prosecution.
She may be permitted to mention on matter for inclusion in the list, Your Lordship. The petitioner, by the virtue of the interim order dated 22nd of October 2022, was allowed to travel abroad. But the respondent authorities are not still restricting me to travel abroad, Your Lordship. I need to travel abroad to various countries for business purposes, Your Lordship. So I'm praying for inclusion in the list and for early hearing, Your Lordship.
Once you have traveled, by virtue of
No, I was allowed to travel by the interim order dated 22nd October 2022, but they are still restricting me. They are not complying with the order.
hand over. Yes.
Your Lordship, I beg to mention for correction of
Great,
the order
Lordship.
dated.
Correction of order.
Yes.
Please hand over. Yes. Do you mention correction? Yes. Yes.
We have permitted to mention one matter. In this case, the petitioner paid around 9,76,000 to the respondent as a service tax, which should have paid by the respondent. And 2020 it was paid since 3 years has passed. Even single penny was not paid to the petitioner, and the petitioner is dire need of money for the other business.
Hand over. Yes. Yes.
Your Lordship, this matter is in this item 425. Your Lordship, it has been mentioned earlier 3 times that Your Lordship was allowed, but it's not in the list. Your Lordship, the urgency is that the matter is related to the embezzlement of home loan by the respondent bank. Your Lordship, they have taken the possession to the other person while they are deducting EMI from my accounts. Your Lordship, both the persons have been sanctioned home loan on the one single property, same property, and I have not.
It's appearing in the list.
No, the monthly list for 25. Your Lordship has
Upgraded. It will appear in the upgrade. Yes.
Petitioner purchase a property in 2000, purchase of 2000, and you want to sell the property.
2009.
Responsibility without any power of jurisdiction, no right to restrict the selling of his own property. It's like
Not right now, sir. Wait for some time. Please wait for some time. Yes. Yes. You. Yes. No, he was there before. Right side. Yes.
matter when on somebody's application, the state electricity board installed a massive transformer in my property.
Hand over. Hand over. Yes. You. You. Yes, please. Yes.
I do that. For the security, as per the RBI rule, the entire money has to be 100% marked. I did that entire each stuff. Now the bank has issued a servicing notice on 11th of August saying you have not deposited, we proceeded. 11th of August, you are granted.
Hand up. Yes.
Lordship, I have been removed as supplier of this field by some arbitrary categorization where this matter is not a
You have been. Please repeat once.
I have been removed as a supplier of this field by some arbitrary categorization of this bond rate and this matter is
Hand over, please. Yes.
Regarding item number 123 of the monthly list, my lord.
Yes.
Petitioner is not really allowed to deposit the revenue only 7,000 to SBI. And thereby, my lord, they are withholding my title deed, my lord, for several.
Upgraded either. This will appear as an upgraded matter, please just.
For 3 minutes, I have missed my mentioning slip. I am preparing and within
Very
3 minutes, within 3 minutes.
Very well. Please stay there when the slip is handed over so that he can identify.
Yes, I will.
Thank you. Yes.
Electricity matter, your lordship, although the case has been filed against the state of West Bengal, but due to bona fide transformation message, there is state of West Bengal has to be included in the cost category. Your lordship, free granted leave to add the sum.
To be mentioned either for correction of cost title. To be mentioned for correction of cost title. Yes.
For inclusion in your lordship's list, your lordship, this is basically an illegal enforcement in the work of property, while the concerned authorities are endorsing their enforcement by providing mutation as well as trade licenses and electricity also. Your lordship, on
Hand over, please. Yes.
My lord, the petitioner's house was burned down in 1993. Thereafter, police didn't take the lodge the FIR. Thereafter, CRR was allowed by
What are you wanting now?
compensation, and it's been 1 year.
Hand over, please. Yes.
My lord, I am the special officer appointed in this matter by an order passed by Honorable Justice Bhattacharya when her ladyship had this determination. My lord, I require urgent clarifications, my lord, regarding the implementation of the order, my lord.
You have to go before Justice Bhattacharya
My
there.
lord, the parties went before Justice Bhattacharya. Justice Bhattacharya's opinion was any dispute arising out of any subsequent event to the order has to come before my lord. Now, my lord, the difficulty I'm facing is that there are differences of opinions between the petitioner and the private respondent
You
regarding.
filed any application?
My lord, it perhaps won't require the filing of an application, my lord. 5 minutes, my lord. My lord keeps the matters to be mentioned. I'll explain the matter.
You are personally the officer.
I am the officer.
Hand over. To be mentioned at the other. You just remind me why it is appearing as to be mentioned.
Very well, my lord.
Yes.
Lord, my lord, with notice I am mentioning it for lordship for upgradation. This is my relating to the, my lord, the refund of the excess stamp duty, which has been wrongly paid. My lord, the in term earlier order has been passed by this court, my lord, by the Honorable Justice Bhattacharya. My lord, thereafter the order has been passed rejecting this application only on the ground of limitation.
Please wait for some time.
My lord, the,
No, this has to be hard on merits now for some time. Yes.
no, this is, my lord, the order.
Not right now. Sorry. Yes.
Your lordship, the insurance claim of the petitioner has not been dealt with in accordance with the law. And my lord, there has been several instances of fraud that has been.
What insurance? Life insurance?
My lord, this is a general insurance, motor vehicle insurance. My lord, the claim was raised in 2021. This is 2000.
Please wait for some time.
My lord,
Wait for some time. Yes.
Lordship, may I be beg to mention a matter for upgradation, Lordship. Since 2013, I had taken a loan. I have been paying every installment of the loan. I have come up for a balance transfer of my loan account, but now I get to find out from the bank that my original deed, the bank has not even taken up the original deed from the registration office, and neither.
You can wait for some time. Not right now. Sorry. Yes.
My lord, I'm praying for upgradation. My property has been illegally declared as Thika property, and I have filed an application in the month of February.
You have a right before the tribunal.
No.
Yes, Land Reforms and Tenancy Tribunal. Your relief does not lie here.
But I'm praying for expeditious hearing. They are not taking any steps on neither.
Very well. It will
hearing
appear as
the
upgraded matter. Expeditious hearing to upgrade matter.
Grateful.
Yes. Yes. Next man, please. Yes.
Lordship, this matter regarding release of advocate professional fees is a senior public
Hand over.
prosecutor.
Yes.
My registered deed has not been returned on the ground of
You want to put in the the duty?
Yes.
Hand over. Yes.
This is a matter of they declared me as a willful defaulter without hearing, and I have filed two.
You are against the first committee or the review committee?
I have filed two writ petitions whereby I have filed in the stage 1 and the stage 2. And in the last occasion, your lordship has directed to appear both the matters in the list, but appearing as item number 220.
Upgradation I cannot grant. Sorry. No upgradation now. Yes. Next. Hand over. Yes.
The matter was heard by Commissioner and but direct me as the state was not appearing. Even notice of the matter is finally passed. It happened to the adjourn. So it is now appearing gradually.
Nothing doing.
And 2:30 in articles that matter. If few of that is also please to hear of the matter. Even order has been passed, but in presence of the state respondent, it will be signed. That's why you also try to be.
Nothing doing. I'm sorry. No.
2:30 that day. Kindly consider.
No. No upgradation, please. Yes. Why?
The matter when a petitioner has purchased the property under the certificate. After purchasing the property, my bank has neither the hand over the physical person, not even return back my money. But it is very difficult.
Please wait for some time.
In the meantime,
No.
Allahabad Bank has already been marked with the.
Understand, but wait for some time. Yes.
Can to be allowed. Only can to be allowed. So Allahabad Bank be added with the Indian Bank.
I can't understand anything. Yes.
Construction with private blocking my engagement of the government land, honors construction of government land.
Hand over. Yes. Yes.
My lordship order dated 27 July. So this is CHC matter. Developer as a party. The next date of this matter appearing is 21st August.
This is an application for addition. Whenever the matter is called on pay for leave, then yes. Yes.
May I permit to mention, my lord, this is long pending cases, my lord, from the year 2019, my lord.
Any other urgency? Yes.
70, my lord. I am.
No, I've started from 2006. So your matter has to wait for at least say 11 years.
My lord,
Here is not an urgency anymore. Yes, Mr. Dey. Yes.
I have one matters relating to my renewal of license in respect of form.
What happens, my lord, I have renewed it earlier, but what happens, we are not finished the renewal. Now we are the renewal with the, my lord, the fees of, my lord, from 2011 to 2022, they are taking all the fees. And my lord, that is the urgency.
Mr. De, please wait for some time.
But I am waiting, my lord, I have mentioned.
No, not right now, Mr. De. No, yes. I'm sorry, no.
Some urgencies there.
No, Mr. De, no, not so urgent.
My lord, bills are going.
Mr. De, I understand, but not right now. Yes. Yes.
Petitioner Bank Authority apply to the concerned DM for police help under section 14 SABYASACHI Act, but DM not dispose the application.
Hand over. Yes.
My application, madam, 1st of September, it will be last date for inclusion in the list. My company. Company not.
So I refused your.
9th of August.
I refused your mentioning.
9th of September.
Yes, next matter, please. I'm asking a question, you're not answering, so I have to shift to the next place. Yes, please. Yes.
Petitioner is in the business of export and import of tea. Your lordship, he needs to travel by the end of August. He was a personal guarantor in respect of a company was defaulted in payment of loan.
Passport withheld.
Yes, your lordship.
LOC.
Passport, yes.
What are you
Passport
challenging?
Your lordship, LOC as well as
Hand over.
your
Yes.
lordship, kindly list is any day this week.
It is appearing in the list.
Yes, no, item monthly is item number 460.
Upgraded the other. Yes.
Lordship.
Upgrade, please.
Lordship, may I be permitted to mention your lordship for upgradation from
There are at
2000?
least 1,000 matters probably
Lordship,
upgraded.
from 2002, your lordship, I'm fighting for upgradation of my pay scale and pay parity. 2 round of litigation has already been done
I'm sorry,
in
you
the
have to wait for
central.
some more time. No.
Lordship. Lordship, praying for inclusion in list in the matter, the petitioner, the custody, the house of the petitioner was taken over illegally by the respondent bank without giving the original title deed. And on that ground, we cannot enforce in the surface proceeding thereby.
No, surface, you wait for some time. Yes.
Lordship, I'm praying for inclusion. The petitioner is a paints and primers supplier. I had a work order from Kapurthala, Punjab, and I complied with such work order. However, the same was rejected on the basis that I did not comply with the proper order, and therefore.
How does this court have jurisdiction? Kapurthala were rejected.
Lordship, thereafter multiple amounts were deducted by Eastern Railways and Southwestern Railways.
Wait for some time, sir. I'm sorry.
May I be permitted to mention for the inclusion in the list matter where the LIC is not disbursing the amount which was lying in the name of the petitioner father, despite of the fact, we have submitted all the legal certificates. So, this is
hand over. Yes.
Grateful.
Lordship, may I be permitted to mention for upgradation, Lordship, electricity new connection, and the petitioner is undergone bypass surgery.
Hand over.
Okay.
Upgraded the idiot. Yes. Yes,
Not
please.
in the list, but to be listed before your lordship, since the matter Amazon has been, my lord, released from the list of the honorable judge, which is wrong about that, so that I am mentioning.
Please hand over. Yes. It is the other list. Yes. Yes, Mr. Prasad.
May I permitted to?
No, Mr. Prasad is there. Yes.
My lord, I am seeking inclusion of an application for substitution. My lord.
Application, please hand over. Yes. Substitution.
I'm getting.
What have I done? I have refused your mentioning today.
9th September, that's why your directed came to know 1st September it is last.
What last date of what? I can't recollect.
I am the agriculture company.
Yes.
I manufacture agriculture equipment.
Yes.
One tender was published by the horticulture department where I did not participate. But I did not comply and not cooperate on that. River order passed against me.
Hand over. Yes.
That's why I am not in a position to participate.
Yes.
In the upgrade.
My lord, may I have the
It upgraded. Yes.
may I have the permission to mention a matter, please?
Yes. Yes.
My lord, this case has been filed on March 13th on 2020.
Against what? What is your grievance?
Grievances actually the petition.
What have you challenged?
Property farm and supplied some textiles since last.
You were asking for a money claim.
Yeah, my lord.
Please wait for some time. Yes.
I give to mention item number 50 of my lord's daily list. The urgency is that the petitioner is a resolution professional registered under the Insolvency and Bankruptcy Board of India. Now, a disciplinary proceeding was initiated, and my lord, his license has been cancelled. There is no suspension. Grossly disproportionate punishment. The urgency.
Declare it upgraded. It will appear as upgrade.
It does not reach to the my lord, may it be on.
As you reach upgraded. Yes. Even if it is reached today, it will be taken up when it comes in the upgrade list.
The urgency that 12th, that's on Saturday, his term has expired, and he is in
Very well.
several
Upgrade. Yes. Yes.
Lordship, may I permitted to be mention the matter relating to senior citizen freedom finder
pension scheme. I filed an application, contempt application on 2020.
Contempt of this court's order?
Yes.
Contempt of whose order? You search out in the meantime, I'll hear him. Yes.
Sir, may I lordships kindly to mention one matter. It's regard to my lord 104 of your lordship's daily list is a tender matter. Now, what has happened, my lord? The petitioner participated in the tender. Having all qualification, his bid was rejected for the reasons based on to the respondents. My lord. Soon after filing the writ petition, my lord, tender has been cancelled. But we apprehend, my lord, the fresh tender will be initiated, my lord. Unless and until we know the reasons of our rejection, my lord, we shall make the same mistakes against which the respondent will reject my bid. If your lordship would kindly hear out the matter with a direction, my lord, upon the respondent to assign the reasons for our rejection, my lord, it will be a great help to the petitioner, my
It
lord.
appears to be mentioned then.
My lord.
To be
Please
mentioned,
apprised.
remind me why. Yes. Mr. Gupta, I've heard you. Right.
Item 766 of Maharaj.
No, one is enough. Yes.
He raised extreme.
No further mentioning, I'll hear the clap.
Your lordship will not take care of
No.
this because the entire project is stopped. But may I prefer release?
No, I had a talk with the Chief Justice, no release because other benches similarly placed. Other benches, even some benches are worse placed.
It's after
Chief Justice directed me not to release these matters. Yes. Because other benches are equally placed. Or if not worse placed. Yes. Yes, please. Yes. Yes. Many projects over all the courts in West Bengal, throughout West Bengal are stalled. Yes.
Lordship, I am no knowledge. Whose order?
Whose order? Come prepared on next Monday and mention. Yes.
Sir, we have filed for order specific instruction can application on 10th of August. It is not appearing in the list.
Hand over the can. It a list you can. Yes. Bol. Yes.
Thank you.
He's with you.
See, no.
Yes. আপনি বলবেন কিছু?
হ্যাঁ
বলুন।
হুজুর আমার নিবেদনে আমার একটা অভিযোগ আবেদন আপনার এই মাননীয় কোর্টে জমা আছে।
আচ্ছা, আপনার কি কোনো লয়ার আছেন?
লয়ার ছিল স্যার, হ্যাঁ উনি দিয়েছে, মেনশন করেছিল, সেটা এলাও হয় নাই কারণ আমি
না, আপনি কি লয়ারের কাছ থেকে নো অবজেকশন নিয়েছেন?
হ্যাঁ
লয়ারের কাছ থেকে আপনাকে লয়ার ব্রিফ ফেরত দিয়ে দিয়েছেন আপনাকে?
ফেরত দেয়নি।
না, উকিল বাবু থাকলে আমি ডাইরেক্ট পার্টিকে শুনতে পারি না। যদি উকিল বাবু থাকেন উকিল বাবুকে দিয়ে মেনশন করাবেন। তাকে যদি রিজেক্ট করে থাকি তাহলে আপনাকে আমি রিজেক্ট করব।
উনি করেছিল স্যার, আমি
না, এরম নয় যে উকিল বাবুকে রিজেক্ট করেছে কিন্তু আপনাকে অ্যালাউ করবো আপনি নিজে এলে। ওইটা ভুল ধারণা আপনার। আপনার উকিল বাবু ছাড়া আপনি শুনতে পারি না আপনাকে। যদি আপনি নিজে অ্যাপিয়ার করেন মামলাটায় গোড়া থেকে তাহলে আপনাকে শুনবো আমি। কিন্তু উকিল বাবু থ্রু দিয়ে অ্যাপিয়ার করলে শুনবো না, এবং উকিল বাবুকে যদি রিজেক্ট করে থাকি আপনাকেও রিজেক্ট করছি আমি। সরি, কল on the list. Yes.
My lord, I am petitioner in person, my lord. My lord, person. Military Engineer Services, they have illegally blacklisted me and
কে অন করছে কে? তুমি অন অফ করতে পারছো না? তুমি অফ করে দাও। Yes, please continue.
my lord, from beginning, my lord.
No, you have been blacklisted. You want inclusion in the list?
For upgradation, it is already running in as item number 390 in the monthly cause list, my lord.
Upgradation, we have seen today, this morning. From the morning, I have been upgrading so many matters.
My
Your
lord,
matter
please.
cannot be heard. Blacklisting, I'll have to hear the matter on merits. That is why I'm not upgrading these. I'm upgrading only the short matters and those which cannot wait for even a day.
My lord, I'm on starvation, my lord. I'm a senior citizen, and please.
You don't look like a senior citizen first, and
Please,
you don't
please.
appear to be starved. So first one is a compliment, second one is also a compliment basically. So no upgradation right now. Sorry.
My lord, I'm suffering.
I appreciate
all
your
my
suffering.
work it has-
Yes.
All my work it
Call
has-
on the list.
My lord, last mentioning, my lord.
My lord, he mentioning item number 1 to 6. My lord, that is why that is pending during 14 years. After that, one case was started, C14679. Those 6 items are of RTI applications. Those are very much required for these cases, and that is why prayed for to be mentioned or any inclusion in that list, my lord.
Yes, give the numbers. Those will be included in the list.
Yes, my lord, 1 to 6, my lord. Mentioning.
Mentioning 1 to 6 এর লিস্টে দিয়ে দিন, কল করে।
Grateful, my lord.
top item, item 12.
Item number 1, my lord.
No, one, those contempt and applications due to my court officer's fault, those are appearing at the top. Those are to be taken on Friday.
My lord, Friday I have some problem, my lord.
Difficult, your problem, that is your problem, yes.
My junior will mention on.
Yes, please. Item, whichever has been called on. Item 20.
Item 12.
Who is appearing, yes. Move your matter.
Well, my application, my lord, that is, it's appearing under the heading my applications only, my lord.
12 you are appearing, item 12. Yes, what is the matter?
My lord, writ petition filed challenging an order passed by the district magistrate under section 14 of the SABYASACHI Act. Well, this was the writ petition was entertained in view of the fact, my lord, the DRT 3, the Debt Recovery Tribunals 3, was not sitting. The order passed, my lord, was that there would be an interim, that is the bank, the respondent non-banking financial institution, my lord, will not be entitled to proceed without a formal leave being granted by this court. And the leave to mention the matter before this honorable court was also granted through the parties. Now, my lord, post passing of that particular order on 27th of June 2022, my lord, there was this application challenging section 14 order passed by the district magistrate was moved before the Honorable Debts Recovery Tribunal, and an order was passed dismissing the said application. My lord, will kindly take up, my lord, page 13 of my application. I'm so sorry, my lord. Page 11 of my application.
No, let me see the first, let me see first the 27th June order.
Yes, my lord, that is at page 11 of my application.
The application.
Should I place it, my lord?
No, I'm just.
May I give your lordship the back?
No, wait. So, yes. Yes, the only ground it was entertained, Mr. Shen, was
Yes. But now kindly see, my lord, this order, this application, my application before the DRT.
Yes.
There was a cease work.
Right.
Order was reserved on a particular date. If your lordship kindly just takes once, my lord, my writ petition, I'll just show your lordship that order.
Yes. Mr. Shen, I'm taking up the application and the writ petition together.
Exactly.
Together, yes.
Your lordship will kindly come to page 121. This is, my lord, my IA was considered here.
Yes.
Adjourned to 27/5/2022 for further hearing.
Right.
Thereafter, my lord, kindly come to 122.
Yes.
Hearing was concluded on 27/5/2022.
Yes.
Now, my lord,
we
have filed
copy দিয়েছি.
My lord,
We have
kindly
prepared
see,
one supplementary.
we have filed a supplementary affidavit to show, to record that this IA has been disposed of on 27th of June. And my lord, I want to show your lordship one thing, my lord. Kindly come to that order. I have a constraint to file a recalling application. Why? Kindly see, my lord.
Page 105 is the improved order.
105 once.
105 of the supplementary?
Yes.
Yes, my lord. What are 105 and 80?
Page 105 order. The order.
Kindly see 105
Yes.
passed on 12th of July. What is interesting, my lord, is the court, High Court order. Kindly come to paragraph number 3.
Yes.
Learned counsel for the applicants has submitted that they filed 2 writ petitions before the High Court at Calcutta challenging the same DM order which were heard, and 2 separate orders were passed by the Honorable High Court. On 27th of June, WPA number such and such, Honorable Justice such and such has observed. Lord, kindly note, hearing was concluded on 27th of May. There was no possibility, judgment was reserved.
there was no possibility for any of us to make these submission to bring on record before the learned DRT anything subsequent to that. 27th June is the order passed by the writ court. Well, suo motu cognizance could not have been taken by the learned DRT 3 of the order dated 27th of June. Matter is reserved in 27th of May.
And the advocate also given change prior to that.
There is no question of appearance and making.
Did that affect the matter on merits? Show me that.
We were not hurt.
Why can't he take cognizance of an order passed by the High Court?
Well, it
You have moved this forum also, you have chosen this forum.
Yes,
Yes.
but it has to be placed before the DRT.
No, how was it prejudicial to you? I mean, consideration of this.
Kindly see, my lord, this
The order was
aspect.
behind our back.
Now, my lord, what is the merit of the matter? Merit of the matter is, my lord, wait. Well, section 14 order, which has been passed by the DM,
Yes.
is on the basis of an affidavit of the secured creditor. The affidavit of the secured creditor, based on which the order has been passed, contains expressly false submission regarding factual aspect. Why? Because, my lord, the notice of the secured creditor says that it is a fully tenanted property. Not once, 13-2 notice, 13-4 notice, everything.
The deed also mentioned.
And the deed also mentioned. That is why they have mentioned in their notice. But when they file an affidavit before the DM, the representation is that there is no tenancy. And based on that, blindly and mechanically, the DM has passed an order on the basis of that affidavit. That was my specific issue in this IA. Well, your lordship will
You had
find-
preferred the writ petition on self-same ground as the IA because of its pendency for a long time.
Yes, my lord, because my lord, at
For
that-
which it was relegated by Justice Bhattacharya to that forum. Now that forum has passed an order.
now, my lord, my submission before your
Yes,
lordship is that
yes.
since I have already filed an application for recalling of this, because this issue has not been considered at all. Now that issue, this application.
This writ petition has become infructuous.
No, I am only saying this, my lord.
Yes.
This application has been fixed for hearing by the learned DRT on 22nd of September. Well, kindly permit me to kindly direct that this IA be heard afresh. This IA has already been filed, this application for recalling. This kindly direct this to be heard.
For
And
recall of the order dated
27th of June.
12th of July.
Yes, sorry, 12th of July. 12th of July.
No, Mr. Shen. You are just trying to stall the proceedings.
Well, then, my lord,
Sufficiently reasoned order.
your lordship will then kindly go into the merits of the matter.
How can I? Because this all self-same cause of action, this court permitted you to move the DRT. You have moved. You got an order against you.
Kindly see, my
How
lord.
can this court again re-enter into this
No,
issue?
that is what I am saying, my lord.
No.
This is a fraud on the face of it.
No.
And that has not been considered by DRT3.
No.
Only one fact I would like to show your lordship.
The
Nothing
client
more.
is just trying to delay, Mr. Shen.
No, at all not. But your lordship
When
will
they have
prepone
filed
the
the
date.
application, when they have
Your
filed the
lordship,
application.
your lordship will prepone the date. Any day. Your lordship will.
Just because a recall application has been filed, because this is a reasoned order. You have not preferred any check.
Come to the reason one.
Let us come to
Let
this.
us
Yes.
kindly come to the reason one.
Page
My
106
first
onward.
point is
Yes.
paragraph 3 of the impugned order.
Yes.
There was no representation of my client. Learned counsel for the applicant has submitted that they filed 2 writ petitions before the High Court. Matter was made CAV. There was no question of any representation before the DRT3 on 12th of July.
No hearing was conducted.
And my lord, this for applicant, your
So
lord,
you say these orders could not be considered.
I am not saying that. This recording, I did not make any representation or submission regarding this order, could not have, because matter was CAV on 27th of May.
Behind our back.
That is number one. Number two is, my lord, kindly see at the top, for the applicant.
You did not even intimate Justice Bhattacharya's order to the tribunal. How was paragraph 3 recorded? Learned counsel for the applicants, that is you. You had submitted that you had filed 2 writ.
Maybe the bank has, I don't know.
That day,
Then you should have approached before that court, that tribunal, the same court
That
to
is
say
what
that
I have applied, my lord.
wrong recording of fact.
that is
And
what-
how does it prejudice the main matter?
Coming to that. my lord,
Yes.
your
So this is the first ground,
That is
yes.
my first ground, my lord.
Yes.
And also, my lord, another technical issue for the applicant, Mr. Ganguly Learned Counsel. He has already given change long back. Would not have represented.
Where is
my-
that recording?
At the top, my lord, just above the order,
Acha,
present for applicant.
Acha.
Then, my lord, kindly come to paragraph 4, submitted that the order passed by DM is bad in law, stay of approval may be passed on the learned appearing for the respondent oppose the third learned counsel have challenged the demand notice and the possession notice. Incorrect. I have challenged, my lord, only the order of DM. Adjudication of aforesaid issues cannot be made in interlocutory application. They are subject matter of challenge in main essay. Normally, adjudication restricted to relief sought for in the petition. Learned DM South 24 Pargana has passed the order on 16th of March, which was communicated on 18th of March. Copy of the order has been annexed to the IA. Impugned DM order shall have to be examined under purview of 14(1)(b) and the ratio of judgment delivered by Supreme Court in Noble Kumar. 14(1)(b) provides that any application made by secured creditors shall be accompanied by affidavit duly affirmed by the authorized officer declaring 9 clauses and provided further that on receipt of such affidavit, DM shall, after satisfying the contents of the affidavit, pass suitable order. Therefore, an affidavit declaring 9 clauses and its consideration with satisfaction of the magistrate is mandatory. Moreover, Noble Kumar case further emphasized that satisfaction of the magistrate on 9 clauses contained in affidavit is mandatory and that should be reflected in the order. I have carefully perused the order passed by the DM and find that learned DM has passed a reasoned and speaking order which reflects his consideration and satisfaction on the affidavit declaring 9 clauses laid down in 14(1)(b). DM has considered each and every step of surfacing proceeding, including aggregate loan, NPA, as also status. Correct description of the property has been recorded. Learned counsel for the applicant argued the demand notice was served. I am not on that one. Your lordship will kindly take once, apropos this paragraph, the DM order once, my lord, which is part of my writ petition. Page 94.
Then you have to challenge this order on merits.
I am only saying that this is a case of fraud, absolute fraud perpetrated by the secured creditor, and this satisfaction is not recorded by the DM. That is what I wanted, my lord, in my IA to be determined, whether the DM has satisfied himself on the affidavit.
Did you point out the fraud, alleged fraud before the DM?
Before my lord, the DRT I have done.
Yes, very well. Where have you pointed out that fraud?
Yes, my lord, in my application in the IA.
Yes.
My lord, I'll show your lordship the application on IA. Kindly come to, my lord, page 87. Kindly come to page 89.
Yes.
Internal page 3, paragraph 6.
Writ petition?
No, of the writ petition. This IA is annexed to the writ petition.
Yes. Yes, please. Yes.
Kindly come to page 89. From the copy of the above DM order, it is evident that the authorized officer has suppressed vital facts and knowingly provided wrong information and also submitted false statement under oath and affidavit as detailed below against the relevant paragraphs of the DM order. Authorized, this is the quotation from the DM order, para A. Then, my lord, my comments. It has been carefully mischievously suppressed that above demand notice was posted very late, was received by applicant on 23rd June. That is around 50 days from the date mentioned in the demand notice. Though it has been mentioned in the representation dated 4th July sent by the applicant to defendant number 1. Due to this suppression of vital fact, Honorable DM was misled to understand the respondent was sent. Representation was sent 2 months after the date of the demand notice, which is beyond the prescribed 60 days limit, making it legally ineffective, and for which the date of its reply within the mandatory 15 days on receipt of demand notice, stipulated in 13(3)(a) is not required to be. 90C. Kindly come to subpara C at page 90. My point is here, my lord. C is the quotation. The property is not under lessee and tenancy as per affidavit. Deeds or all other relevant submitted by the authorized officer in his affidavit. Defendant number 1 has submitted a false affidavit affirming that property is not under lease and tenancy, though the title deed of the property in question kept in safe deposit with the defendants. The possession notice dated 25th September, demand notice issued by the clearly mentioned that the property is fully tenanted. Then, my lord, I've annexed the demand notice, possession notice with this and the title deed along with this IA.
Their demand notice.
Yes, their demand notice, their possession notice,
Achha.
which will show that they describe the property as fully tenanted. But I'll show your lordship. I'll show your lordship, my lord, the demand notice and the possession notice. Kindly see page 80 first. It had a better copy down. This is the possession notice at page 80.
Yes.
Well,
It's all right. Where is it stated tenanted there? Yes, yes, fully tenanted.
And another, my lord, the
Yes,
13th
yes.
notice also.
Yes, yes,
Page 63.
yes.
Page 63, it starts
Hmm.
at page 70. Where the schedule, the description of the secured asset.
Yes, yes, right, right.
Which is fully tenanted. So these two
You are the
records.
tenant.
Yes.
You are the tenant.
No, I am the owner. There is a separate writ petition by the tenants. So, my lord, these were on record before the DRT3 in that IA. There is not a line of consideration of my affidavit.
Page 125. That on that day, HON'BLE is writing mail. On that day, there were seized water. There could not have been matter, could not have been taken.
What locus standi do you have to point out the tenants? I mean,
The property belongs to me.
it's a tenanted property.
Yes,
Otherwise,
yes, my lord.
this is not a good ground for you to get an order of stay of the
Well, this is
Section 14 order.
This is
Yes.
contrary to the provisions of the statute. And the provision of law is now that, my lord, if the tenancy is pre-existing,
Yes, yes.
then that is to be protected.
That is the tenant's locus standi. Tenant is a party here. Tenant is a party.
Tenant has a separate writ petition. My lord. Tenant has a separate writ petition.
It is also appearing before me.
Huh? But that was appearing at that point of time.
Oh,
Say a similar order.
that was rejected. Or
No, my lord. They have filed a vacating in this writ petition. That is why, my lord, this.
oh, that's right.
So, my submission is just
All right, very good, yes.
twofold, my lord.
So you have taken out a recall application
Of the 27th of July.
of the
12th
12th July order, 12th July order before the tribunal to point out that these points were not considered either by the tribunal or the
Yes.
magistrate.
Well, and this is not merely a case of, my lord, recalling on merits. I am saying, my lord, the tribunal has to consider on the facts which I have stated.
Very good, yes.
No, my
And
lord.
I am only saying this, but I do not want to, my lord, take time. I am only saying this, your lordship can prepone the date.
Hmm.
Let this issue be decided once and for all.
And page 84 is not page 84 of the writ petition. This is not your recall application. This is your main application challenging the section 14.
That's a put up application, my lord.
84 is the put up and
Very good.
86. 80 is not 86.
I'm sorry. Yes.
87
87,
is
right.
the IA.
Very good. Let me hear them. Yes.
Now, my lord, insofar as, my lord, the order,
Yes.
my lord, forming a part of the writ petition, my lord, your lordship, if kindly takes up page 122 of the writ petition once.
Yes.
122.
That's the last order, my lord. Yes, that's the last order, my lord, which has been annexed to the writ petition. Last order passed by the DRT prior to the order passed by this honorable court, my lord. It appears, my lord, it was passed on 25th of May 2022, and the matter was to be listed on 27th of June 2020.
Hmm.
Now, my lord, on 27th of June, the matter was moved before this honorable court, wherein the order was passed by this honorable court, directing an interim stay, and the leave has to be obtained from this honorable court in order to pursue. Now, my lord, on 12th of July, the order was passed by the Debts Recovery Tribunal. Well, they apparently have just been handed over with a copy of the supplementary affidavit. It appears, my lord, they had affirmed this particular application way back as on 5th of August 2022. The matter had been pending before the learned Debts Recovery Tribunal. I'll just indicate that, my lord, wherein it will appear that it appears.
Which application? Page 87 application?
No, the recalling application, my lord.
The recalling application.
Recalling application.
Yes. 12th of July order, 12th, I'm sorry, my lord, 12th of July order 2022, the recalling application preferred before the Debts Recovery Tribunal on 5th of August 2022.
Yes.
Now, my lord, they have waited for more than 1 year. My application has been taken out, my lord, very recently. My lord,
12th July was the order passed.
by the Debts Recovery Tribunal
Was the recall application filed?
on 5th of August 2022.
Yes.
My lord, thereafter, they have been waiting in the wings. Nothing has happened. We come up before this honorable court with the vacating application. My lord, that is when the supplementary affidavit was affirmed. The matter was taken up by your lordship on 11th of August. That is when this affidavit is affirmed and served upon me.
But
Today morning.
Can the tribunal proceed without considering this?
My lord, good, bad, whatever, my lord. I am on
Good
law, my
and
lord.
bad are different things.
My lord,
We cannot be indifferent. Unlike what we say.
my lord, over here,
Will.
even if I consider, my lord, one aspect of
It
it.
should have been considered at least.
I
It's a
understand.
fully
Let
tenanted
them go.
premises.
Let them go, my lord. Nothing's happening. They're not taking steps in this particular writ petition, nor are they taking steps over there. Now, my lord, I'm in this case, my lord. It's a
So I propose to dispose of the writ petition by extending this interim order passed here for a limited period. Within that, the recall application has to be heard.
Kindly.
I'll indicate only one thing, my lord. Whether this writ petition at all is maintainable, I am a non-banking financial institution, a private entity. My lord, my contention is based solely on, my lord, I'm covered by an authority of the Honorable Apex Court, my lord. It is the right to my reach. Where the Honorable Apex Court, my lord, has specified that no writ petition is maintainable against the order. My lord, even in case of a Section 14 application, the appropriate forum has to be the Debts Recovery Tribunal. Now, this was a chance which my learned friends, clients had taken before this honorable court insofar as the maintainability, because at that given juncture, the DRT was not functioning. Now, my lord, it is not the case as on today that the DRT is not functioning. So if they have to, they can jolly well, my lord, go up before the learned Debts Recovery Tribunal and take out a put-up application citing the urgency. If at all there is any urgency.
If they are agreed by the Debts Recovery Tribunal order, they can also go up before the
DRT. And my lord, pausing here for a moment, my lord, nothing has happened over the past 1 year. The only fact that this writ petition is dismissed in the event it is, my lord, my point of demur succeeds before this honorable court, that does not debar them from proceeding in the proceeding filed before the Debts Recovery Tribunal. As on today, my lord, I'm before your lordship, my lord, challenging the maintainability of the writ petition. They have, my lord, over the past 1 year sat idle over it without taking any steps before the learned Debts Recovery Tribunal to proceed with the matter. Now suddenly they come up challenging once again, my lord, so that this writ petition, the interim order passed therein, continues till they get an favorable order, if at all, from the learned Debts Recovery Tribunal.
Let me pass my order now.
Very good. Grateful. My lord, I'll just indicate, my lord, I'm covered by paragraphs 15 to 21 of this judgment, my lord.
15 to 21.
15 to 21.
On consent of parties, comma, please take your seats, both sides. Yes.
Sir, I had come to the court because DRT was non-functioning. Order of DM was already executable against me. I had no other option at that stage.
Yes.
And only one thing, my lord, my learned friend is saying I have filed the application in August. My lord, the listing date as per the website of DRT3 gives me the listing date on 22nd of September. But I do not have any hand here.
August 22, my lord.
So that is not my fault.
Might not be, but steps could have been taken.
That is not your fault. Your fault is waiting for 1 year. That is what is happening.
No, waiting for 1 year. Well, my learned friend has also approached your lordship after how many days?
You waited for them to approach. That is
My
your
lord,
fault.
my application has been
The
filed out in
application
May.
is the records of the court.
Learned counsel for the petitioner. On consent of parties, comma, the writ petition itself is taken up for hearing along with the application for vacating the interim order past hearing, comma, since the adjudication on the vacating application would virtually involve taking up the writ petition itself on merits. Full stop, next para. The writ petition was preferred at a juncture when the regular presiding officer was absent in the concerned Debts Recovery Tribunal, that is the Debts Recovery Tribunal, comma, third bench, comma, and was entertained on such score. Full stop, next para. Vide order dated June 27, 2022, comma, the learned single judge taking up the matter had observed that since the matter was fixed before the DRT-Roman 3 on the same day, that is on June 27, 2022, and the writ petition had not been considered on merits, comma, the respondents shall take leave of the court before initiating any action against the petitioners. Full stop, the writ petition was directed to be listed after 3 weeks. Full stop, in the event, comma, the interim application or any other proceeding is decided by the DRT-Roman 3, comma, parties were given liberty to mention the matter before this court. Full stop, next para. Learned counsel for the parties point out that on the said date, that is on June 27, 2022, comma, the matter was taken up for hearing. Full stop, next para. It is contended that ultimately on July 12, comma, 2022, comma, the IA of the writ petitioner, comma, filed against the order passed by the concerned district magistrate under section 14 of the SABYASACHI Act 2002, comma, was taken up for hearing, was decided. Full stop. The said order dated July, where is that annexure? July 12th order?
Page 13 of my learned friend's application.
Yes. The said order
105 supplementary.
It is also at 105 of the supplementary.
Yes, yes. The said order dated July 12, 2022 has been annexed by the parties respectively to their vacating application and supplementary affidavit filed by the petitioner. Full stop, next para. It transpires from the said order that the tribunal took into consideration the order dated June 27 passed by the coordinate bench in the connected writ petition. Full stop, next para. Thereafter, comma, the tribunal proceeded to decide on the petitioner's application, comma, ultimately coming to the conclusion that the tribunal did not find prima facie any defect in the order of the district magistrate. Full stop. It is seen from the said order that the tribunal elaborately considered several aspects of the matter, including the fact that the district magistrate had passed a reasoned and speaking order which reflected his consideration and satisfaction on the affidavit declaring 9 clauses as laid down in section 14 within bracket 1 within bracket small b. Full stop, next para. However, comma, it is contended by the writ petitioner that the magistrate did not consider the most important facet of the challenge taken out by the petitioner, comma, to the effect that patent fraud had been practiced on the magistrate insofar as the affidavit filed before the magistrate did not disclose that the property was fully tenanted, comma, which is evident from the notice of possession as well as the demand notice issued against the petitioner by the issued in the present case against the petitioner stroke borrower by the financial institution. Full stop, next para. In the absence of such consideration, comma, it is submitted that the adjudication dated July 12, 2022 is palpably vitiated, comma, vitiated, full stop. Next para. As such, comma, the petitioner has taken out an application for recall on the said order, comma, primarily on the ground that the facet of allegations regarding fraud were not considered by the tribunal at all. Full stop, next para. Learned counsel appearing for the respondent financial institution stroke applicant in the vacating application contends that the writ petitioner sat tight over the recall application for over a year without moving the same, full stop. As such, comma, it is clearly seen that the attempt of the writ petitioner is to stall the proceeding and is not bona fide. Full stop. It is submitted that in the absence of an independent challenge against the order dated July 12, 2022, before the appropriate forum designated in law, that is the Debts Recovery Appellate Tribunal, comma, this court does not have, comma, within the limited scope of the writ petition, comma, any authority to entertain the dispute raised regarding the said order. Full stop. Next para, that apart, comma, learned counsel for the respondent financial institution argues that the writ petition is not maintainable as of today. Full stop. It is argued that the same was entertained simply because the DRT3 was not functioning regularly at the relevant juncture. Full stop. However, comma, as of today, comma, it is evident that the said tribunal is fully functional, comma, which is also exemplified by the order dated July 12, 2022, passed by the said forum. Full stop. As such, comma, the writ petition ought to be dismissed on the ground of maintainability alone, comma, if not on other grounds. Full stop. Learned counsel for the respondent financial institution places reliance on the judgment of Phoenix Arc Private Limited versus such and such, reported at 2022 5 SCC 345. Full stop. Learned counsel, comma, by placing reliance on the said judgment, comma, argues that a writ petition against a private party is, comma, under normal circumstances, comma, not maintainable. Full stop. It is only maintainable when a public function stroke public duty is carried out by the authority. Full stop. Next para. However, comma, it was also held by the Supreme Court, comma, it is contended, comma, that if proceedings are initiated under the SABYASACHI Act and stroke or any proposed action is to be taken and the borrower is aggrieved by any of the actions of the private bank stroke ARC, comma, the borrower has to avail the remedy under the SABYASACHI Act and no writ petition would lie and stroke or is maintainable and stroke or entertainable under Article 226 of the Constitution of India. Full stop. Next para. Heard learned counsel for the parties. Full stop. Next para. The peculiar predicament in the present case is that the respondent financial institution argues that the writ petition is not maintainable at the present juncture due to availability of the DRT3, comma, although it might have been justified for the court to entertain the same at the relevant point of time when the DRT3 was not functioning regularly. Full stop. However, comma, the said objection has to be taken with a pinch of salt. Full stop. Next para. Even on June 27, 2022, comma, when the writ petition was moved for the first time, comma, it is evident that the DRT3 was functioning, comma, albeit to a limited extent, comma, since the order itself recorded that the matter was fixed before the DRT3 on the said date. Full stop. In fact, comma, the application of the writ petitioner was duly heard by the DRT3 and an order passed therein on July 12, 2022, comma, contemporaneously with the writ petition being entertained. Full stop. Next para. Having not taken the point of maintainability and the said point being not kept open at that juncture, comma, the respondents have fully participated in the present writ petition and cannot now resile and take an objection regarding the maintainability of the same. Full stop. Such an exercise, comma, if given premium to, comma, would permit the litigants to take opportunities and liberties before the court, comma, derogates the law. Full stop. Next para. Thus, comma, the point of maintainability, comma, taken at this belated juncture, comma, is turned down. Full stop.
One thing, Malad. In the order dated 27th of June, Malad,
yes,
my clients were not represented. If your lordship kindly takes up the application page 11.
You're right.
So, my lord, I had not been there. I was not represented at that given
I'll
branch.
record that you have submitted during my order, and I'll give my reasons for that also. I have to. Learned counsel appearing for the, you are for respondent numbers?
5, my lord.
Learned counsel for respondent number 5, comma, at this juncture, comma, rightly points out that the said respondent was not represented on June 27, 2022, when the order in question was passed, and, comma, as such, comma, there was no scope of taking any objection as to maintainability of the writ petition. Full stop, next para. However, comma, it is recorded in the said order that the affidavit of service filed on that date was kept on record, comma, indicating and implying that due service has been effected on all the respondents. Full stop, next para. Moreover, comma, no subsequent complaint has been raised by the respondent number 5 to the effect that no copy of the writ petition was served on the said respondent. Full stop, next para. In fact, comma, the respondent number 5 waited for quite a long time to file the application for modification, comma, not taking the point of maintainability specifically at any point of time. Full stop, next para. Since the order in question was passed by the coordinated bench on June 27, 2022, comma, it cannot be said that the respondent number 5 had no opportunity thereafter, comma, to challenge the maintainability of the writ petition. Full stop, rather, comma, the said respondent has submitted to the jurisdiction of the court by taking out an application for vacating the interim order passed therein.
But the challenges to the maintainability of the writ petition. But there is no point as soon as we have entered appearance in this.
The next para, such belated challenge to the maintainability, comma, as such, comma, is cannot be entertained. Full stop, next para. That apart, comma, the point of maintainability loses relevance on another aspect of the matter as well. Full stop. It is well settled that fraud vitiates all. Full stop. The writ petitioner clearly canvassed the point of fraud insofar as the demand notice as well as the notice of possession issued by the respondent number 5 clearly mentioned the property being fully tenanted, comma, which was clearly suppressed in the affidavit filed by the district magistrate. Full stop, nothing in the order of the district magistrate, comma, challenged in the writ petition, comma, discloses any consideration of such fraud at all. Full stop. The district magistrate apostrophe's order does not indicate anything to show that it was pointed out to the district magistrate that the property was fully tenanted, comma, which would and should have pointed the district would and should have prompted the district magistrate to enter into at least a preliminary inquiry as to whether the tenancy was prior to the loan being taken. Full stop, next para. In any event, comma, since the debts recovery tribunal, comma, despite the said point having been taken by the writ petitioner, comma, also did not advert to the issue of fraud at all, comma, the exercise carried out by the debts recovery tribunal on by its order dated July 12, 2022 has rightly been challenged by way of a recall application by the writ petitioner. Full stop, next para. However, comma, for the sake of propriety, comma, although the district magistrate's order actually does not reflect any consideration on the property being fully tenanted, comma, since the writ petitioner has chosen to take out a recall application before the debts recovery tribunal, comma, which is the designated forum in law to take into consideration such aspect as well, comma, this court is not interfering with the present writ petition. Full stop. However, comma, for all practical purposes, comma, the recall application of the writ petitioner ought to be adjudicated first by the debts recovery tribunal before allowing the possession of the property to be taken within the contemplation of Section 14 of the SABYASACHI Act 2002, pursuant to the order impugned in the present writ petition. Full stop, next para. Accordingly, WPA 10529 of 2022 is disposed of by restraining the respondents from taking any coercive or other action in terms of the impugned order passed by the district magistrate under Section 14 of the SABYASACHI Act 2002, prior to the disposal of the recall application filed by the writ petitioner before the DRT 3, for recall of the order dated July 12, 2022. Full stop, next para. It is expected that the tribunal shall dispose of the said recall application in accordance with law upon hearing learned counsel for the parties, without being unduly influenced by any of the observations made herein on merits, by the end of September 2023. Full stop, next para. It is, however, made clear that the restraint order passed herein shall continue till the disposal of the recall application filed by the writ petitioner as indicated above, and shall be subject to the final order passed on the said recall application by the tribunal. Full stop. No address to cause unnecessary.
Kindly give the protection at least 1 week after the order. So that, my lord, I have a.
No, Mr.
Now, my lord, there's one more thing, my lord. During the pendency, my lord, as long my learned friends can always take steps for extension of the interim order, if at all, my lord. Now, what is being made, my lord, is that will operate till the disposal without whatever was from it.
Without what?
I wouldn't, my lord, as it's.
Tell me, why not?
Fair enough, my lord.
Without what?
Because that's going to continue, my lord. That's what my apprehension is. They are going to delay the proceedings.
No,
In
that is
that
the-
kind of a scenario, my lord.
No, that is
the conduct
that is
itself
the-
has demonstrated, my lord,
that is
they have.
that is the only fetter which is there for you not to proceed before the recall application is heard out. If I put it for a
Lord,
limited
that is
period,
exactly
then you will be delayed.
My lord, the difficulty was
The
since
balance of convenience between your dealing and their dealing is against you.
my lord,
They will be ousted. You will get your property,
they
another
won't be
property.
ousted, my lord. My lord, that's on merits. I cannot deliberate on that.
No, fraud
particular issue.
question has to be looked into. Fully
I
tenanted.
completely agree, my lord, but that has to be done by the learned DRT. That's all what I'm on, my lord. But insofar as the operation of the interim order is concerned, I would humbly beseech your lordship that the same may be made limited. Until because, my lord, this will continue otherwise. But they are going to take advantage of the fact that the application is pending and no steps would be taken whatsoever for fear of
I mean, it is expected. It is expected. It is expected. It is expected that the recall application shall be heard out by the end of September. By the end of September 2023. যেখানে লিখেছি full stop. Next para. Such time limit is, however, peremptory and mandatory, and the tribunal shall positively dispose of the recall application within the said period.
Grateful, deeply obliged.
Can such and such is accordingly disposed of.
Grateful.
I'll have to change that expected. I'll put in some other expression because expectation cannot be positive and mandatory.
Grateful, madam.
In event your lordship had said without unnecessary adjournment.
It's neither here nor there sort of an order. Yes.
Grateful, madam.
Thank you. I'll
Item 13.
Item number 13, I am on behalf of the petitioner, Lordship. Lordship, in that instant matter, I humbly draw your Lordship's kind attention on the previous order, wide order dated 23/6/2023. Lordship, by strength of the previous order, respondent number 2 and respondent number 4 were directed to produce the report before your Lordship through registry. Actual brief fact of this instant matter is that, Lordship, 2 records are missing. And due to that very reason, the petitioner at first filed one put-up petition for tracing out the records, and after that preferred the representation also.
So you and the respondent number, the private respondent.
I'm on behalf of the petitioner.
Yes, private respondent is also there. No. Yes,
Yes,
petitioner
Lordship.
and private respondent filed
private
complaint and counter complaint. So
Lordship.
those cases are, those records are missing.
Lordship.
Yes, what about the report? Yes.
Lordship, I don't know.
Registry report দেয়নি কোনো? Registry তো report দেওয়ার কথা ছিল। আচ্ছা। 2 আর 4 কারা কে ছিল দেখি?
Learned District Judge Barashat and Learned Additional Chief Judicial Magistrate Barakpur.
বার করে দাও, রিপোর্ট গুলো বার করে দাও। এরকম ম্যাটার থাকলে রিপোর্ট গুলো বার খুলে দেবে। Those resulted in criminal cases.
Lordship. Actually, all a case, counter case have been initiated between the petitioner and private respondents.
এটা কার? কোনটা কার রিপোর্ট দেখি? এটা তো এখান থেকে কমিউনিকেশন গেছে। দাঁড়াও। এটা তো কমিউনিকেশন। এটা এদিকে দাও। It transpires from the report given by the office dated August 10, 2023 that the special messenger's report conveying the order of this court to the court of the district judge, North 24 Parganas was received on July 5, 2023 by the said court. Full stop. The memo, the concerned memo, however, returned answer from the office of the ACJM Barakpur, which apparently refused to take the letter as it is not a special executive magistrate court as mentioned in the address. Full stop. Next para. However, it transpires from the records that no reports have been filed by the said two respondents pursuant to the order dated June 23, 2023. Full stop. Next para. Such conduct on the part of the respondent number 2 and 4 is squarely deprecated. Full stop. As such, the respondent number 2 and 4 are directed to file reports as sought by the order dated June 23, 2023 at the earliest, positively within a fortnight from the date of communication of this order to the said two respondents. Full stop. Such reports shall be filed directly by the respondent number 2, that is the district judge, North 24 Parganas at Barashat, and the ACJM, Barakpur, on the next returnable date, personally or through their counsel. Full stop. Next para. It is made clear that the respondent number 2 and respondent number 4, as named above, shall act in compliance with the order, on the basis of the written communication by the learned advocate for the petitioner, coupled with a server copy of this order and the order dated June 23, 2023. Full stop. In the event there is any further default on the part of the district judge, Barashat, and or the ACJM, Barakpur to furnish such report as per the above direction, stringent directions shall be passed against the said authorities, which might also be incorporated in the service records of the said judicial officers. Full stop. The learned advocate for the petitioner is shall ensure that the copies of the order of this date as well as that dated June 23, 2023 is served at the earliest on the respondent numbers 2 and 4 as per above direction. So please serve the office.
Lordship, actually, on the order dated 23/6/2023, I have not served the order. Lordship, now I will serve the.
Not directed to serve.
No, actually, I was not directed to serve, Lordship.
Who says you are directed to serve?
Lordship.
That's why you are directed to serve now.
I will serve, Lordship.
You
Now I will
along
serve.
with server copies, and I'll
Lordship, I will serve.
I'll direct. I'll direct if necessary. I'll direct personal appearance of those judicial officers
Lordship,
if they don't file.
Lordship.
File immediately.
Lordship, and Lordship, kindly give a reasonable date, Lordship.
Achha, the matter shall next be listed on August 31, 2023, fairly at the top of the list.
Lordship, I am deeply obliged, Lordship. I am deeply obliged.
Item 14.
Yes, 14.
Good morning.
Lovely. Yes, who is for the petitioner?
Well, I am for the petition.
Yes, Mr. Maninder.
May it please, Your Lordship. We are challenging
Rest of the
disconnect.
day.
No. May not be more than 10-15 minutes, my lord. We are challenging disconnection notices,
Yes.
all dated on or about 2nd of August 2023. May I give you, Lordship, a brief facts first. My lord, the petitioner before Lordship is a jute manufacturing industry. It's a company. But your Lordship knows the jute manufacturing industry is a labor-intensive industry. So, my lord, the petitioner has labor lines. Initially, my lord, the electricity was provided by the petitioner to the laborers and their households from their own supply. Well, it was found that that supply was not adequate supply to cater to the needs of the household of these laborers. As a result whereof, an arrangement was reached at between the workmen and the company, as well as we had consulted the CSC. So 32 meters were installed for 32 clusters and one workman for each cluster was identified as the consumer. So your lordship will find from each of the bills that it is X and others, Y and others, so on and so forth.
These were block meters.
No, these are, my lord, single meter. Block meter.
Has to be block meters, yes.
Block meters.
And
I'm
others
sorry.
means block meters.
Block
Anyway,
meters.
yes,
Well,
yes.
But I'm not versed with that
No,
technicality.
naturally, yes.
My lord, what happened, my lord, all was going well. The arrangement was that, suppose, my lord, 3,000 rupees or 7,000 rupees is the electricity bill for X month, for month of June. So in the month of August, for that bill, my lord, proportionately, my lord, deductions would be made from the wages of the laborers belonging to that cluster. In the month of May, a bill was raised. My lord, kindly take this bill. This is very interesting.
Bill was paid at the first instance by the laborers themselves.
No, from the very day one, the company took the responsibility and paid the bills directly to the CSC, and this is an
and subsequently you deducted from their wages.
Yes, yes. That
Right.
was the
Yes.
Well, kindly take, my lord, for once, page 228 onwards. I'll take your lordship not three documents first. My lord, kindly take first page 251, 245. It starts from page 228. Kindly take 245. আছে তো এই তো I'm sorry, pagination nahi. I'm so sorry. Malad, may I just take your lordship?
Pagination is very means smudged sort of. I mean, it must be there.
It's blurred. It's blurred somewhat.
Very blurred.
ডিসকানেকশনটা বন্ধ রাখ, আজকে প্রাইজেশন করে পাঠিয়ে দেবো।
Yes, after your CSC limited for immediate assistance, that is the immediate assistance. Yes. Yes.
Kindly
Mr.
take one of the bills. I will take your lordship to two such bills and two such subsequent bills and two such subsequent notices, disconnection notices. Kindly take, this is the month bill for the month of May 2023. Kindly take, my lord, the amount, it is 9,60,390. Your lordship has got that. And units billed is 1,08,650. So this is for 1 month. Malta has got that?
What is that? 1 lakh? Oh, yes, yes. I'm sorry. Yes.
1,08,650. So this is for the month of May. So, my lord, kindly take now another such bill. Kindly take, my lord, page 251. My lord, this is the case of Aminullah, and this is the case of some Prahlad Shahu. Kindly take, my lord, this May 2023 bill. In this case, the bill details are like this. My lord, the amount is 1,98,980, and the units billed is 29,832. My lord has got that. My lord, kindly now come directly to volume 2 of the petition. First, kindly take, my lord, page 269. This is corresponding to, my lord, Aminullah.
So that is no violation of Article 14.
Yes, my lord.
Both Aminullah and Prahlad Shaw have been.
Yes, my lord.
Yes. 269, yes.
269.
Yes.
I'm sorry, 269. June 2023 is 369. 369. It should be 369. I'm sorry. Just kindly give me a second. I'm so sorry. Yeah, ঠিক লিখেছি না দাও এক সেকেন্ড this Prahlad Shaw is
Aminullah is 369. Aminullah is
369. Well, kindly now take, my lord, the bill for the month of June. Well, now the unit is 5207.
Yes.
And the net amount payable is so and so, taking into account the earlier amount. And this also, my lord, has a notice. This is the green bill, the traditional green bill. So you have to, there is a notice of disconnection that if you don't pay within such and such date, the electricity supply would be disconnected. This is for, my lord, Amirullah. Now coming to Prahlad Shaw, your lordship will find at page 327. 327.
Yes, 327. Prahlad Shah.
This is again bill for the month of June, taking into account the earlier bill, and now the total unit is 1901 and the total amount is so reflected. This also contains a notice of disconnection.
Yes.
Now, kindly take any of the disconnection notices because all are similarly worded. In the meantime, upon receipt of these bills, the representatives of the company met the CSC officials, but in vain. They could not convince that this is not possible for 1 month. Now, kindly take, my lord, one of the disconnection notices which your lordship will find at page 333.
Yes.
May I read out this notice? We write to inform you that due to incorrect recording of meter readings for months together prior to May.
Page 333.
Yes, my lord. Sorry, I'm 383. 383. Yeah, so this pagination. I'm so sorry.
Yes. We write to inform you. Yes, yes.
We write to inform you that due to incorrect recording of meter readings for months together, so now it is no longer restricted to the month of May. It becomes months together. Prior to May 2023 account bill, our bills raised prior to April 2023 account resulted in huge underbilling vis-a-vis the actual consumption of units. This fact was detected only in June 2023, and the said underbilling was reconciled by including the underbilled units in May 2023 account bill. The same was intimated to your representative during our visit at site so-and-so Ludlow Jute Mill, Chengel, on June 22, 2023. The caption meter was read on the scheduled reading date, that is 16 June 2023, to capture the units consumed to be billed in the May 2023 billing account. The reading obtained on the said date was 163371. Considering the undercharge units not billed earlier along with the consumption of the current unit, our consumption bill for the May 2023 account was prepared for 29832 units, that is 163371 minus 133539. So, my lord, for the month, it is an admitted position that prior to this, the reading was 133359. So, only when it was inspected during the June visit, it was found that it is now 163371, amounting to rupees so and so. As the bill is consolidated in nature, for the sake of your convenience, we are agreeable to accept the same in suitable installments. The above meter was inspected by our engineering department on 31st May 2023. When the meter was found to be registering correctly, the consumption being made through it, and the reading on the said date was 162253. Subsequently, the June account bill for 1901 units amounting to rupees 107471.99 was tendered on the basis of the actual meter reading, that is 165272, obtained at site on 17 July 2023. The June 2023 account bill includes the unpaid May 2023 account bill amounting to rupees 2,11,000 and odd, with the due date of 31st July 2023, which is still lying unpaid. As an essential part of our responsibility for providing uninterrupted services, we must ensure timely receipt of payments to continue supplying electricity to our valued customers. Unfortunately, despite our previous meeting with Mr. Rajesh Gupta on June 27, 2023 at his office, where the whole matter, including the underbilling and subsequent charging of the underbilled units in May 2023 account, was explained in detail, the outstanding amount for May account has not yet been settled. Thereafter, the bill for June 2023 account has been raised, which includes the unpaid amount of May 2023 account bill. To avoid disconnection, we urge you immediately to make the payment of the outstanding amount or contact the undersigned to avail installment facility. It is imperative that you act promptly in demonstration of your bona fide. Please note that failure to address this matter within 15 days from the date of receipt of this notice will compel us, albeit reluctantly, to disconnect the above caption meter as per extant statutory provisions. This action would be taken as a last resort, since we sincerely wish to avoid any convenience to the beneficiaries of the supply. An opportunity to make payment is hereby being granted. then this is the usual. But three things arise, my lord. One, for the month, there is, my lord, admittedly, the recording for the month of May is in lakhs. The units are in lakhs. My lord, for the there is no justification or there is no rationale behind this order to make this bill as retrospective in nature, to give this bill a color that it is for the prior periods. And if it is for the prior periods, then obviously 56(2) will come into play, because they have not even disclosed in their disconnection notice for how many months this underbilling or underreporting was occurring. There is no finding of fact arrived at by the authority that the bill was tampered by anybody. They say that the meter was functioning correctly. If the meter was functioning correctly in the month of June, the meter was also functioning correctly in the month of April. The meter was also functioning correctly in the month of March. So, my lord, what was the occasion for which, my lord, the units consumed for the month of May was an astronomical figure. It is an astronomical figure, not commensurate to the consumption at all. My lord, first, my lord, this disconnection notice is bereft of any rationale. The disconnection notice does not disclose for how many months this underreporting happened or underbilling happened. The disconnection notice also does not justify how the meter can be correct for the month of April, March, April, and June. But something happened during the month of May, which prompted them to record units in excess of lakhs. My lord, in all the cases, in all the 32 cases. My lord, this notice is therefore bad if it is for the prior period under section 56(2) of the Act, and it is bad if it is for the present period, for the reason, my lord, there is no justification whatsoever, because there is no tampering of the meter at all. Well, I pray for your lordship that these notices may be stayed for the meter.
Mr. Majid, why didn't you approach the GRO? Grievance Redressal Officer? I mean, that is the authority. Factual questions have to be gone into here.
Well, factual, my lord, some admitted facts are already there before lordship.
Some admitted facts are there.
What is the first? I put the question to myself with all humility. First admitted position is that the meter reading for the month of April or any prior period was identified or was noted. The meter reading for the month of June was also noted. Now, the meter reading for the month of May recorded, I do not know, in excess of lakhs in each and every cases. Maybe a little less, little more, that I am not right now elaborating. Then, my lord, the bill itself does not say, the disconnection notice does not say that for which prior period, for months together.
The questions you have raised are on principles.
They are principles.
Very.
And, my lord, not only that, my lord,
yes,
this notice entails adverse civil consequences.
Adverse?
Civil consequences, no doubt about it. If this notice entails adverse civil consequences, was it not obligatory on the part of the authority to disclose the reasons and before arriving at this kind of decision, give an opportunity of hearing to the parties? Not this kind of discussion. My lord, my respectful submission before your lordship would be, my lord, to quash these notices. My lord, I tell your lordship, the consequence is like this.
Yes.
Around 1,200 family members of these workmen would be affected by this kind of disconnection.
That is the trump card being used by Leonard Jr. from the date of mentioning.
Yes, my lord. Not only that, my lord, today, if I pay this amount, my arrangement says that I have to recover it from my workmen.
True. They have to pay. Ultimately, it is
they have to pay. And if that be so, my lord, this unit will close down.
That is the main ground. 1,200 workmen family members is the main ground. The others are secondary.
It is supervening public equity, my lord. It's a question of supervening public.
Very well, yes. Yes, what do you say on the supervening public? What possibility should I say?
Yes, my lord. Supervening, my lord, then in that case, my lord, the
no, not that. But Mr. Rai, he is justified, apparently justified in two things at least. that regarding this tampering, there is no charge. Admittedly, there was
no question of tampering.
no tampering or even defective meter.
No, my lord.
That be so. What happened in May?
Yes.
Yes.
That is why, my lord, if your lordship takes, my lord, page 383 once again, my lord, I'm leaving apart, my lord, the points of maintainability now, my lord, so that, my lord, I can show, my lord, that I am not malafide in my approach. My lord,
Yes.
383.
Page 380?
83. My lord, the letter which was placed by my lord.
Oh, that's right. Yes. Yes.
My lord, it says, we write, my lord, the first line, we write to inform you that due to incorrect recording of meter readings, now there is a mistake in recording of the meter readings. My lord, one more thing is not disputed. That other thing which is not disputed is that the number of consumption units, my lord, which are shown in the meter are also not disputed. My lord, there is no averment in the writ petition that the number of units shown in the meter, my lord, should not be that which has been shown. My lord, the calculation arrived at on the basis of the number of consumption units, my lord, recorded by the meter, reflected by the meter, revealed by the meter. And, my lord, the consideration or the consumption costs arrived at, my lord, upon such calculation. My lord, how can that be disputed, my lord, in my very respectful submission, if the number of units consumed is not disputed? My lord, there is no dispute as regards the number of units consumed. No, my lord, so far as the point as regards, my lord, section 56(2), Lord, 2 years. My lord, this is not a case where, my lord, I have come after, my lord, a particular passage of time having passed, then, my lord, intermittent, there is a break, and I come again. My lord, this may include, my lord, the entirety of the 2 years. This may be less than 2 years. Even if it is more than 2 years, my lord,
disclose nothing on that count, Mr. Rai.
Lord, we have written, Lord, because, my lord, that needs to be gone into, my lord.
If this was the consumption only for May 2023, it is ex facie suspect.
It is not, my lord, because it says.
Because you have admitted that there were previous incorrect recording of.
Yes, it says for months together. Lord, it says for months together.
So you have to be specific on that. These are the months on for which we have charged you. Otherwise, how can you raise such a bill out of the blue?
That requires, my lord, that requires.
Give them a hearing on this and disclose exactly what is the breakup for which month, what,
Yes,
how many
definitely,
units.
my lord. That is why, my lord, the GRO, my lord, they could have approached the GRO. My lord, they should have approached the GRO.
Instead of going to the GRO, Mr. Rai, I'll set aside because this does not disclose any basis.
My lord, your lordship will not set aside on this, my lord. They have been called for, my lord, your lordship will kindly see.
Yes.
My lord, kindly see, my lord, page 384.
Yes. To urge you to immediately make the payment.
And, my lord, before that, my lord, to avoid disconnection, we urge you to immediately make the payment of the outstanding amount or contact the undersigned to avail installment facility thereafter. It is imperative to act promptly in demonstration of your bona fide. Please note that failure to address this matter.
No,
Lord, there is no representation against
you
this.
don't
Lord.
give your breakups. How can they address the matter even without
Lord,
knowing
let them
for
say
what
so.
period you are charging, Mr. Rai? No.
Lord,
there is no basis of charging at all here. Suddenly, all on a sudden, you said so many units and you admit for the previous months, so many
Lord,
months.
let them represent against this letter.
Why should they? You should
Lord,
first disclose what is the breakup one for exactly what period there were incorrect readings. You have to disclose these. You have to have some transparency, Mr. Rai. Just because you run almost a monopoly, cannot do this.
Lord, it was not because of monopoly, my lord. I have demonstrated, my lord, that the units, my lord, consumption units, my lord, which are recorded in the meter, that are correct.
Just see your language.
Yes.
We write to inform you that due to incorrect recording of meter readings for months together.
Yes.
Prior to meter, which months? What is the incorrect meter reading? You disclose nothing. Precious nothing, Mr. Rai. Due to that, our bills raised up to April 2023 account resulted in huge underbilling. You say the entire thing, it's absolutely arbitrary, Mr. Rai. Palpably arbitrary. It's especially arbitrary. If this is not arbitrary, then what is? Tell me.
What
Yes,
is
you have given a reason. But what is the reason? This reason is not a reason at all. So disclose. That is why I am saying that I have to set aside this at the outset, because on what will they answer? You have to formulate the question properly first. That this is the number of months for which there were incorrect readings. These are the units consumed during that period. On the basis of it, this is the bill breakup. Let them dispute it.
Very good.
And instead of the GRO, I'll appoint a special officer, Mr. Mukherjee, who will decide.
Yes, madam. That will be
Since he's very, very ardent on these things.
But I agree to that, madam.
Yes, they are agreeing. Yes.
I leave it to you.
So, Mr. Mukherjee, when is suitable to you? You have to make only certain 1,000 calculations. I mean, yes, 1,000 or 2,000 calculations only. Yes. And we'll have to take the meter readings for the relevant.
I've left maths in class 10, my lord, I had to very
Learned senior counsel for the petitioner contends that the demands made by the CSC Limited for supply of electricity to labor lines of the petitioner industry were palpably arbitrary and ought to be set aside. Full by placing the concerned bills for the relevant periods, comma, as well as the notice threatening disconnection in default of payment of the alleged outstanding amount dated August 2, 2023, comma, it is contended that the CSC Limited has disclosed almost nothing regarding the exact period for which there were incorrect recording of meter readings and the exact units consumed during such period. Full in view of there being no such allegation up to the month of May 2023 and from June 2023 onwards, comma, the sudden inflated bills for the month of May 2023 is without any explanation at all. Full it is contended that, comma, admittedly, comma, the meter in question does not suffer from any defect whatsoever. There is also no tampering charge on the part of the CSC Limited. As such, comma, there is no rationale behind the exorbitant bills raised for the month of May 2023. Next para. In the event the CSC is of the opinion that the said bill was raised for retrospective periods, comma, there is always the issue of a bar under section 56 within bracket 2 of the Electricity Act 2003, comma, since in the absence of specific disclosure as to the relevant period, comma, it may very well be assumed that the period for which such alleged underbilled amounts are charged were beyond 2 years from the date of raising of the bills. Next para, that apart, comma, there is no justification whatsoever in the impugned demand notice, comma, it is contended. Next para, learned senior counsel appearing for the petitioner, comma, thus, comma, submits that the said bills for the month of May 2023 as well as the demand notice be set aside. It is further contended that the proposed disconnection by the CSC Limited shall adversely affect about 1,200 family members of the laborers, comma, who work for the petitioner company and live in the labor lines where the electricity in question is supplied by block meters for several clusters. Next para, learned counsel appearing for the CSC Limited submits that the writ petition is not maintainable since the challenge as preferred in the present writ petition pertains to a billing dispute which has to be resolved under the governing regulations before the concerned grievance redressal officer within bracket GRO. Next para, secondly, comma, it is submitted, comma, that even without making any charge of tampering and or faulty electricity meter, comma, the demand notice itself discloses that there were certain incorrect recording of meter readings for several months prior to May 2023. Next para, it is submitted that there is no bar in the distribution licensee to raise bills on account of mistakes committed in meter readings. Next para, that apart, comma, the writ petitioner, comma, it is argued, comma, has not disputed the units consumed during the relevant period. Hence, comma, the present challenge is toothless. Next para, upon hearing learned counsel for the parties, comma, it transpires that the bill for the month of May 2023 raised by the CSC Limited against the petitioner for supply of electricity to the labor lines of the petitioner's workmen is palpably without any basis. Full stop. On a plain reading of the bills for the previous and subsequent months, it is clear that the amount raised and alleged units consumed as per the said bill is ex facie exorbitant. Full stop. Next para. The said, the difference between the said bill and the unit consumed as per the same is demonstratively different in magnitude from the previous and subsequent months. For sub next para, the explanation of the CAC, afforded in the demand notice dated August 2, 2023, annexed at page 383 of the writ petition, throws precious little light on the said issue. Full in the very first sentence, the CAC Limited admits that there were incorrect recording of meter readings on the part of the CAC Limited for within double inverted months together prior to 2023, double inverted close, full stop. There is no disclosure whatsoever as to the exact months regarding which there were incorrect meter readings and what were the actual meter readings for the said months. Full stop. That apart, no breakup whatsoever has been provided by the CAC Limited for charging such exorbitant amounts under the head of the month of May 2023 solely. Full stop. Next para. The CAC Limited itself admits that the meter was not tampered and or did not suffer from any fault. Full stop. Hence, the reason for the incorrect readings and or the basis of charging such exorbitant amounts is also not disclosed. Full stop. Next para. Contrary to the argument of the CAC Limited that the demand notice itself affords an opportunity to the petitioner to clarify the discrepancies, if any, in the bill, the notice itself stipulates that within double inverted to avoid disconnection, double inverted close, the CAC urges the petitioner to immediately make the payment of the outstanding amount or contact the undersigned, that is the assistant manager within bracket commercial bracket closed, Howrah Regional Office of the CAC Limited to avail installment facility. Full stop. It is also disclosed in the said notice that it is imperative that the petitioner acts promptly in demonstration of the petitioner's bona fide. Full stop. Bona fide within double inverted is a misused term in the demand notice, since the notice itself is palpably arbitrary. Full stop. Next para. The notice is a direct threat of disconnection in the event the petitioner does not pay the exorbitant amounts charged, since the only two options given to the petitioner to avoid disconnection was either to make the payment of the outstanding amount or to contact the author of the communication to avail installment facility, which also pertains to such payment being made. Full stop. Hence, no prior opportunity of hearing or representation was given to the petitioner. Full stop. More importantly, the demand notice itself is absolutely opaque, and does not disclose any basis of the overcharging. Full stop. Hence, the said notice cannot survive judicial scrutiny. Full stop. Next para. Insofar as the point of maintainability is concerned, since the demand notice impugned herein and the bill for the month of May 2023 are palpably arbitrary and without and unreasonable, this court, within its powers of judicial review under Article 226 of the Constitution of India, is very well empowered to interfere, without unnecessarily relegating the petitioner to a fact-finding authority. Full stop. The challenge preferred in the present writ petition is on broad principles of natural justice and does not require a fact-finding inquiry at this stage. Full stop. Accordingly, WPA 18998 of 2023 is allowed on contest, thereby setting aside the bill raised by the petitioner by the CS Limited against the petitioner for the month of May 2023, as well as the demand notice dated August 2, 2023. Demand notices dated August 2, 2023, issued by the CS Limited against the petitioner, which are impugned in the present writ petition. Full stop. The CS Limited shall raise a fresh bill, indicating the exact breakup for charging the amounts in the said bill, for the month of May 2023, incorporating previous dues in, if any, by clearly mentioning the exact months when incorrect recording of meter readings took place and the exact units consumed during the said months and the charge thereof. Full stop. Such bill for the month of May, 2023, including the detailed breakup, shall be sent by the CS Limited to the writ petitioner afresh. Full stop. However, nothing in this order shall preclude the CS Limited from issuing current bills for the continuing consumption of electricity by the writ petitioner regarding the meters in question prior to the issuance of the fresh bill. Full stop. Next para. It is made clear that in the event the CS Limited issues such a fresh bill in compliance with the order of this court, and the petitioner has a further grievance with regard to the breakup and or on other factual aspects on the same, it will be open to the petitioner to approach the concerned grievance redressal officer for resolving such dispute.
And only, somewhere it is bill, it will be bills, bills.
Bill for May 2023 bills.
May and June.
Yes. Yes.
Grateful,
Thank you.
Yes,
Thanks.
so grateful.
Great.
Upgraded matter, item 15.
15, Lordship, I beg to appear on behalf of the.
Yes.
My lord, this unfortunate story of a lady and my lord, her brother, my lord. Since 1981, they are not getting pensionary benefit and all these things. My lordship will find, my lord, 3rd January's order.
And her brother.
Brother, my lord.
Your father something happened to your father?
Died. Father died.
Yes.
My lord, he was an ambulance driver of the state of West Bengal and the health department. Lordship, kindly see Lordship own order on 3rd January 2023. Once it was upgraded and my lord directed the state authority to file the report. My lord, that report is whether in the record or not, my lord, I am not brother, my lord. But we have taken exception of that report. We have enclosed that particular report of the state authority. If this honorable court kindly permit me, I can hand it over. My lord, the order dated, order dated 3rd January may kindly be looked into, my lord.
Report exception you have already filed?
Yes, my lord. This is in my hand, my lord.
Yes.
Except, my lord, what happened, my lord, protracted litigation in the State Administrative Tribunal first round. Thereafter, my lord, the Honorable Writ Court.
Have you given a copy of the exception to them?
Yes, my lord, we have served them. And we have given them repeated notice. The copy of the notice is lying with us. Yes. My lord, my humble submission may kindly be looked into, my lord. Kindly see page 16 of the writ application. Page 16 of the fact of the case, my lord.
No, what was your claim?
My lord, my claim is, my lord, the pensionary benefit. My lord, the brother, my lord, the son of that deceased employee applied for the compassionate appointment. That was, my lord.
He died in harness.
Died in harness.
Then?
Lord, kindly see page 16.
Yes.
My lord, in the year 1983, my lord, at the bottom, lordship will find the date 16/8/1983.
Yes.
My lord, the plea, my lord, they have taken in the year 1983. That plea is repeated in the report itself. My lord, last paragraph, no other record are available in this office. So the application of Mr. Ghatak is forwarding for favor in of necessary action. 1983, 16/8/1983. My lord, the person died in the year 28th December 1981. My lord, lordship will find, my lord, before that paragraph, lordship will find, it is written by the government of West Bengal, Office of the Subdivisional Medical Officer, Katwa, SP Hospital, my lord, Bardhaman. Second paragraph I am reading, my lord. In this connection, I beg to inform you that Shochipati Ghatok, the father of them.
This is paragraph?
Para 2, my lord. Of
the
the
report?
page 16, no. My lord, I'm reading from the writ petition.
Yes, yes.
Some old document I have enclosed here with. My lord, the second paragraph, in this connection, I beg to inform that Shochipati Ghatok worked in the hospital up to 1965. As per records available in the office, he has been paid salary up to 1965 when he was on deputation at Asansol LH Hospital.
When did he die?
My lord, in the year 1981. Lordship will find from page.
So he did not apply from 65 to 81?
No, my lord, he was in the service. And
Yes.
while he was service died, page 18 may kindly be looked into. It is their document.
No, you have asked for his dues from a particular hospital.
No, I am asking from the state of West Bengal, my lord, the health
Internal-
department.
yes,
Health
right.
department. They are, my lord, the disbursing
What is the
section.
meaning of this? In this connection, I beg to inform you that Sri Shochipati Ghatak worked in this hospital up to a particular period.
My lord,
So how does this help you?
No, not helping. My lord, certain documents are lying with us. We have enclosed here with. My lord, they are taking repeated plea. The records are not with them, as a result of which.
Which authority has to pay, Mr. Chakraborty?
My lord, kindly see, my lord, the health department. My lord, the respondent number. My lord, the director of the respondent number 2, Government of West Bengal, and the principal secretary has also made party, Department of Finance, having office is Navanno, because my lord, there was repeated direction from different department to reconstruct record, and they are taking the same plea. The record is
As an employee under which department?
Health department. My lordship will find, my lord, page 18. Lordship, kindly see, for compassionate appointment, they have processed the application of the son. Here, my lord, as it appears, paragraph 6, my lord, of page 18, date of death of disease, my lord, lordship got it?
Yes, yes.
28/12/1981. Date of birth of the disease is, my lord, 32. It means, my lord, 92, my lord, date of retirement, 10 years left there, my lord. That being the situation, then again, my lord.
So what about happened about the compassionate appointment?
My lord, the compassionate appointment, my lord, kindly see, my lord, they have rejected my compassionate appointment, page 27. My lord, kindly see, my lord. Record is not there and delay was there and all these things, my lord, that was their plea. Though, my lord, they have processed my application in time, I have processed my application.
When was your application first filed? Your father's application, when was it filed? Oh, he died during it. When did you first file the application for disbursal of the dues?
My lord, since very beginning, my lord, very beginning we are trying hard.
First application, please.
My lord, I'm coming, my lord.
He died in 1981. Must have been close to that.
No, I closed them, my lord. That being the situation, my lord, here the they are, my lord, virtually illiterate persons, my lord, they're in difficulty, but their application for compassionate appointment was under process. Even, my lord, offered him to be a personnel of the police department. And, my lord, all other examination, my lord, endurance tests are taken place. That is reflected from this document I have enclosed here with.
What happened to that?
My lord, nothing happened. In page 27 may kindly be looked into, my lord. Page 27, they have rejected that contention because it is penury for the delay and all these things. In the year 2015, they have rejected that application, my lord. Here in the year 2011, communicated in the year.
That was not challenged by you.
My lord, not challenged, but my lord, during this time, I became an older person, now about 55, 56 years old, my lord. My lord, I am not.
Occasion of Justice Datto's division bench judgment?
My lord, division bench judgment, my lord, lordship, kindly see page 29. At the very outset, it was before the State Administrative Tribunal. State Administrative Tribunal rejected it. Then, my lord, we moved this honorable.
What? Which this present application?
Yes, my lord. Previously, my lord, the very outset, since, my lord, it is State Administrative Tribunal jurisdiction, we have made application before the authority. Page 29 may kindly be looked into.
Rejected on what ground?
My lord, delay, my lord. Page 29.
Yes.
Even my lord, the pensionary benefit and other benefit where no third party.
Rejection of the compassionate appointment application.
That is as it reflected from page 29. Only compassionate appointment was taken into consideration by the State Administrative Tribunal. But my application was for twofold reason. One, my lord, pensionary benefit, other compassionate appointment. That was the reason for that, my lord, Honorable Justice Dipankar Datta, as his lordship then was, my lord, rejected the order of the State Administrative Tribunal and relegated it before the State Administrative Tribunal once again. Now, my lord, the second round of litigation, State Administrative Tribunal directed the state authority to reconstruct my document. So far, that is not done, my lord. That is, I'm showing, my lord, page 29, my lord, the order passed by the State Administrative Tribunal.
That demand is still now pending.
Yes, my lord. And my lord, myself is, my lord, in a situation in the hovering in between life and death, not getting any penny, my lord, since 1981. And state authority, even in this report, my lord, took a particular plea. I was not a permanent employee. Whereas, my lord, they themselves proceeded my file for permanent for my compassionate appointment. That being the situation, my lord, taking it very casually. Lordship will find, my lord, the last order passed by the, my lord, the State Administrative Tribunal, that is page 45. Very specific direction was there, my lord. Page 44, 45, my lord. My lord, I'm reading, my lord, third paragraph of page 44, subject to, my lord. My lord, reading.
No, they have stated that besides a person who was reportedly born on 20th of February 1932, and who last worked till 18th of May 1965, you did not work last till that
No,
date.
my lord, while I was doing work, my lord, myself, my lord, the death was taken place. That being the situation. And my lord, certain documents they have, my lord, we have collected from that at that point of time, including, my lord, the file which was processed by them for my appointment in died in harness. That document I have just shown, my lord.
Can you please show me the order of the tribunal directing the?
Yes, my lord. That is page 44, my lord. Third paragraph. That is in the year, my lord. Lords, you will find in the year 2019, in all probability. Yes, my lord. On 3rd September 2019, start from page 39. And my lord, the last two paragraph, my lord. Lords, you will find from the page 44. My lord, it appears from the annexure of the Shochipati Ghatok, worked in Katwa SD Hospital, Bardhaman in 18 May 1965, and was paid salary so when he was on deputation in Asansol LM Hospital. That is also a government hospital. Therefore, no records are available. He expired in the year 28 December 1981. Since there is dearth of record, and as it appears from the reply of the service book, could not be reconstructed due to non-availability of instruction from higher authority. Considering the said fact, this application is disposed of by directing the Chief Medical Officer of Health Bardhaman, now Purbo Medinipur, the respondent number 3, to first decide by coming to a finding and by passing an order regarding the identity of the applicants and the length of service of the deceased government employee, Shochipati Ghatok, after verifying the records within 8 weeks from the date of presentation of a copy of this order. If he is satisfied about the identity of the applicants and confirm the length of service of deceased government employee, he shall immediately seek for necessary order of reconstruction of the service book, and the additional Chief Secretary, Government of West Bengal, my lord, the respondent number 1 shall issue necessary order of reconstruction of service book within 8 weeks, and the service book will be reconstructed within the said period. And the service book is reconstructed, the matter regarding grant of pensionary and retirement benefit will be considered by the respondent number 1, and reason order shall be passed within 10 weeks. My lord, that was not, my lord, superheated. Then, my lord, I draw attention of the Honorable Lokayukta. That is page 41. Page 41, my lord, immediately cognizance was taken by the Honorable Court.
Page 41.
47, my lord, I may be excused. Annexure P11. And my lord, the Lokayukta has taken up, my lord, the cognizance. Page 51 may kindly be looked into. My lord, here, my lord, Dr. Ajay Kumar Chakraborty, Director of Health Service, together with Sudeshna Gupta, Special Secretary of Additional Director of Health Service, are present. Then, my lord, I'm skipping, my lord, 2-3 lines. Dr. Chakraborty, in usual fairness, submits the department has already taken all possible steps, even in absence of any service record of the late Shochipati Ghatok, so that grievances of the complainant be remedied. It is also submitted that they are quite aware about the order passed on 3rd September 2019 by the West Bengal Administrative Tribunal.
They were directed to expedite. After this, what happened?
My lord, after that, my lord, nothing happened. My lord, because of this Lokayukta is not functioning, my lord, there is no consent from the Honorable Rajyapal and all these things defunct. And one more document I want to show, lordship. My lord, at a point of time, my lord, the department in the year, lordship, kindly come to my lord. Lordship, kindly come to my lord, page 26 for a while. My lord, the roaming in the barandas of Shastha Bhavan for a considerable period of time. At that point of time, my lord, Special Secretary, my lord, wrote this letter to the Superintendent Katwa Subdivisional Hospital, my lord, in the year 2015, page 26. Inviting a reference to above, you are hereby requested to furnish the latest development regarding disbursement of pensionary benefit in respect of the late Shochipati. My lord, every attempt has been made by the petitioner and this, my lord, ill-fated family. My lord, nothing happened, my lord.
Have you got anything to show, any document, anything to show for the purpose of reconstruction? Apparently, they say the records are not available. They're being very slipshod about it.
I'm showing, my lord, there are several documents which are available with me. Page 16, 17, 18, every document, my lord.
Of the petition?
Yes, my lord. Page 16, And my lord, the last letter of my lord, the special secretary is of the opinion pensionary benefit related report. He short for. My lord, page 16. Here, this particular letter, they have admitted Shochipati was their employee and then deputed to the LM Hospital, Asansol. This is one. Page 16, annexure P1.
Yes.
This is the document, my lord. This document in the year 83. At that point of time, they have taken this particular plea. The documents are missing. Died in the year, my lord, 81 December, 28 December, 83 file is missing from the state authority. Then lordship kindly find, my lord, next paragraph page 17. My lord, to some extent, my lord, it is difficult to read, my lord, but I'm showing certain documents are there. And then, my lord, they have decided to appoint me, lordship kindly see page 18, para 9, last paragraph, whether the candidate is willing to be employed in the post of police constable. If so, his measurement, chest, height, weight, please, all the furnished. Then, my lord, there are all details, chest 37 inch, my lord, the height so and so 5'5".
You were turned down on medical ground.
No, my lord, they have page 27. Page 27, my lord, kindly see. There was delay in all this thing because, my lord.
After giving this offer to you?
Yes, everything, my lord, 3-member committee was also operating so far, my lord, ascertaining my grievances. Page 21, may kindly be looked into, my lord.
The division bench did not take care of the compassionate effort.
Yes, my lord. True. Because, my lord, I am a aged person, my lord, and at the same time, if
But at the point of time when it went up before the division bench, you had already crossed
52 years, my lord, what happened, my lord, that particular portion, my lord, we are asking, my lord, the intervention of the Honorable Court for our survival. Then, my lord, the betterment in life, my lord, rather standard life. My lord, so far this job is concerned for
this
lord,
calculation, whatever documents you have, what are the documents? Tell me.
My lord, the calculation I have not made, my lord.
Calculation you cannot. No. What documents are there to show that your predecessor was in service at that point of time?
That is, my lord, they are document once again, my lord, lordship.
Page 16.
Page 16, 17, 18, my lord, the compassionate appointment
Page
related
16 to
document.
18, apart
18,
from that, yes.
18, then, my lord, kindly see, there was a 3-member committee, page 20. For to ascertaining my condition of, my lord, the financial condition and all these things, page 20, type portion is page 21. My lord, kindly see, my lord.
Yes.
3 members committee, first paragraph, my lord, last 3 line, last 4 line, compassionate ground, my lord, Sri Kalachad Ghatok, petitioner herein.
Give me the page numbers, Mr. Chakut.
Page 21.
Apart from that, any other page?
Any, my lord, I am showing once more,
that
my
he
lord.
was in service.
I am showing on page 22. Page 22, in continuation to this office order dated inquiry into the matter of prayer of employment of the compassionate ground in respect of Kalachand Ghatok, son of Shochipati Ghatok. Shochipati was ex-employee and Kalachand is the son and petitioner over here. This particular document, this is in the year 2008. And then let's turn to the next page. All other documents, my lord, they have collected from me, page 24. Employment.
Petitioner number was petitioner number 1's employment now.
Now, my lord, he is an unemployed person, my lord, in all frustration, he is living his life. And my lord, virtually, my lord, is a below poverty line person. And my lord, that being the situation, my lord. And lord, we will find also, my lord, page 24, employment on compassionate ground in respect of so-and-so.
No, have you ever heard anywhere that you are below poverty line and anything?
My lord,
or anything regarding
that is, my lord,
condition?
that is, my lord, I'm just, well, there are a round of litigation, my lord. And we have made every statement before the state administrative tribunal. Now here, my lord, we are the order passed by the Lokayukta, my lord. I'm sure
it has been observed that you are below poverty line, or
no, my lord, that is, my lord, in this application. My lord, naturally, my lord, I'm not doing anything. My lord, I can, my lord, file it by swearing affidavit. And my sister, she is widow, she is living with me. Both of we are, my lord, there. I'm an unmarried person, not able to, my lord, even.
According to you, Mr. Chakravarti, what can be done if the records cannot be reconstructed?
My lord, from, my lord,
how will the what will be the basis
from 81, my lord, date of death, my lord, their calculation is required to be made, my lord, or at least interim pension to be, my lord, initiated by them, my lord. At the same time, a final report to be, my lord, called for and to ascertain the what
report calling for won't do.
Lordship.
No further report can be called
Lordship.
Because several reports have been called for over the years.
Yes, my lord.
Over say 20, 40 years.
40 years, my lord.
For 40 years, reports have been called for.
My lord.
You have seen the fate of that.
Yes,
no further reports are not called for.
Kindly direct
on the basis of the materials
available. One judgment, my lord, the similar circumstances where, my lord, the Honorable Supreme Court was of the opinion in such a situation, lordship, kindly see, my lord, the bold portion and paragraph 6, my lord. Lord, I'm just reading, my lord, the bold portion, my lord. pension, family pension, right of a illiterate widow of a petty employee and obligation of employer in respect where a gangman under the railway died while in service and his widow illiterate and unaware of a right to family pension and the remedy to enforce that right held, it is obligatory for the railways to compute the payable family pension and offer the same to the widow even without making a claim or initiation of litigation on her part.
That is on a different point.
My lord, different point, my lord.
Entirely different point.
My lord.
Here, these things were not disputed.
Yes, my lord.
There, she did not apply. She was
Yes,
illiterate, so it was directed to be.
But even in,
That is always there.
Yes, my lord.
But here you are not showing that he was in service till his demise or something like that. That is no proof of that is there.
My lord,
We also have to curtail Mr. Chakraborty. I'm being very candid.
Lord.
I'm not meaning anything to your client.
Lord,
We also have to be candid that chance litigants do not take the opportunity of the mercy of court.
Lordship.
We have to be candid on that also.
Lordship.
We have to be balanced on that because this is state exchequer.
Lordship.
Taxpayers' money will be paid.
Lordship.
Now, if you are entitled, definitely you will get it.
Lordship.
But there has to be some basis.
Lordship.
Anything to show that he was in service after 1965.
Well, 1965, he was deputed in the, my lord, the Asansol LM hospital. That is also a government hospital. Here, my lord, they are making all communication with the Katua hospital. My lord, it is up to the state authority to communicate, my lord, the LM hospital is a branch of, my lord, the state authority. My lord, that document is not lying with us. We are, my lord, our age was, my lord, we are minor at that juncture, my lord. Kindly visualize a situation 40 years back. Now I am 52, 53 years old, my lord. That being the situation, my lord. They have admitted, I have been deputed in the LM hospital.
Your mother was alive then?
Alive then. Meanwhile died. Meanwhile died, my
I'll
lord.
close arguments on this. I'll see the materials and pass some.
Lords.
Despite the matter having appeared on several occasions, none appears at the time of call on behalf of the respondent authorities, full stop. Hence, the matter is taken up for hearing ex parte, full stop. Heard learned counsel for the petitioner at length and perused the averments made in the writ petition, the annexures thereto, as well as the report filed by the respondent authorities and the affidavit in opposition thereto filed by the petitioner, which is also kept on record. Full stop. Next para. Upon such hearing, the arguments are concluded. Full stop. The matter is reserved for judgment.
Only, my lord, paragraph 6 may kindly be looked into.
6 of the writ petition?
No, my lord, this judgment, my lord, which I have referred to. Though, my lord, the factual aspect is different, my lord, yet, my lord, the helpless person, my lord, what is to be done, my lord, some indications are there, my lord. Deeply.
রিপোর্টের অপোজিশন বলেছি এফিডেভিট ইন অপোজিশন যেটা বললাম এফিডেভিট ইন রেসপন্স করে দিন একই টু দ্য রিপোর্ট তো বলেছি এফিডেভিট ইন অপোজিশন টু দ্য রিপোর্ট বলেছি তার বদলে হবে এফিডেভিট ইন রেসপন্স টু দ্য রিপোর্ট লিখলেও কিছু না একই থ্যাংক ইউ What are you trying to say? You are muted.
Yes, my lord, now I'm unmuted. In the last matter, item number 14, my lord has set aside May bill. It will be May and June both. May and June, yes. June, my lord has yes. May and June both.
Mr. Dasgupta, June was not placed by Mr. Mujumdar, nor did I see.
My lord, it is May and June both because my lord, I had not paid in May, so June bills raised with disconnection notice again. My lord can see me at page 325. May and June, identical bills. It's May and June both. I can see the records and annexure P10.
Mr. Dasgupta, it will appear as to be mentioned tomorrow, day after tomorrow.
Very well.
That will be behind the back of the other side. To be mentioned,
or Millard, I can request Mr. Rai to come Millard at 2 p.m. Millard. I can request Mr. Rai to very good.
Yes, you can do that.
Very.
Move on.
That we could only serve the state government by the GP.
Dispensation.
Kindly take page 39 first.
You have served a copy of the writ petition previously?
No.
No, could not touch.
Page 39, the urgency, my lord.
Yes.
Lordship appearing on behalf of state respondents.
Yes. This notice, my lord, the petitioners received on 11th August 2023. It says, my lord, it will be demolished on 13th, my lord, at 3 p.m. Prior to this, my lord, there was no notice, no proceedings. Now they rely on an order passed by this honorable court, which has been annexed, my lord, the next page. Somebody moved a writ application before this court without making us party. It's a large number of street vendors are there. This is at Raidigi. Now this order was passed, my lord. Kindly take the respondent number 5. I don't know, probably the executive engineer will visit the local and prepare a site plan as to the area of the government property and the persons in occupation therewith, if there be any. If he finds that there is any persons occupying, he will take expeditious steps for the purpose of removal of the same. If the property is a road, he will take steps under the provisions of the West Bengal State Highways Act. It is expected.
This is initiation of the proceeding, not demolition.
It is a demolition notice.
But this is the order which they are relying on?
Yes.
Oh, no.
No proceeding has been initiated. This is the order, my lord, he had been relied on. This is dated, my lord.
No, but this is different.
This is in contempt, my lord, they are relied on the 4th August 2023. And the order dated 20th March 2019. The second line.
What is the order in contempt? You have to see that also.
This is the parent order, my lord, for which
Not the parent order. I want to see that order also, 4th of August. That might have been more stringent.
It has not been annexed.
Without that, I cannot pass any order, Mr. Bandyopadhyay. Just find it out from your website. Yes.
my lord, I have got
Yes, from the phone you can read out.
Contents order has not been annexed.
My lord, an order dated March 20, 2009 was passed in the writ petition directing the appropriate steps for removal of illegal occupants from land. Advocate appearing for the alleged contemnor submits that on local inquiry it was found that the land did not belong to the Public Works Department. However, he is unable to say whether the land in question belongs to the state or not. In such circumstances, District Magistrate South Chobbish Pargana will be personally present in court on August 11, 2023. He will apprise the court as to whether the land in question is a public land or not. In the event it is a public land, then the person responsible with regard to the same, whether there are any illegal encroachment in the land are concerned, and take steps to removal of such encroachment. There's nothing, my lord, you also can go through it, my lord.
Need not. You have read out. You have read out the entire thing.
Yes, my lord,
No,
entire
it's
order. So now there must be some proceedings. Now one provision, my lord, you also kindly take, my lord, this was never.
Proceedings need not be. I'll stay this. Stay operation. I'll grant stay of operation. In fact, I'll set aside the notice. But if you want to use an affidavit, I mean, what is your defense? You had to initiate proceedings under law.
And in fact, Street Vendors Protection
Yes.
Act is a central act. It says it cannot be. There must be 30 days notice even for relocations. And they are for 30 years. Trade licenses, their electricity bills are there.
The name of the act?
Street Vendors Protection.
West Bengal.
No, this is central act. Special act. Overriding
So here,
effect.
West Bengal Highways Act probably is applicable.
Overriding effect is there, my lord. There is an overriding effect. And being a lateral law, the last judgment of the Supreme Court also, my lord, says, my lord, the lateral law will prevail. And it provides for survey, grant of certificates, and section 18, kindly see, even for relocations and, my lord, removal, 30 days notice is to be given.
Should be.
And there is no attempt at the instance, but they are for 30 years and 40 years. Now,
Yes.
can we stay this, my lord? Otherwise, my lord, let them come.
Come and do what?
Then again says that no instructions are
Without any instruction, just now leave matter and
Let them
just.
file an appeal against this, let them explain before the appellate court.
Yes.
Which is your page number, the impugned order?
39.
The present writ petition is being moved with short notice on the state, comma, in view of the extreme urgency involved, full stop, by the impugned notice dated August 11, 2023, comma, the alleged unauthorized occupiers encroaching upon the subject landed area have been directed to vacate the land and remove their belongings before 3 p.m. on August 13, 2023. Full stop, August 13, 2023, comma, that is yesterday. Full stop, it is indicated in the said order that a proceeding to demolish all unauthorized structures built on the said land will be initiated on August 13, 2023, 3 p.m. onwards. It has not yet started.
No, not because we made a representation from the lawyers. Issued a notice
Learned
that
counsel
this
for the
petition is-
petitioner contends that the said notice was issued palpably dehorates the law, full stop. In the said demolition notice, comma, the assistant engineer, comma, Joyanagar subdivision of the PWD has cited an order dated August 4, 2023, passed in CPAN 278 of 2020, and an order dated March 20, 2019, passed in WPA number 5652 of 2019. Full stop, next para. It is contended that neither of the said orders contain anything to prompt the authorities to start a demolition drive. Full stop, next para. Heard learned counsel appearing for the state as well as the petitioner. Full stop, next para. Learned counsel for the petitioner is justified in arguing that nothing in the order stated March 20, 2019 and or August 4, 2023 indicate the demolition of any structure to be carried out on the property in question. Full stop, next para. A bare perusal of the order dated March 20, 2019, passed in the writ petition in question, indicates that the learned single judge directed that the respondent number 5 therein would visit the locale and prepare a site plan as to the area of the government property and the persons in occupation therewith, comma, if there be any. Full stop. If he finds that there is any person occupying government property, comma, he will take expeditious steps for the purpose of removal of the same, full stop. If the property is a road, comma, he will take steps under the provisions of the West Bengal State Highways Act, comma, 1964. Full stop. It was further expressed that the proceedings were expected to be initiated within a fortnight from the said date. Full stop, next para. It is palpable.
State Highways Act Section 10 has also not been complied with.
It is palpable from the said order that, comma, even in terms of the order, comma, in the event any encroachment of government property was found out, comma, the procedure to be adopted by the respondent authorities was to initiate proceedings under the West Bengal State Highways Act, comma, 1964. Full stop. It is further indicated in the said order that the proceedings were to be initiated, double inverted initiated, within a fortnight from the said date. Full stop. The petitioner has also relied on the provisions of the street vendors within bracket protection of livelihood and regulation of street vending bracket closed act, comma, 2014, comma, which also contemplates prior notice before taking any action under the same, and also envisages several safeguards against the squatters, comma, if they are street vendors within the contemplation of the act. Full stop, next para. In fact, comma, none of the provisions of any law existing in India provide for eviction of a person in occupation of a property without following due process of law. Full stop. A cardinal principle of natural justice as well as the rule of law is that a person, comma, before being driven away from a property, comma, has to be heard and given an opportunity of hearing. Full stop, next para. in the present case, comma, the impugned notice being having not complied with any such provision or being preceded with any such action, comma, cannot be sustained in the eye of law. Full stop. Next para. Although the order dated August 4, 2023, passed in CPAN 278 of 2020, has not been annexed physically to the writ petition, comma, at the juncture of hearing, comma, with the leave of court, comma, learned counsel for the petitioner reads out the same from the official server of this court. Full stop. Next para. Even a perusal of the same indicates nothing to show that any direction was passed on any authority to demolish all structures, comma, authorized or unauthorized, comma, standing on the disputed property. Full stop. Next para. In view of the above discussions, comma, this court is of the opinion that inviting further affidavits would only stall the steps, comma, if required to be taken for unauthorized construction by the respondent authorities and not serve any useful purpose for either of the parties. Full stop. Since the relevant documents have been annexed to the writ petition, comma, nothing remains further to be disclosed by way of affidavit. Full stop. Next para. The sole premise of the impugned notice was the two orders passed in CPAN 278 of 2020 and WPA 5652 of 2019, comma, which have been discussed profusely in the above discussions. Full stop. As such, comma, affidavits are not being directed. Full stop. It is deemed that nothing in the writ petition is admitted by the respondents. Full stop. Next para. In the light of the above observations, comma, WPA 19701 of 2023 is allowed on contest, comma, thereby setting aside the impugned notice dated August 11, 2023. Full stop. Nothing, comma, however, comma, in the present order shall preclude the respondent authorities to initiate proceedings in accordance with law for eviction of any unauthorized occupier of the premises in question, comma, if property, property, comma, if any, comma, following due process of law. No rest to cause satisfied.
Only memo number may be indicated. 11th August contains a
আচ্ছা,
memo
যেটা
number.
সেটা সেট করলাম,
Memo
allowed,
number 790.
thereby setting aside the impugned notice dated August 11, 2023, bearing memo number 791. Thank you.
Much obliged, Lordship.
Thank you. Yes, Mr. Dasgupta. Yes.
Malad, Mr. Mukherjee is there. Malad, I request him to
Mukherjee,
come.
July also. July.
June. May and June.
আচ্ছা, ওটা আইটেম নাম্বার কত ছিল?
14.
14.
ভেরি ওয়েল। আইটেম নাম্বার 14 কে নিয়েছে অর্ডারটা? মাধববাবুকে বলে দিও যে ওটা মে আর জুনের অর্ডার দুটোই সেটা সেট হয়েছে।
Bills of May and June.
Very well. Thank you. Yes. It will be done.
Obliged.
Grateful, man.
Item 16.
Petitioner?
No.
How can we be appear for the petitioner?
No, I can. I have that latitude, my lord.
Against the state.
When the union or any of the public undertakings are not parties, I can appear. And I am availing that latitude also.
That's very well. Yes.
This is a different joy appearing for the petitioner, always. My lord, at the outset, I would indicate.
You're for the union?
At the outset, I had indicated, my lord, I am for the Union of India and also, my lord, the SFIO, my lord. This arises out of, my lord, lookout circular, my lord. My lord, I had requested.
That I should be given the joy to appear for the petitioner.
I had requested Mr. Chaudhary, my lord, that I will be praying for an accommodation today, but he said that no, he will be moving the matter today. This was mentioned and this was upgraded, my lord. But there, it is an uphill task for me because, my lord, what Mr. Chaudhary will be relying upon is, my lord's judgment, my lord, insofar as, my lord,
that it will be an uphill task.
It will be, my lord, but it will be a joy, my lord, to distinguish that, my lord. And, my lord, I will be, my lord, if Mr. Chaudhary wants to commence and conclude his arguments, my lord, I will leave that to your lordship, my lord. I will
Mr.
just,
Chaudhary won't commit the mistake of only relying on my judgment in my court.
no, there are other
There
judgments
must be some
also.
other things also.
There are other judgments
He
also.
won't make that mistake. He's sufficiently
There are other
senior and
judgments
mature
also,
for
my
that.
lord, which has been delivered
Yes.
following my lord's judgment, my lord. So my lord's judgment is as on date, my lord, the sheet anchor, because my lord relied on Karthi Chidambaram's case, my lord.
Very
So that is what I intend to distinguish. So that, my lord, I would, my lord, seek, my lord, that
My
Mr.
learned friend has deprived me of the entire joy. I haven't yet
Entire
moved.
joy,
He has
yes, yes,
anticipated what I'll rely.
Now we can start directly probably from Karthi Chidambaram and
My lord,
the,
I'll tell you,
and
Lord,
the issuance of the, and the communication of the bank.
I was, my lord, humbly beseeching, my lord, if it can be taken up, my lord, on next Monday, my lord. I want to come back prepared, my lord.
There's a chance of change of determination.
No, my lord, kindly make it part-head also, my lord. I sincerely, my lord, want to argue this, my lord.
My lord,
Because,
may
my lord,
I-
I lament the fact, my lord, that my lord, had I
Mr.
been
Bhattacharya, why you do ask for time? These are, I mean,
Like,
usual
it's a-
matters and usual orders.
It's a pure question of law. There is on facts, my learned friend will
You
have.
must be regularly dealing with this matter.
my lord, in so far as this particular case is concerned, my lord, but this was heard on numerous occasions, my lord, by the Honorable Justice Moushumi Bhattacharya. I had also relied upon a judgment delivered by the Honorable High Court of Delhi, my lord.
Justice Bhattacharya took a favorable view.
No, not on that, my lord. It was heard
But
time
I
and
will
again.
tell your lordship,
I need to come back, my lord, with also, my lord, the instructions as
It
regards.
is heard at on several occasions, Mr.
No, my lord,
Bhattacharya.
as regards the status, no affidavits were also exchanged. The status of, my lord, the investigation as conducted by the SFIO. There are two
So
lookout.
that cannot, I mean, save the lookout circular issued prior to that. Then that will be at best a reason for even if I set aside
No,
the
my lord, the lookout circular.
Yes.
Now that has been issued.
Post facto event cannot justify a
No.
previous
The
lookout circular.
lookout circular has been issued at the behest of, my lord, the SFIO.
Yes.
I am representing, as well as, my lord, the bank. Because there is, my lord, the serious fraud investigating office, my lord.
At the juncture when you issued the LOC, now if at that point of time there was any justification, Mr. Bhattacharya, it survives.
Yes.
Otherwise, it does not.
There was.
That will not preclude from you from issuing a
No,
fresh
no,
LOC.
there was, my lord.
But
There
that
was.
is post facto event cannot be a relevant
Not
consideration.
post facto, my lord. It is, my lord, in connection with that investigation only, my lord. How much it has progressed, my lord.
Not necessarily. Let us see. Yes.
my lord, as lordship has.
Yes.
My lord, I'm for respondent number 2, my lord. I'm led by Mr. Abhishek Guho, my lord. Let the petitioner start their argument. We shall respond on the next. Guho. We shall respond on the next day, my lord.
Why next day? No.
My lord, kindly.
My lord, kindly takes it up.
My lord, kindly.
My lord, takes it up as the first item.
Lord, may I complete my arguments if at all?
I think that will be better. Yes.
Let me complete my argument. My learned
Yes, my
friend,
lord.
both of
We
my
shall
learned
respond
friends,
on the next day, my lord.
because my lord,
Mr. Bhattacharya will respond today. You will respond on the next day. Yes.
because I'll indicate, my lord, ad interim order was refused because, my lord, Mr. Bhattacharya came and said this is of a two arguments were advanced. Number one, that all the earlier judgments have considered the circular of 2010 and 2018 and have not considered a fresh circular of 2021, which has more draconian provisions and something completely different. In fact, if I recall, he said it's a secret document, it cannot be given. It has been handed in sealed envelope. Then, my lord, pursuant to orders of court, this was given to us. And, my lord, I will show, and now another judgment has come in, that this 2021 circular is nothing but a consolidation of all the earlier three circulars. There is not a single new provision subject to correction by my learned friend. The only variance in the provision is earlier a lookout circular was valid for 1 year. Now that restriction has gone. Whoever is the originating, my lord, agency, they have the responsibility that if any reason they want that to be removed, they have to make an application and it would be removed. Earlier, my lord, 1 year was the validity, you had to reapply and it would be again, my lord, done. Other than this, my lord, and I shall show from the 20.
Now they can have it withdrawn earlier.
They have the option. Every quarterly, my lord,
So that has been added by the 2021.
2021, it's an addition. And that has been judicially noticed, my lord, another coordinate.
That's less draconian then.
No, my lord. But, my lord, it has never been done. This is a new feature. Because, my lord, I am suffering this circular for the last 3 years. And the second contention on which, my lord, I was refused an ad interim order because subject to affidavit, my lord, this SFIO or Special Fraud Investigation Office, my lord, this was said that this is a special fraud and it is something very special. So therefore, it has other considerations. Now, my lord, I have got, my lord, SFIO is nothing, my lord. This SFIO is a creature of the Companies Act. My lord, lordship will know that, my lord, under the 1956 Companies Act, my lord, there were some offences which had a criminal, my lord, implication, in the sense that, my lord, it was, my lord, they were known as Schedule 9 offences. It could be tried by the magistrate. And some, my lord, had civil consequences coupled with criminal ones. Now, my lord, in the 2013 Companies Act, section 212, my lord, it has envisaged that, my lord, it has envisaged a special investigating agency called the SFIO, that in the event, my lord, the ingredients are there, my lord, the tribunal, which is a civil body, will, my lord, depute SFIO to conduct the investigation, and a special court is there, my lord, and the motion of criminal proceedings, my lord, sets in. It's just like any other investigating agency. But so far as the guidelines are concerned, and I'll straight away come to the 2021 guidelines, which is, my lord, a summarized version of the parent 2010 guideline, and, my lord, the subsequent two, my lord, amendments which were made to it.
So we get all the provisions there. It's easier.
All the provisions there.
Right.
My lord, lordship would recall, my
Yes.
lord, the parent guideline, my lord, there was a pro forma in which, my lord, the originating authority had to apply. And, my lord, one of the requirement was there has to be pending criminal proceedings, and, my lord, other, my lord, the pro forma indicated. Because in none of these cases, my lord, we are privy to the original lookout circular. And, my lord, the affidavit of the bank also does not disclose anything else other than the fact that my client is a defaulter.
Right.
No additional ingredient is available.
Yes.
And, my lord, the additional fact that SFIO is investigating the matter. Now, my lord, even from the affidavit of SFIO, I will show, and from in my petition I have disclosed, my lord, after SFIO an order is passed, because, my lord, now, my lord, throughout India, more or less all the high courts have taken an universal view, my lord, save and except one or two exceptions, which is often relied by the authority, that, my lord, the fundamental right, my lord, of travel and movement, my lord, cannot be curtailed with such draconian restrictions until and unless you comply with the guidelines. Now, my lord,
in fact, previously, the defaulters who did not want to leave the country, now after coming into force of this, now they're leaving the country more.
But
they're going on tours even.
In fact, my lord, all these cases, my lord, we used to encounter, my lord, one common refrain is, my lord, two names used to come up, my lord, that
one of the names, don't take the risk.
Yes. Because
you may be debarred from
controversial.
appearing in court. Yes.
So, while two names were taken, and say, lordships know that these two names were there, so these were there.
Yes.
Now, my lord, we are strictly on the interpretation. And, my lord, here also, though, my lord, another agency is saying...
Give me half a minute. Mr. Bhattacharya, is it really necessary to adjourn it for that? I mean, you are wanting to appraise me on, or appraise yourself on the stage of the investigation. How is that relevant even?
Well, that will be relevant because, my lord, I have filed my affidavit, my lord. In the affidavit, we have indicated, my lord, the role of these two
Affidavits
petitioners.
have been exchanged.
Yes.
This is the hearing stage.
Yes,
Now
hearing
you are
stage.
only on this current stage of the investigation that is not even jarment for an LOC issue.
Jarment, my lord, in view of, my lord, what
Yes.
I had cited, my lord, the judgment delivered by the Honorable High Court of Delhi on the 15th of February 2023. Now, there, my lord, the Honorable Court, my lord, chose, my lord, not to exercise extraordinary jurisdiction under Article 226, considering, my lord, the involvement of the petitioners therein. Here also, my lord, the case is something very similar.
I'll have to distinguish that, Mr. Bhattacharya, with utmost respect.
No.
That
Because
has already
that
been
cannot be
done.
charged for an LOC.
Duty is to, my lord, rely on
Definitely, yes.
judgments, my
But
lord.
I just wanted to take the contours of your submission, sir. Very well, I'll hear you on that also. So let us hear it out. Yes.
Now, my lord, petitioner number 1 is the son of petitioner number 2. And, my lord, both of them, my lord, are directors in the company called Kohinoor Power. I mean, in para 10, we have stated, my lord, first time we come to know of the LOC, when, my lord, the petitioner number 1 was trying to, my lord, go to, for his business purpose, he was going international to Nepal. He was told that there is a LOC both against your name and in the name of the father. Sorry, petitioner number 2 was going to Nepal, and he was told that you cannot leave the country without the permission of the authorities. And, my lord, we come up, my lord, before your lordship. Now, my lord, kindly straight away come to, my lord, two things are there. I must be very candid, my lord. There is a willful defaulter order against the petitioners. And, my lord, number 2, my lord, this SFIO investigation order is there. Now, my lord, so far as SFIO is concerned, first kindly comes to SFIO chithi dutar pata bol. My lord, kindly takes page 63. I'm sorry, page 34.
You would be arguing that SFI investigation is not a pending criminal proceeding.
No, my lord, I will show, my lord, what SFIO did. Right from 2020, they asked us to furnish certain documents.
Right.
That we have taken over the investigation, and I'll show, my lord, I'll show from the Companies Act, my lord, the entire structure of SFIO. There is nothing special other than the fact that the name is a special investigation. It is just any other investigation agency like the CBI or the ED or anyone else.
A pending criminal investigation is not a sufficient ground to issue LOC.
No. Well, there has to be an offense. I'll show lordship the
Language, but I'll look into it.
And my lord, in the last 3 years, other than asking documents from me, which I have duly furnished, nothing has been done. There is not even an FIR from the SFIO against me, leave alone charge sheet. I'll show your lordship the.
So you want to look me to look into page 34?
34, yes.
Yes, 34.
My lord, kindly see, my lord, page 34. This is my response. This is in 2020. I am in receipt of-
Please ask your junior to just take information whether any FIR has been lodged in the meantime. Only that.
But so far as SFIO is concerned, my lord, the provisions do not, my lord, permit lodging of FIR. They file the report after investigation. The investigation is underway, my lord. Our affidavit has been filed.
Well, I'll place their affidavit.
Yes, then, yes.
But kindly takes this. I am in receipt of the letter of 18. From the letter, it appears that central government has ordered an investigation by Serious Fraud Investigation Office SFIO into the affairs of the company Kohinoor Power under section 212(1). I'll come to this act, my lord, provision. Contents of the letter of September 18 suggest that an investigation by SFIO is initiated by the central government in the month of June 2020 under section 212C of the Companies Act in respect of KPP.
But I will, my lord, interrupt, my lord. I apologize, my lord. I have just received instructions, my lord. I am just receiving instructions, my lord, that one of the other directors, my lord, Mr. Vivek Duggar, now he is, my lord, he's basically hiding in Nepal, my lord, and the SFIO, my lord, is unable to serve any notice of summon upon them.
He is not a petitioner, my lord.
Another director of the company, my lord. So the fate will be something very identical, my lord.
Let me complete my argument, my lord. This sort of prejudicial submission should not be made.
Nepal is not prejudicial. Nepal is too close.
In fact,
one can walk into Nepal and bring that.
I was leaving for Nepal when I was, my lord, stopped. My lord, Nepal, my lord, passport is of course.
Your lack of aspiration is the reason for issuance of LOC, himself. Yes.
Oh, my lord,
anyway,
interim order, my lord, I had business engagements in China. I was unable to get an ad interim order. I could not go. But be that as it may, my lord. Now, my lord, everything, now, my lord, all the bank has filed the affidavit, the SFIO has filed the affidavit. Now, I would like to place on record the following facts for your kind consideration. Then, my lord, the history has been given. Why, my lord, the business failed. Then, my lord, kindly come to page 35.
Yes.
Second para. However, resolution of the company did not happen and liquidation.
Yes, please take your seat. Have you got a seat behind you? Yes. Yes.
However,
thank you. Yes.
However, resolution of the company did not happen. This is after the insolvency proceedings. Resolution failed and liquidation order under 33 of IBC was passed by the adjudicating authority in respect of KPPL. Copy of the order is attached. Pursuant thereto, KPPL is presently in liquidation. Liquidator has been appointed. This is to note, though I was, and this will take care of my learned friend submission also, though I was a director in KPPL along with Vivek Duggar post initiation of CIRP in August 2018 and post liquidation order till date, for more than last 2 years, we are not involved in the affairs of KPPL. During CIRP, the resolution professional was in charge, so and so. In the circumstances, I will be submitting the documents available with us as soon as possible. I further request you to approach the liquidator of KPPL also, who will be in a position to provide you the documents and information which are in his possession. I assure you that from my side, all possible assistance will be given to you in making investigation, and we will cooperate with the information and document. I am sorry for the delay, so and my lord, the earlier, my lord, the letter, my lord, this is a trailing mail. At the bottom, lordship will find, my lord, this was the mail that we had received, that central government had set up so and so, and this is the response that we give. Now, my lord, we'll kindly come to the detailed response at page 37. They had asked for certain documents, my lord. Lordship will find 15th October 2020. My lord, from item 1, 2, 3, 4, all these, whatever we had, Lordship will find creation of charge, copies of, my lord, up to right up to, my lord, this goes on till 40, page 40. And my lord, kindly see the last paragraph. We hope you find the above in line with your requirement. We also assure you that we will submit the balance available document at the earliest, for which we are in process, and so on. We will cooperate with you, fulfilling all your requirements. And then, my lord, in November, kindly come to page 43. The balance documents are also given. November, page 43, 30th November. This is in reference to so and so. We could collect, and the board of directors also suspended, had provided information we could collect. Because, my lord, the IBC proceedings from 2018. So, my lord, the board was suspended. So, whatever we had, we first gave it, and then whatever we could collect, lordship will find reports and returns filed with various tax departments, all details. Then, my lord, this goes on.
Liquidation proceeding is still on.
My lord,
the liquidation is still on.
Liquidator is good. My lord, the resolution process failed. My lord, there was no resolution. So liquidation proceedings going.
Very.
And then, my lord, page 49, 8th March 2021. And we are continuously, my lord, whatever documents we could gather, I am just showing my bona fide. 49 to 51, further documents we give them. And, my lord, page 52, my lord, one of the petitioners, Prashant Botra, my lord, he also writes, giving his own personal, how much equity shares he has till when he was a director. He was a director till 2016. So he has said that whatever records I have up to that I have given, and so on. So this is what has been given. And then kindly come to page 59. The company in October. And these are all being given, my lord. Only one letter we received. All are being given, whatever we could collect. Referring to the above and in continuation, please find further documents. Joint lenders meeting, minutes of the meeting. Then, my lord, whatever details they had asked for, we had given the entire thing. And kindly come to the last portion of it. Page 62. We hope you will find the line with your requirement. We also assure you we will submit the balance. So, my lord, 5 letters we have given from 20 to 21, giving all documents which we have. Then, my lord, this is the order of the Company Law Board, page 63, Company Law Tribunal, I'm sorry. My lord, since one of the petitioners were also a personal guarantor, my lord, proceedings are there. And there is no allegation that I have not attended any of the proceedings.
There are injunctions against you.
My lord.
There are injunctions against you.
Yes, yes. My lord, on
the IBC.
kindly see 63, my lord,
Yes.
para 3. Honorable High Court at Calcutta in matter of Arun Kumar so-and-so challenging the virus has stayed further proceedings. My lord, this order, which has been referred to, is at page 67. We have given it for completion. At page 67 is the order. My lord, this is, my lord, page 67 is the order passed in Arun Kumar Jagatramka, which has been referred to there. At page 68 is the operative part of the order, petitioner restraint. And that was followed by the Company Law Tribunal. My lord, kindly comes to Page 63, para 4, referring to an order of Honorable Supreme Court of India. This is also annexed. I'll come to it shortly. Said order of Calcutta High Court has restrained the personal guarantor from transferring or alienating or disposing of any of his assets until matter is heard out. This stipulation, which is reiterated by the Supreme Court in another order of so and so, would apply in the matter as well. We adjourn.
Up to page 70, I've more or less seen Mr. Chaudhary the relevant
it is
thing.
safe.
That is Supreme Court I've seen.
The reason why
High Court, Supreme Court, every authority has given in.
why I am saying this, my lord, number one,
Protected.
SFIO, the very first letter, I have been vigilant on my own in furnishing whatever documents I could have. And my lord, from 2020 to 2023, my lord, there is not a single letter that I have not attended any proceedings or I have not gone to, no summons has been issued to me, or that there is any cognizable offense. 3 years are there. Because, my lord, the requirement of all these circulars of LOC is that there has to be a cognizable offense, and my reading of it is for, my lord, absconders who are running out. I have gone to all authorities and
Yes.
in fact, my lord, I am told even in this year, July and August, my lord, we were called by the SFIO and we have gone there. My lord, page 71, after, my lord, one of the petitioner was restrained in the airport, page 71, my lord, I write to all the banks and to my lord SFIO also that please recall the request lookout circular. And my lord, I write, my lord, page 72, I also write, my lord, on behalf of the other petitioner also. But I write both on behalf of P1 is Prashant and P2 is Vijay. And my lord, after this happened, my lord, what happened in the airport, my lord, kindly see the third last paragraph. Upon repeated requests for such unreasonable and unnecessary harassment in not allowing me to board the flight to Nepal, it was informed by the senior officer, immigration officer at the airport, that based on information provided by the addressee number 1 or 5, request for lookout circular has been issued, wherein my name was included. Upon demanding to see a copy of such request, same was refused by the senior officer on the ground. Such document was confidential and could not be disclosed or made over. Therefore, the apprehension is justified. We have to travel internationally for business purpose and not being allowed to travel within insurance. So, this was the representation made. In fact, Lordship will find, my lord, we did not know that if any other bank has added to it or not. So we have made, my lord, 3 or 4 banks, whoever were our creditors, my lord, parties in the writ petition. Of course, my lord, now the position is clear. Only SFIO and, my lord, Bank of Baroda. My lord, these are the 2 banks which have, my lord, which fall in the category of originators or pursuant to whose request, my lord, the immigration authorities have issued the lookout circular. And, my lord, Bank of Baroda's letter, Lordship will find at page 82.
Yes, confidential.
Yes. When I ask for that, they say since lookout circular.
So there's a probably circular somewhere. The government circular is there. A government circular is indicating something that it's, I mean, not pertaining directly to the lookout.
Kindly, my lord, Lordship.
Something is there, was cited.
But I had indicated that before the Honorable Justice Moushumi Bhattacharya. So her ladyship was of the view that the guidelines are not secret documents, but that is a secret document. And I made over the guidelines, my lord, upon the.
No, my lord, submission.
Nothing is a secret document. I mean, LOC wise.
My lord, this guideline.
No, it was there. It was
submitted. This is a secret document.
No, that
because the document at the top, my lord, I shall show. Now it is, my lord, on record. My lord, kindly have a look. This is what, my lord, after orders they have submitted.
No, Justice Bhattacharya open up the guidelines. I'll open up the LOC itself.
No, her ladyship was of the view that LOC is a secret document. This is not a secret.
So that view also I'll change. So LOC is not also not. Why should LOC be a secret document, Mr. Bhattacharya?
No, but there was a
The
provision.
secrets of
that
the country are revealed to the public at large by way of an LOC. I mean, you issue a lookout circular against a particular person, alleging that this person has done something. Everybody should know it rather. Why should it be confidential? It should be made known to everybody.
No, but there was another document that I had indicated.
It is a petitioner who should come up and say it, let it be confidential so that I am not maligned. And why should the government say it's a confidential document? The source of information is revealed in an LOC.
Well, at page 85, my lord, this is the pro forma, my lord.
Yes, something was there. I mean,
this is the 2021 circular, which was handed over by Mr. Bhattacharya. Lordship will find in the second page, right at the top, it is second, third, secret, fourth, all secret written. Up to page from second page right up to, my lord, the last page. That is why, my lord, he submitted, this is a confidential document. This is the endorsement.
The he is not at fault actually. The government is.
I am not saying he is at fault, my lord. It's not nothing.
If the
personal
government
against-
writes secret.
It was because of this reason. He said that this is written secret here. I can't just give it there. So it was handed on sealed cover. Then, my lord, it fell from the court that if you are relying on this in all.
Is the relevant portion of this, Mr. Chaudhary, which says that banks should not disclose? Something is there.
Nothing, my lord. I shall show that, my lord. My lord,
Something-
firstly, kindly see, my lord, firstly, kindly see, my lord, in the subject,
Yes.
consolidated guideline for issuance of lookout circular in respect of Indian citizens and foreigners. My lord, subject, right at the top. Now, my lord, in the first paragraph, the last two lines, these guidelines were subsequently modified by the ministry by 5th December 2017, 18 and 18. And the parent guideline, Lordship will find, has been referred to 2010, 27th October 2010 at the top. Then, my lord, Honorable High Court's, the Delhi High Court's order has been taken into account. Then, my lord, other judgments have been taken. Now, kindly come to page 4. Right at the bottom. Page 4, my lord. Kindly see from para 5, if I may read. In pursuance of order dated 26 July, Honorable High Court at Delhi, this ministry issued detailed consolidated guidelines with a ministry's so-and-so dated 27th October 2010, which were modified by, my lord, the subsequent 3 modifications are there. Now, my lord, clause 6. The existing guideline with regard to issuance of lookout circular in respect of Indian citizens and foreigners have been reviewed by this ministry after due deliberation in consultation with various stakeholders in supersession of all these guidelines issued. Vide these ministries' letters referred to in para 1 above. It has been decided with the approval of the competent authority that the following consolidated guidelines shall be followed henceforth all concerned. So, my lord, it is just consolidation of all the 3. Now, kindly come to B. This is what was there in the 2010 guideline. Request for opening LOC must invariably be issued with the approval of an originating agency that shall be an officer not below the rank of, my lord, these were mentioned. My lord, we are concerned here with, my lord, serial numbers 14 and 15 on the next page.
Yes.
Officer of Serious Fraud Investigation Office, Ministry of Corporate Affairs, not below the rank of additional director, and, my lord, chairman or managing director or CEO of public sector banks. My lord, Lordship would recall in the earlier guideline, bank and, my lord, its SFIO, they were all subsequently, my lord, amended and incorporated. Now, in one go, we have all the. So, we are concerned with 14 and 15. Then, my lord, kindly turns over. The other clause with which we are concerned is clause H, I, and J. And this is, my lord, identical. It's verbatim, my lord, reproduction of 2010, except in J, my lord, a slight modification is there. My lord, H is recourse to LOC is to be taken in cognizable offences under IPC or other penal laws. My lord, very clear. Detail in column 4 of the enclosed pro forma regarding reason for opening LC must invariably be provided, without which subject of LOC will not be arrested or detained. But this pro forma is at page 85 and 86 of my writ petition. In cases where there is no cognizable offense under IPC and other penal law, the LOC subject cannot be detained, arrested, or prevented from leaving the country. So, my lord, it is clear. If you don't have a cognizable offense, you cannot be prevented from leaving the country. The originating agency can only request that they be informed about the arrival and departure of the subject in such cases. Then, my lord, J. The LOC opened shall remain in force until and unless a deletion request is received by BOI. My lord, BOI is Bureau of Immigration, from the originator itself. My lord, this is the new variance. Earlier, my lord, all LOCs were valid up to 1 year. It would automatically lapse. This is, my lord, the new variance which has come in the 21 consolidation. No LOC shall be deleted automatically. This is the only variance. Originating agency must keep reviewing the LOC opened at its behest on quarterly and annual basis and submit proposals to delete the LOC, if any, immediately after such a review. The BOI should contact the LOC originator through normal channel as well and so and so. And then, my lord, kindly come to the clause L. This is the clause, my lord, which my lords have considered in the previous judgments, which was an inroad made by virtue of amendment. Now it's identical. In exceptional cases, LOCs can be issued even in such cases as may not be covered by the guidelines.
You need not read the entire thing. Economic interest of India and larger public interest.
Same, same. And it is identical.
Yes,
The
yes.
reason why I am saying this is
These are
because
the only two grounds which can be taken by banks.
economic interest. Here also it is economic
And
interest.
larger public
Manan
interest.
was possibly asking for referring to this document. Manan was
Yes,
saying that there is some document.
Anyway, let me hear Mr. Chaudhary, then I'll. Yes.
So, my lord, lordship can take it from me, my lord. This is the identical clause which fell for consideration before your lordships, my lord, in the other matters also.
Has any of you produced those requests for LOC in this case?
Nothing. In the affidavit, my lord, no disclosure has been made. I'll show, my lord.
Not even the SFIO?
Nothing.
Probably on ground of secrecy.
My lord, in fact, my lord, the SFIO's affidavit, my lord, the only thing is investigation is going on and it may hamper the investigation. That's all. There is nothing in the affidavit. And my lord, kindly, my lord, when lordship is looking at this circular, kindly see the pro forma starting at page 85. Kindly see, my lord, page 86. Because, my lord, when they have given it, these pro forma, we presume, were filed. And kindly see clause 11A and 11B. And this is in line with the circular. Criminal case specify full details. FIR number, date, section of law, police station, district, country. Wanted by law, court or judicial authority. Name of court, order by which subject is wanted. Name of any other agency authorizing so and so. These have to be given. Now, my lord, first kindly see, this is the factual background under which we come up before the court. Now, kindly first see, my lord, the affidavit in opposition of R6, which
I'll
is
keep this, Mr.
SFI.
Can I keep this?
Manan, can I just make a copy and return it?
But return this to me because I've marked already. Yes. Yes.
My lord, kindly take the affidavit of R6.
Second copy nahi na.
My lord, kindly come to para 5.
This is affidavit of?
My lord, R6, which is SFI.
R6 already.
My lord, I will only deal with the oppositions of, my lord, the two originating
Yes,
authorities.
obviously. Yes.
My lord, R6, it's an affidavit affirmed by Purnabo Ganguly.
Mr. Abhishek Guha is appearing for the.
My lord, Bank of Baroda.
So that is also the other contest event. Yes.
My lord, Purnabo Ganguly is, my lord, Assistant Director, SFIO. My lord, kindly see.
Yes.
Para 5 starts. Para 5. Lord, kindly first see sub-para
Please
7.
give me half a minute because I was wrongly looking into the reply. Yes.
Affidavit in opposition of R6. Purnabo Ganguly. Lordship has found that.
No, not. Hey.
It should be in the back sheet of
Yes,
Narendra Prasad Gupta. Narendra Prasad Gupta.
Photo gulo pache 6%. Yes. So what is it? Have it Xerox because I want it.
I have already sent for the photocopy.
Thank you. Thank you. Paragraph 5 you said?
Para 5, sub-para 7, Roman 7, which should be in page 5.
Yes, got it.
My lord, this is in respect of, my lord, in the liquidation proceedings, my lord, the liquidator and the resolution professional who subsequently became the liquidator, my lord, at their instance, my lord, the order was passed. Lordship will find thereafter an avoidance application being so and so was filed by the resolution professional of KPPL under IBC on the basis of forensic audit, praying that an order be passed directing the respondent therein to be jointly and severally contribute so and so as per section 43 or the sale deed be completed for the transfer of land in favor of KPPL. Later on, the resolution professional bid its report of 28th April 2020 submitted information on avoidance transaction under IBC, followed by his presentation before the central government, and subsequently Ministry of Corporate Affairs, in exercise of its power under 212(1)(c) of the Companies Act, has inter alia ordered investigation by the Serious Fraud Investigation Office into the affairs of the company. And this happened, my lord, in April 2020, pursuant to which letter was written. I have supplied all documents. So that the entire web of transactions involving KPPL can be unearthed and a complete picture of fraud and siphoning of fund comes out. The investigation is ongoing with the SFIO. A copy of the order of 3rd June issued by Ministry of Corporate Affairs is annexed. May not kindly see R1. This is the order. And I shall show, my lord, the provisions of the Companies Act. Well, this will be in page 10. 3rd June order. And my lord, after, my lord, the SFIO takes over, I in my petition have disclosed that this is the letter I got. I have given 5 responses that up to the period I was a director, these are the documents. Subsequently, I have got hold of 3 more sets of documents. I have submitted everything. And even, my lord, I have attended whenever they have called, and there is no letter, my lord, any other allegations against me that I am not cooperating, I have not attended, I have not replied.
Mr.
No.
Chaudhary, has serious fraud been defined anywhere in the
Well, I shall show your lordship.
Yes.
Now kindly takes the provision of the Companies Act.
212(1)?
212, lordship has the Companies Act.
Yes, 212(1) I am there.
Yes.
Yes.
Now, my lord, 212, lordship will find without prejudice to the provisions of 210, where central government is of the opinion it is necessary to investigate into the affairs of a company by the Serious Fraud Investigation Office. But SFIO একটা definition আছে কিনা দেখুন। Well, these are the 4 conditions.
Yes.
Then, my lord, straight away, kindly come to, my lord, clause 6. I'm sorry, clause 2, subsection 2, not clause 1, subsection 2, where any case has been assigned by the central government to the Serious Fraud Investigation Office or investigation under this act, no other investigation agency of the central government or any other state government shall proceed with investigation in such a case. But the reason why I am showing is this is also a criminal proceeding with a special authority who has certain privileges, my lord, than the other normal, my lord, police or any other agency. Statute empowers them. And apropos my lord's query, lordship will kindly take section 2, clause 83. What is Serious Fraud Investigation Office? Definition lordship was asking.
211.
No, my lord, kindly come to 283 first. Then
It says 211. And I mean
211. Absolutely.
I've seen
Read with
211. Yes.
By notification, establish an office called the Serious Fraud Investigation Office. Then, to investigate. This is only an investigating agency, nothing more, because there is
a clue may be found in ABC of 210, because those are the instigations on which the investigation is started.
What was happening?
Yes.
Even under the earlier Companies Act, now, my lord, offences or corporate offences, if I may call, it is no longer restricted to, my lord, fudging of balance sheets and, my lord, non-compliance of statutory provisions. Well, there are, my lord, serious fraud is siphoning of funds from one company, hawala transactions, all these are there. So, my lord, where, my lord, and when a criminality is involving companies, my lord, because there is interpretation of balance sheet, there is interpretation of cross-checking with other companies, which may be associates or, my lord, may not be associates. My lord, a special provision has been set up in the Companies Act itself. My lord, it is nothing but another investigation agency. Just as we have the CBI, my lord, under the Special Police Act.
And the moment in the public interest comes in, which is your case also, 212(1)(c) is public interest. So then it's on the government to decide.
No, SFIO, my lord, moment the government receives the complaint, my lord, these are only the indicative part that it may be in public interest or on request from any department. Here, my lord, I have shown your lordship, there was an order passed, my lord. In the meantime,
Mr. Chaudhuri,
The
there is some
resolution-
distinction with public interest.
Yes.
210 says investigation into affairs of the company,
Hmm.
where the central government is of the opinion that it is necessary to investigate into the affairs of a company. A is on the receipt of a report of the registrar. B is on intimation of a special resolution passed by a company. But C is in public interest, unfettered.
Here,
When the central government is of the opinion that it is necessary in the public interest, it can direct.
no, here, my lord, I showed your lordship.
You
the
come
order.
under public interest. C.
Here, my lord, instead of the registrar, after, my lord, the liquidation proceedings started,
Yes.
my lord, the resolution professional had also made an application to the central government,
Hmm.
which, my lord, the government on the report of the resolution professional directed an inquiry.
That the government chose to do, but Mr.
And, my
Chaudhary,
lord, whenever
that
the
is not required.
whenever, my lord, lordship can take it from me, whenever obviously, my lord, the investigation has to be in public interest. Otherwise, my lord, it's no private interest
So
involved.
in your case, only 212 1C has been quoted. That is what I am more bothered about.
Yes, I will come to 212 1C.
No, that is the only clause quoted. There is
Yes.
no other.
My lord, there is no report from the registrar.
Exactly, that is what I'm saying. So therefore, it depends only on
Correct.
the wish of the government.
Correct.
Yes. Yes.
But, my lord, even if it is in public interest, my lord, and it is only, my lord, all I am saying is it is only in the realm of investigation. Because, my lord, this is, my lord, assuming jurisdiction of an investigating authority. And this was done in 2020. 212 1C. My lord, because, my lord, the others over here, there is no question of registrar giving report. There is no suo motu intimation by special resolution. And neither, my lord, any government department has given any order.
Mr. Chaudhary, what are the teeth of the SFIO?
Yes.
What
Now, my
is
lord,
the
lordship,
sanction?
kindly see, lordship has seen subsection 2.
Yes.
Now, kindly come to subsection 4.
I mean, what can it do?
I'll come. Well, there is a special court. Upon investigation, if it finds an offense, my lord, there is a special procedure how it will deal with it. My lord, in fact, it's a special court or the judicial magistrate's court. Subsection 10 is there. I'll come to that. My lord, may I proceed sequentially?
Yes.
Well, kindly comes first to subsection 4. The director serious fraud investigation shall cause the affairs of the company to be investigated by an investigating officer. So, IO, who shall have the power of an inspector under section 217. 217 I'll show. Then, my lord, there is a non-obstante clause, which, my lord, overrides the provisions of criminal procedure code, and notwithstanding anything contained in that shall be cognizable, no person accused under this section shall be released on bail or on his own bond unless. But these things have not yet come. No question of any offense. My lord, moment offense happens, my lord, I fall under that category. That pro forma will say this is the FIR, this is the offense committee. Now, kindly come to subsection 8. Up to 7, my lord, when bail can be granted. Subsection 8. If any officer not below the rank of assistant director of serious fraud investigation office authorized by the central government by general or special order has on the material in his possession reason to believe, and that reason for such belief is to be recorded in writing, that any person has been guilty of any offense punishable under sections referred to in subsection 6, he may arrest such person and shall as soon as may be inform him on the grounds of his arrest. This is also not happened. Subsection 9. Officer authorized under 8 shall immediately so and so. And then, my lord, there is this special court or judicial magistrate. My lord, kindly straight away come to subsection 11. Central government has a suo motu power to direct, submit an interim report. Now, my lord, we ask then 12. On completion of investigation, what the SFIO will ultimately do? The Serious Fraud Investigation Office shall submit the report to the central government. That's all. And then, my lord, 14. On receipt of investigation report, the central government may, after examination of the report and legal advice it may take fit, direct SFIO to initiate prosecution against the company. This is very important. So, my lord, all that has happened up to the affidavit which is before your lordship is only investigation prior to giving report. That is, my lord, up to subsection 4. Kindly see. Up to subsection 4. Shall cause. Beyond subsection 4, it has not even proceeded. Then Suppose, my lord, there is anything negative as against my client. SFIO will submit a report to the central government. The government will then direct SFIO, you initiate prosecution. This is, my lord, in subsection 14. Now kindly see 14A. I'm sorry, my lord, kindly ignore 14A, kindly come to 15. Notwithstanding anything contained in this act or any other law for the time being in force, the investigation report filed with the special court for framing of charges shall be deemed to be a report filed by a police officer under 170. Then, my lord, the criminal process, the criminal law, the procedure of criminal law, my lord, is set in motion. So, in the pro forma, my lord, after this process has come in, or this process has fructified, my lord, the pro forma will give all the FIR, these other, we are not even in that stage. Now, my lord, kindly comes back to the SFIO affidavit and kindly see the other part. My lord, other than clause 7, my lord, the only other paragraph of reference is, my lord, subparagraph 11 of para 5. In fact, SFIO, other than saying larger public interest, my lord, has said nothing. Subpara 11, KPPL has opened charges as per record available on MCA 21 portal amounting to 249 crore from bank, and due to non-completion of project, the kindly note, non-completion of project, the loan accounts were classified as NPA with effect from 1st September 2015. That there is larger public interest involved to the tune of 249 crores. So this is how public interest being calculated. And my lord, the only other paragraph from this affidavit is para 6 and 7. Page 8. The plea of the petitioner that they seek to visit China and Thailand is highly suspicious. This is almost, my lord,
Yes, highly suspicious.
Lalmohan Babu.
Right. Yes.
And unacceptable.
Why I'll show. Why it is highly suspicious, I'll show.
No, you have precedence in Sonar Kella. Yes.
As there is a, but this is for the ad interim stage. We had given some documents that we have some business meeting in China, but that is now at academic. I am on the second portion. Fourth line. In view of the above, petitioners may not be permitted to leave India as the investigation in the matter is pending. This is subsection 4 stage. 212 subsection 4. They will have to come up to subsection 13 before, my lord, they can fill up the pro forma, not before that. There is larger public interest involved in the matter, and issuance of lookout circular is justified for the which would be detrimental. Then para 7. It is once again reiterated, present petitioner are very much involved in the instant case as stated above. SFIO needs to unearth various links, and if petitioners are permitted to travel abroad, there is possibility of evading the probe and ultimately hampering the investigation. Well, these with respect are not grounds even under the 2021 circular. Pendency of investigation by any authority is not a ground to deny. In fact, my lord, I showed your lordship the clause that when you can prevent a person from leaving the country, it is very, very clear. My lord, HIJ, I showed your lordship when it can be done. So, my lord, with respect, my lord, in the affidavit of SFIO, my lord, there is nothing to show. In fact, the affidavit of SFIO indicates that whatever they have done is up to subsection 4 of section 212 of the Companies Act. The stage when, my lord, the criminal proceedings which said triggered, that is, my lord, subsections 14 and 15, 13 and 15, that has not even come. Because, my lord, first, my lord, after their investigation is complete, they will give a report to the central government. Then the central government will do it.
2023 investigation officer
SFIO has not annexed its request here.
Nothing.
Mr. Bhattacharya, are you armed with that? Because you have to
don't
put it
have the
before court.
request with me at the moment. If my lord directs me, my lord, I can produce that in a sealed cover, my lord.
In fact, my lord, in the affidavit of SFIO, 23rd January 2023, that is the last page of that affidavit. Kindly see the investigating officer is now changed in 2023. This is the only document we have, last document of, that is all. And there is, my lord, other than, my lord, the initial notice when information was sought for by me, But kindly see, even in the affidavit, there is no challenge to this portion. That no, I had sought for additional information you did not give, or these are the issues. There is nothing. So, my lord, even on the basis of the affidavit filed by SFIO, no progress has been done beyond subsection 4. And simply because it is SFIO, my lord, it is nothing but another investigating agency who will simply furnish a report to the central government, who, if it is satisfied by the report, will then direct the SFIO, no, this is a cognizable offense, you initiate the criminal proceedings. So this is absolutely premature. Now, my lord, this is so far as R6 is concerned. Kindly take the affidavit of R2, which is, my lord, the Prakash Agarwal, affidavit affirmed by Prakash Agarwal.
But may I just be excused for 5 minutes? My
Oh,
junior
yes,
is here.
absolutely.
This is the other originating agency, which is the Bank of Baroda. It kindly comes to paragraph 3B. Para 3 starts at page 2. 3B is right at the bottom. However, from the, I'm sorry. This is the affidavit of Prakash Agarwal. This will be in the back sheet of Abhishek Guho.
Yes. You are on paragraph?
Well, paragraph 3B, page 2 of the affidavit.
Yes, got it.
However, from the documents produced with the writ petition itself, it can be demonstrated that the LOCs issued in respect of the petitioners are valid and were necessitated in view of the involvement of the petitioner in various offences, including criminal offences. Well, other than this bold statement, there is nothing in the affidavit giving any detail of any cognizable offense, other than this expression, various offense, including criminal offense. Now, kindly see subparagraph E. It is also a matter of record. Various investigation are ongoing. An investigation by Serious Fraud Investigation Office has been initiated against the petitioner and the entity. It is clear that fraud is or in the process of being reported. Beloved, SFIO is saying bank has, there is serious dues of the bank, and bank is saying SFIO is doing, and there is a presumption that it is serious fraud. Process of being discovered. Then, my lord, kindly come to subpara I, which is at page 5. The Government of India, Ministry of Finance, by the circular letter dated 22nd November to the public sector bank, it has strictly stated public sector banks have been empowered to issue requests for opening a lookout circular. I mean, this is the 2018 notification. Then, my lord, kindly see, in case of persons who take loan and willfully default and then escape to foreign jurisdiction to avoid paying back. My lord, this line or this expression is not there in any circular. Willful default, my lord, this has been introduced by the deponent as a part of the circular in the affidavit. Neither the 2018 circular has it, nor the 2021 circular has it. Willful defaulter process, my lord, Lordship knows RBI guidelines, a separate thing has been done. Now, my lord, kindly comes to, my lord, subparagraph O, which Lordship will find at page 7. The exposure of the entity controlled and governed by the petitioner is admittedly more than 50 crore, and the sheer magnitude of offense and its spread clearly leads to an apprehension that petitioner have no intention of paying. Again on apprehension. And then, my lord, the last of the paragraphs, subparagraph R, page 8. There are various other grounds which have necessitated the issuance of LOC. The originator had disclosed such grounds in the request for LOC, a copy whereof shall be produced before the court in a sealed cover if called upon to do so. Lordship will, my lord, firstly, my lord, the sealed cover practice has been, my lord, deprecated by the Honorable Supreme Court. The recent judgments are there. But, my lord, even if it was something serious, it can't be more than what has been stated in black and white, any other ground. After all, at the end of the day, the life and liberty of a person is involved.
You have craved leave to produce it. Have you got it? The sealed cover.
My lord, I have to take instructions.
Yes.
My lord, other than this, my lord, so far as the annexures are concerned, Lordship will find page 15. There is a demand notice of 4th of January 2021. And my lord, the old circulars have been annexed. I am not, my lord, the circulars of 2017 at page 18 and page 20 is the circular of 2018. Detrimental to public interest, larger public interest, economic
So
interest.
as of today, the only things against you which they can argue, I mean, one is you have been classified as a willful defaulter, and this SFIO investigation or whatever.
Yes. Now, my lord, my answer to that is, my lord, Lordship has seen the circular. Willful defaulter has other repercussions in law.
Yes, right.
There is nothing in the circular which says, willful, for circular to be operational, there has to be a cognizable offense. Or, my lord, in the exceptional category of larger public interest of India, or, my lord, serious economic offense. And, my lord, now it is well settled that the quantum of the debt will not determine the degree of that public interest. And, my lord, since they are not coming, and SFIO have already shown, up to subsection 4 from the affidavit, maximum up to subsection 4. No report has been given even to the central government. So how can it be presumed? First, a report will be given, and if investigation continues for another 5 years, this embargo will happen. This can't be, my lord. Now, my lord, apropos this, my lord, 3 judgments, my lord, I just quickly. কোনটা যেটার কপি আছে সেটা দাও, অন্যটা পরে দিয়ে দাও। My lord, this is, my lord, I shall give my lord's judgment, but following my lord's judgment, this is the judgment of Justice Sarkar, Shampar Sarkar, in WPS 6670 of 2022. The Lordship had the occasion to deal with one Vishambar Saran matter, which is my lord's judgment. I'll show it last, since my learned friend has already put me on caveat. This is another, because, my lord, here what was happening, my lord, every time one LOC was being quashed, my lord, another bank was coming and putting in a.
Whichever writ court, learned single judge in this court has taken up these matters, these residuary matters, each one of the benches has passed a judgment of this sort.
Yes.
Each one of the benches. I don't know whether Justice Sengupta has yet done it. No, he's not taking up, he's taking up different matters.
My lord, earlier Justice Mousumi Bhattacharya was taken.
Justice Shampar Sarkar, other benches also.
In fact, my lord, Justice Shampar Sarkar and Justice Mousumi Bhattacharya has both considered the 2021 circular.
Yes, right.
And in fact, I'll come to Justice Bhattacharya, Mousumi Bhattacharya's judgment. Here, my lord, her lordship has taken into account the additional criteria that now, because of that no time limit being there, it is all the more, it has to be, my lord, seriously viewed.
The moment I say that don't cite my judgment, the very next moment Justice Mousumi Bhattacharya and Justice Shampar Sarkar's judgments are cited. So I almost have this by heart now.
My lord, subject to correction,
More than Kartik Chidambaram.
these are the only 3 or 4 judgments, my lord, of our High Court in final hearing on these matters.
Yes.
Lordship's judgment in Vishambar Saran was the first in final hearing. Then, my lord, Justice Sarkar's judgment came. And now we have, I think, my lord, 2 judgments of Justice Bhattacharya.
Right.
Mousumi Bhattacharya. My lord, page 29, para 54, Karti Chidambaram has been considered, so we are not citing it separately, because this is, my lord,
Justice Sarkar's judgment contains all the judgments.
all the judgments.
Most syllable.
My lord, even the Delhi High Court, the other Delhi High Court judgment was considered.
Yes.
Now, my lord, kindly comes to page 32, para 59. Didi, sorry, sir. আমি আমারটা পড়ে দিলাম।
No problem, no problem. Thank you. Oh, Vishambar Sarkar আছে? Vishambarটা আছে?
আরে আছে আছে, তোর কাছে
না, আমার কাছে সভ্যতারটা আছে, ওইটা যেটা মেইনটা যেটা।
My lord, para 56, Lordship will find, my lord, this is the first Delhi High Court judgment. This was, of course, my lord, on a WhatsApp chat, my lord, they said that there are suspicious circumstances. This is the first Delhi High Court judgment. Then, my lord, kindly come to para 59. In my opinion, personal liberty and fundamental right of the movement guaranteed by the Constitution cannot be curtailed at the behest of Bank of Baroda when conditions precedent for making such requests for opening an LOC did not exist in this case. My lord, it appears that Bank of Baroda, my lord, routinely, whenever the default is beyond a certain category.
This is now an alternative recovery procedure.
Yes. Most of the banks, unfortunately, has my lord taken this. And that
we used to joke that whenever you cannot obtain a divorce, you file for extradition. Actually, an extradition application in connection with that writ petition came before me, where a person is seeking extradition of his wife on the ground that she is a Bangladeshi. I mean, this is like that. Whenever you can't do good in your recovery proceedings, issue an LOC.
Perhaps it also has its origin because of the two names and the two things that happened, and public sector banks got involved. My lord, all public sector bank officials, perhaps to save their skin, my lord, they don't.
Maybe that is one of
also
the
another
one of the reasons why doctors give so many, I mean, diagnostic reports. They ask for reports
because now,
even if they are confident, we would sue them the next day.
Clinical eye has almost vanished because
actually, yes, banks cannot be blamed on that solely.
That is the psychology.
You're right. You're right.
Psychology.
Yes.
Who knows what will happen? I will be hauled.
Self-defense, they do it. I mean, don't take the risk. Yes.
Because, my lord, the Immigration Bureau and their affidavit, they have said, we are only the implementation agency.
Yes, Immigration Bureau has to be given a greater power.
They do not cause any, my lord, independent inquiry. Nothing. They are saying in the affidavit, my job is only to be the executing authority. Moment I receive, the justification has to be given by the originator. Now, my lord, the affidavit in opposition does not disclose, had applied its mind or had received information so and so. It is also a matter of record that proceeding with regard to willful default is still pending. Bank has not disclosed any material to show any other proceeding under applicable law, be it civil or criminal, has been initiated. Non-payment of loan and the dues of the bank
You need not read the entire. Just give me the relevant paragraphs. Just say.
Paragraph 59, 60, 63. Bold assertion that departure would be detrimental to the economic interests of the country, so and so cannot.
Yes.
My lord, so far as my lord's judgment is concerned, my lord, I shall just give lordship the copy in. Just give me 2 minutes.
Yes,
My lord, I am just relying upon this is the.
I have a copy for his lordship.
I am grateful to my lord. My lord,
He has got only my judgment's copy.
That
won't
this has
help
been
you.
followed in all the other cases, my lord, which Mr. Chaudhary.
My lord, my lord's judgment, I'll just indicate the paragraph 3, 18, 41, 46, 3, 18, 41, 46, 47, 50, 51, 52, 55, and 58.
51, 52,
51, 52, 55, and 58.
58.
Now, whenever an LOC is issued, people go to Mr. Dotto. Mr. Dotto goes to Mr. Chaudhary.
Yes.
In most of the matters.
LOC specialist.
Yes. Mr. Dotto is there in all the matters up to now.
No, my lord, by sheer coincidence, because the first two matters
Naturally,
were of Vishamba Saran,
yes,
and my lord, they belong to a company or a corporate group called Visa, and my lord, both of us
so it happens, Mr. Chaudhary. Naturally, it happens. Once you do a particular matter, I mean, people come to natural. That's a natural tendency also. Yes.
So, my lord, by coincidence, my lord, we have got this.
Yes.
So, my lord, these are the two. Now, my lord, the last judgment is the one passed in WPA 22748.
For a change, Mr. Bhattacharya was there. Yes.
Oh, it to Ami.
Mr. Bhattacharya was there. And my lord, for a change, I was not there.
Yes, sir. You have distributed between yourselves. Yes.
My lord, kindly comes to my lord, page 9. Let para 17, my lord, Karti Chidambaram has been again shown, and my lord, the other Delhi, my lord, here, my lord, para 16, lordship will note, this is perhaps the Delhi High Court judgment which my learned friend will rely. That was also cited and this was distinguished. My lord, in that, the petitioner did not have any assets in India. That was the distinguishing feature. Here, my lord, I have already shown there are injunctions, whatever.
Yes, exactly. I mean, yes.
Now, my lord, kindly come to, my lord, page 10. Para 19 and 20. The ground used against the petitioner is evidently economic interest of India. There is no evidence that petitioners living for the country for a specified period of time would affect the economic interest of India. The petitioners have not been declared fraudsters or money launderers or even economic offenders. Apart from the reach of lookout circulars to cause immediate and irrevocable violation of the person's fundamental right of movement, lookout circulars have an inexplicably long shelf life. Subparagraph J of the memorandum dated, office memorandum dated 22nd February 21 mandates that a LOC shall remain in force until and unless a deletion request is received by the Bureau of Immigration from the originator, and that no LOC shall be deleted automatically. Although these clauses cast an obligation on the originating agency to review the LOC on a quarterly/annual basis and submit proposals for deletion of the same, this is sadly found to be absent in most cases. Once a lookout circular is issued, it remains alive and kicking for almost all times to come. This spells dangerous repercussions on the person's right to freely move across and beyond the country and remain mobile. The banks have been given untrammeled powers to issue, use, and exploit the lock-in power of a lookout circular without sufficient records being provided in law to the person at the receiving end of it. The expressions detrimental to the economic interest of India in the concerned OM is sufficient to sharpen the talons of a vindictive bank to clip the wings of a vulnerable prey in the metaphoric sense. The writ court hence can and should step in to check such unregulated abuse of power by banks where the facts demand relief. In view of the reasons above, respondent 8 so-and-so bank cannot have any continuing reason to interfere with this. Interference sought to be imposed by way of the lookout circular is arbitrary and without any rational basis. Malad, the next line is very important. Yes. The CBI courts where the cases are pending are free to pass orders or impose conditions as the court may deem fit. Here, my lord, that position, no, it is no court has taken cognizance. Again, at the cost of repetition, only up to subsection 4 stage. First, give a report to central government who will do that. This court sees no reason to allow the impugned circular to. And Millard, I have kindly make a note, para 16, the judgment of Delhi High Court has been considered and distinguished. Yes. Ghanshyam Pandey is the only Delhi High Court judgment which says otherwise. Millard, that has been distinguished. In that case, the writ petitioner did not have any assets in India. Millard, those are my submissions.
Yes, I'll hear both of you tomorrow, day after tomorrow. Heard learned counsel for the petitioners. Petitioners, full stop. Heard in part for further hearing on 16th.
Deeply okay.
But may I?
But Mr. Bhattacharya and ma'am, please come back with your letters you issued to prompt the lookout circulars from your request letters. Please come ready with those. If you want in sealed envelopes, you can bring those. But bring those. I want to look into those on the next one.
Will it be my lord's pleasure to keep it on Monday, my lord?
Why? Come day after tomorrow.
No, this is
it's
being
pending for a long time.
No, my lord, this is being investigated by the Hyderabad office, my lord, the Hyderabad branch, my lord.
So what?
Had it been done by the Calcutta branch, my lord, I would have never made this.
We are not in primitive days, Mr. Bhattacharya. This requires a phone call and at best an email.
But tomorrow is a matter.
Do it today.
No, tomorrow is a holiday, my lord.
Ask today, take information tonight.
If it has to come, my lord, in sealed envelope, my lord, but I am being respectful, my lord. If my lord may kindly
for further hearing on August 21, 2023.
Grateful to you.
আচ্ছা আরেকটা লাইন অ্যাড করে দিন তো the contesting respondents, that is the Bank of Baroda and the SFIO, shall produce copies of the request for issuance of lookout circulars served by them on the immigration authorities to prompt the latter to issue the lookout circulars, on the next date of hearing. I put it in my order, Mr. Bhattacharya, so please, so that it will help you also.
No, I would have urged your lordship also, my lord, to indicate that.
Easier for you.
But may I take back, my lord, the first Bishambar sworn order, my lord? I have only one copy, my lord. My lord's judgment.
Take print out.
জেরক্স করতে প্রিন্টার 5 টাকা করে লাগে।
আমি দিচ্ছি তো বাবা, please.
গ্রেটফুল। তুমি দাও না।
না না 5 টাকা করে গুলো দিয়ে দাও পুরো। এটা শেষ করে দাও।
আমি দিয়ে চেয়েছিলাম এই যে
The original side mentioning.
May I have your lordships kind leave to mention item number 16 of your lordship's student list?
Yes.
Can this be taken up on day before, day after tomorrow?
Taken upon?
Day after tomorrow.
Yes, does the other side know?
The Union of India is there, today.
Whenever it is called on, Mr. Mukherjee, otherwise a plea may be taken that you did not inform. Either bring the other side or mention it at the time of call.
I'm for the petitioner. Mr. Kaur is leading me, is not in town. As you,
Mention it when it is called on.
as your lordship.
I may not preach it even.
As your lordship.
My lord, may I have your lordship's kind leave to mention item number 26 of your lordship's original side list. This is already upgraded by your lordship, my lord. But my lord, looking at the position in the list, it doesn't seem likely that it will come up. Yes, my lord. This is
22.
22 is the last item. Huh? 22 is the last item.
appellate side, my lord. I beg your lordship's pardon. Perhaps if your lordship will permit me to mention now, my lord, I will
Appellate side, Mr. Shahano.
I'll take my try tomorrow.
Item number 1. Wait, please, your lordship.
Yes.
No, do you appear for it?
Yes, please.
The petitioner, he applied for a new passport. When he applied, lordship, he was informed that there is one criminal case pending against him, which he was not aware of. Then he searched the record. He found that one criminal case, which is the dispute between the tenant and the petitioner, who is the landlord, who has recently purchased a property. A case has been started, a charge sheet has been submitted, 323/509. He appeared, he took bail. Thereafter, he made a representation and he filed a writ petition before this honorable court, which is pending. I've disclosed in my paragraph also. Paragraph 17.
Representation regarding what?
To consider and issue with a passport. Now, then the passport authority asked him that you have to bring the order from the criminal court. You have to apply there. So on being advised, he approached the criminal court, made an application, criminal court granted no objection. That is on page 68 of my application.
68. Yes. Right.
Now, after this order was passed, the passport authority issued me the passport. Now, the passport authority issued me the passport for 1 year. Now, after taking the passport, in the meantime, I was applying for my further studies abroad because I am a BTech student, so I'm applying for my master's degree. Now, I've got offer from several universities. One is Queen's in the UK, one is Cardiff University. Now, the period for the education of master's degree is for 1 year. Now, already my 2.5 months have lapsed. Passport, we have received the passport. I again approached the passport authority. And I disclosed this fact that this is the difficulty because in the event if my validity of my passport is not extended, then I'm unable to go for my further studies.
Your passport has expired in the meantime?
No, it is alive.
Due to expire when?
It is due, I'm showing you, lordship. I'm annexing the passport, lordship. Just give me 1 minute, lordship.
So that will
Expire before the
your
lordship.
term of studies.
That is the only difficulty. So I have approached the passport authority.
Where is that representation of yours now? Page 79.
Lordship. Page 79. And this is the reason which they have cited. They've given a letter, they're saying there's a notification by the central government 1993. They have given me the copy also. There's a pictures.
Where is their reply?
Yes. This is a better copy, lordship, because even I'm finding difficulty in Hindi and English language.
Hindi not difficult, but Mr. Chakraborty will have to read it out from me. Yes. That is the only.
This is their.
Now here the rule, this is the notification, is the rule issued by the Ministry of External Affairs in the year 1993, 25th August, where they says that if the court issues no objection and if there is no specific period mentioned therein, then you're only entitled to have 1 year validity of the passport. That is what they are trying to explain to the petitioner.
This is not, oh yes, the second page is there.
Second page, Lordship. A, if there is a specific period, then they will issue the passport according to the court specific period. 2, if no period either for the issue of the passport or for the travel abroad is specified in such order, the passport shall be issued for a period of 1 year. That is what they are trying to justify, Lordship. And the order of the court, the criminal court.
Yes, they're right actually. So they're apparently right. You have to seek a modification of that order or fresh order from the criminal court. Do that. They'll give that. That is the law.
Lordship, this order, I'm grateful to Lordship, but this order was passed when the police also gave a report and says
whatever
that,
may be the scenario. I mean, if the court order does not specify, then obviously A2 applies.
Lordship.
So comply with that. Get a modification.
Only my humble Lordship may kindly direct make a representation there because I've already come here. So
I'll dispose of the writ petition. I'll say that you are at liberty to obtain a modification or a fresh order from the criminal court and produce it before the passport authorities. If you produce, they'll process it.
Lordship, grateful Lordship. And then some time period maybe Lordship.
Although, my lord, I have nothing to say, but the Lordship see the report.
You are appearing for the WBSCT sale. What do you have to say here?
Regarding the extension, my lord, it is upon the passport authority, my lord. The entire thing we have narrated, my lord, regarding the permission and other thing.
Mr. Chakraborty, I don't think you have to say anything else.
So I have no objection to the student's career. But only thing, only thing that actually has been pointed out, in terms of the notification of the government of India in connection with the Passport Act, he has to make an application annually before the tribunal.
Mr. Kasimuddin actually placed the provision even. I mean, he's not denying that. So
Therefore, he has to, 3 options are open. Either to challenge the criminal court's order in 482.
he does not.
He does not. Then what is
Either modification or new application.
At that time, I didn't get the offer from the university. So I
on the basis of subsequent event that may be considered.
Right, thank you. The petitioner contends that the petitioner had obtained an order from the criminal court, where a criminal proceeding is continuing against the petitioner, for the purpose of issuance of a passport in favor of the petitioner. First of next para, subsequently the petitioner, during the subsistence of the tenure of the passport, has got several lucrative offers from foreign universities, to pursue the petitioner's higher studies, for which the petitioner seeks an extension of the validity of the passport. When the petitioner approached the passport authorities, the passport authorities cited a notification, which apparently requires the applicant to obtain a valid order from a criminal court, where the criminal proceeding is pending, in the event, the order of the court does not stipulate the time limit, the validity of the passport shall be deemed to be 1 year. It is submitted that necessary directions be given on the respondent authorities to ensure that the academic career of the petitioner is not hampered. Heard learned counsel for the parties, including the learned additional solicitor general and the state. Next para, a report filed by the state be kept on record. Next para, a perusal of the concerned notification, being notification dated August 25, 1993, within square bracket, GSR 570 within bracket capital E, bracket closed, it is clear that in cases where a criminal proceeding is pending against an applicant of a passport, comma, the applicant has to produce an order of a criminal court, comma, where the proceeding is pending in that regard. Full stop. In clause small a within bracket, it is stipulated that the passport to be issued to every such citizen shall be issued for the period specified in the order of the court, if the court specified a period for which the passport has to be issued. Full stop. However, comma, in subclause within bracket small Roman 2 III, comma, if no period either for the issue of the passport or for the travel abroad is specified in such order, comma, the passport shall be issued for a period of 1 year. Full stop. Next para, the said clause being applicable in the present case, comma, since the criminal court, comma, at the first instance, comma, did not stipulate any time limit for which the passport has to be issued, comma, the remedy before the petitioner is to approach the said criminal court for a modification of the order or a fresh leave to obtain a passport for the period necessary to pursue the petitioner's studies. Full stop. Next para. Hence, comma, no irregularity can be found in the refusal of the passport authorities by citing the notification in question. Full stop. Next para. In view of the above observations, comma, WPO 1499 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned jurisdictional criminal court, comma, where the criminal proceeding against the petitioner is pending at present, comma, seeking either a clarification / modification of its previous order whereby leave was granted to the petitioner to obtain a passport and or to obtain a fresh order from the criminal court, comma, for issuance of passport to the petitioner, comma, covering the period during which the petitioner shall pursue his studies abroad. Full stop. If such an application is made, comma, the criminal court concerned shall decide the same as expeditiously as possible, comma, preferably within a fortnight from the date of making of the application. Full stop. Upon an order being passed by the criminal court, comma, in that regard, comma, the petitioner shall be at liberty to approach the passport authorities with such with a copy of such order. Full stop. Upon such an approach being made and an application being made accordingly by the petitioner for modification of the said passport, comma, the respondent number 1, that is the regional passport officer, shall process such application at the earliest and modify the passport accordingly. Full stop. No address to cause urgent certificate. Modify the passport accordingly, comma দিয়ে ওখানটা লিখে দেবেন, subject to the petitioner otherwise complying with all due formalities in law. No address to cause urgent certificate.
So instead of 14 days, can it be 10 days because my
No, that will get difficult.
It cannot be less than that.
we have to deposit the money in the university. My mother is standing there. We have taken loan also. So only 4 days, 10 days, Lordship. I'll apply it tomorrow
By the Sessions Court.
by the 12th Metropolitan Magistrate. I'll file it on Thursday. I'll file it on
Fortnight
Wednesday.
10 days করে দিন. Yes.
Grateful, Lordship.
All due formalities in law. ওখানটা না, আমি যেখানটা 14 days within a fortnight with, হ্যাঁ ঠিক আছে, থ্যাংক ইউ, হ্যাঁ বাস, থ্যাংক ইউ,
Item number
10 days, হ্যাঁ, yes.
Item number 2, I appear on behalf of the petitioner, right? Friday, I mentioned the matter and Lordship was kind enough, to direct the matter to appear in the list considering the urgency of the matter.
Yes.
May I, file the affidavit of service?
Actually, I appear for the respondent bank.
Before I
Just now, I have received a copy of the writ petition. Can it
served
be
on
taken up?
Friday, I'm told.
Can it be taken up on Friday, my lord, subject to my
So
lord's?
he has got some urgency.
Lordship.
Yes.
The facts are before I place the relevant documents.
So can it wait till Friday? What is the urgency?
Urgency is the show cause notice, which is at page 95. They have said, kindly come to page 95. I have challenged that show cause notice because I say there is a gross irregularity in the notice and Prima facie, that is, my lord, not sustainable in law. Page 95 is the show cause notice issued by the State Bank, my lord. They say prima facie, they are satisfied that there are signals of fraud and the account has been marked as suspected fraud. Now, my lord, kindly turns over. They have given certain, my lord, factors, which I say on the face of it, my lord, are wrong, my lord. Then, my lord, page 98, what they say, paragraph 5, my lord, if you do not make any submission within 15 days, which expires, my lord, either today or maybe expiring tomorrow, as mentioned above, the bank shall presume that you have nothing to say in the matter and will take decision as appropriate as per the RBI guidelines. And this has been done contrary to the RBI
That's
guidelines.
what you say. My lord, this notice, my lord, which was issued, is a show cause notice. My lord, subject to
So
correction.
they're challenging the show cause notice. I
They are
have to
challenging the
consider
show
at
cause
least
notice,
whether
my
this
lord.
is valid.
They
Yes.
were directed to give a show cause. They have not. They have made an offer for settlement. That is pending, my lord, subject to correction, my lord. I have already got instruction from the Bombay. My lord, that is under process. My lord, maybe it has been communicated to them. I do not know. My lord, that instruction I have to take in.
If
Whether-
that be so, then you cannot take action on this. I mean, this has
That's
to
my
be stayed for a limited period.
My lord, if that be so, my lord, they have already, after this, my lord, they have applied for a, my lord, settlement.
Settlement was prior to that. And, my lord, if I show you the settlement, Lordship would
My lord,
find
now
how, my
what-
lord, they have
my lord,
acted.
now
So
after
if
the
you
Supreme-
say that you won't proceed on the basis of this notice or the time limit given herein is extended,
Lord, he did not show cause.
then I'll
Even-
hear him. Yes,
Absolutely.
let me hear him on interim orders. Yes.
My lord, I tell you, Lordship, my lord, the facts, my lord, before I show you the documents, my lord.
My lord, I do not have any documents to show, my lord, that whatever my learned friend is showing today. That
No,
is
I am
what
not
difficult.
showing anything new, my lord. Whatever they have been annexed to the writ petition, I would be relying on that.
Just-
Save and except,
I
my lord, the
told, my
RBI
lord, just,
guidelines,
my
which
lord,
everybody is aware of.
outside the court, I received the brief.
You
It is
don't
coming from-
understand. They are in jeopardy because the last day of the show cause expires today. If they don't appear before the your authority, then it will be presumed that they don't have any defense and their account will be marked as
My lord,
fraud.
they were
They are under this guillotine. So if you pray for time till Friday, you have to concede to it that you won't take any coercive action on this on the basis of this show cause notice before Friday.
Then, my lord, can I come back within 5 minutes?
Let me, my lord, proceed, my lord, if Lordship permits, my lord. My lord, the petitioner number 1 is a company and petitioner number 2 is one of the directors and also stood guarantor in some of the loan transactions. Initially, the company's name was, my lord, Bengal Infrastructure. Then it was converted to, and, my lord, the petitioner number 1 existed. Now, my lord, for the purpose of expanding the business, my lord, the petitioners, my lord, obtained loan from various banks. There are several banks. Lead bank of the consortium is, my lord, Central Bank of India. Why I say it's important, I will be relying on the RBI circulars to show how they have acted, my lord, contrary to the RBI guidelines. Now, my lord, I obtained loan. I also obtained loan from the respondent in the year 2008. Now, my lord, admittedly, there was some default because, my lord, the business has gone down. And, my lord, initially the account was, my lord, it was a willful defaulter. It was declared account was, my lord, marked as, my lord, fraud, my lord, and a CBI case was initiated.
That was during your regime.
Yes,
After you took-
yes. And, my lord, I participated. I obtained bails. My traveling was, my lord, absolutely necessary. And, my lord, I had to obtain approvals from the CBI court and I was permitted to travel. Important thing, my lord, I have settled the dues with most of the banks. And one of the bank, my lord, is IOB, which had issued a LOC, my lord. That was subsequently, my lord, quashed, my lord. Mr. Chaudhary was arguing that's, my lord, the last one. So that was quashed. Now, my lord, I have settled with all the banks, including the State Bank of India. And, my lord, State Bank of India, what they did, my lord, the respondent number 1, they initiated a case under Section 7 of IBC. CIRP process was directed to be proceeded with. I preferred an appeal. It was stayed. And in the appeal, my lord, parties have agreed to settle and the offer of settlement was recorded and the hands of CIRP was, my lord, stayed, my lord, for a considerable period of time. Then, my lord, finally, my lord, settlement was arrived at. That is very important. That was, my lord, on 12th of April 2023 with this particular respondent. Now we are not concerned with the other banks, my lord. After entering into the settlement, my lord, I, my lord, paid about 12 crores 50 lakhs to the respondent. There were certain terms I will be relying on. It says that whenever you pay the dues, my lord, in terms of the settlement, proportionately, certain properties which were mortgaged would be released so that I can get the investors and pay off the dues of other banks because settlement, my lord, I had entered into with some other banks. They have acted contrary to that. Then, my lord, they have said about the forensic audit. I given the documents. I produced all the documents which I could. Important thing, prior to this, in the year 2018, my lord, they had conducted a forensic audit. At that point of time, I had submitted all the documents.
Can I look into these factors at the show cause stage unless you show something palpable?
That I will show. That I will show.
So that
Absolutely.
first, because show cause we are very
Yes,
limited. Mr.
Absolutely. I'm grateful to you. But just, my lord, I was telling the facts, my lord. Now, my lord, kindly have a look at, my lord, the circular. This I wanted to show, my lord, about just to place the conducts. First, my lord, before I show you the RBI circular, which has been issued in contemplation, my lord, with section 35A, my lord, Reserve Bank was empowered, my lord. Only one document I will show you, my lord, the settlement which I had entered into with the RBI, that is with the State Bank. That, my lord, is at page, my lord, 85. Lordship has got it, my lord. Page 85 of the writ petition.
Yes,
This document is important, my lord, on the basis of my argument that the prima facie it is liable to be quashed, my lord. Show cause notice. Kindly have a look at this settlement which I had entered into. May I, my lord, read out? We referred to your letter dated so and so. That was the proposal that I give. I have annexed that. Lordship need not go into that. For settlement of your dues to the bank and subsequent discussions on the caption subject, we are pleased to advise you that the offer to pay rupees 81 crores towards the dues of petitioner number 1 company, that's, my lord, to the bank has been accepted by the appropriate authority. Then, my lord, the total amount payable under the settlement would be 81 crore. My lord, the terms have been quoted. Kindly, my lord, turns over. Page 86, F, that is very important. Next page, my lord.
Yes.
All cases filed by the company, directors, guarantors, if any, against the bank are to be withdrawn. So till 12th of April, whatever the case that was instituted, that has to be withdrawn. So anything for this show cause notice will have to be a subsequent fact, not a fact prior to that of the settlement, my lord. Now, my lord, kindly, my lord, comes to the settlement which I had entered to do with the other banks. That is very important, my lord. Kindly have a come to, my lord, page 25. I submitted before your lordship at the very beginning, my lord. There's a lead bank of consortium is, my lord, the Central Bank of India. Page, my lord, 25, my lord.
Yes.
My lord, I had settled the dues, settled his claim, my lord. Page 25, lordship would find, my lord, the terms of settlement and their proposal to the petition number 1. We are pleased to inform you that kindly, my lord, ignore this. The account was declared as fraud. I submitted before your lordship. That was, my lord, way back in 2000, my lord, 13, my lord. Prior to that, I got the orders. Therefore, the criminal action cases initiated in the account will continue. Kindly take note of this. So whatever the case was, that will continue. Subject to whatever I settle, that will continue, and it will have a different impact altogether.
As opposed to this.
Yes, not only this, but other banks also I had settled. I'm grateful to your lordship. Kindly come to page 46. I have settled with all banks. I will not trouble your lordship to look into all the settlements, my lord. Page 46 is the settlement with the UBI. Kindly come to clause 7 once.
Where will not be withdrawn.
Same. Now, my lord, after 12th of April, they, my lord, said a forensic audit will be conducted, and my lord, I have given the documents. But as rightly lordship has said, my lord, I will not show you because then I will be inviting the court to go into the merits. Now, my lord, kindly have a look at, my lord, the RBI circular in this regard, which is very important. This is very important, my lord. Whether it has been complied with or not, my lord, that lordship would kindly see. If I can satisfy your lordship, it has not been complied with, then obviously, my lord, this notice goes, my lord. Kindly, my lord, come to once, my lord. Running page 24. My lord, at the bottom, lordship would find the page number.
Yes.
8.9, lending under consortium or multiple banking arrangements.
Right.
Here, my lord, is the consortium. Lending under consortium comes because there are about 8 banks, my lord, and the lead bank is the Central Bank of India. Kindly, my lord, have a look at, my lord, clause, my lord, 8.9.4. Next page, page 25. This is very important.
Yes.
Lordship has got it, my lord.
Yes.
The initial decision to classify any standard or NPA account as RFA or fraud will be at the individual bank level, and it would be the responsibility of this bank to report the RFA or fraud status of the account on the ILC platform so that the banks are altered. In case it decided at the individual bank level to classify the account as fraud straightway at this stage, the bank shall then report the fraud to RBI within 21 days of detention, and also the report of the case to CBI police. So far as my knowledge goes, CBI case police, nothing has been informed. Next, kindly read on. As is being done hitherto, further within 25 days of RFA fraud classification, the bank which is red flagged the account or detected the fraud would ask the consortium leader, kindly take note of it, would ask the consortium leader or the largest lender under MBA to convene a meeting of the JLF to discuss the issue. Not done. So far as my knowledge goes. The meeting of the JLF, so requisition must be convened within 15 days of such a request being received. In case there is a broad arrangement, the account should be classified as a fraud. Else, based on the majority rule of the agreement amongst banks with at least 60% share in total lending, the account should be red flagged by all the banks and subjected to a forensic audit commissioned or initiated by the consortium leader. Here, my lord, the consortium leader is the, yes, no approval, nothing. Or the largest lender under MBA. All banks as part of the consortium or multiple banking arrangement shall share the cost and provide the necessary support for such an investigation. Now, my lord, one more clause, my lord, I would show, my lord. Then, my lord, 8.9.5, it talks about the forensic audit, my lord, when it's to be completed within a period of 3 months. I am not on that, my lord. Now, my lord, kindly come to page 20.
The first sentence of 8.9.4 says, the initial decision to classify any standard or NP account as RFA or fraud will be at the individual bank level.
Yes.
And it would be the responsibility of this bank to report the RFA or fraud status of the account of the on the CRA ILC platform so that other banks are alerted.
Yes.
So this is not required to be done at the outset.
At the outset, one of the factors is this. Other factors also the approval of the consortium bank. So far as late
approval comes later, isn't it? Because this has to be done first.
But this has to be done at first. I am grateful. In case it is decided at the individual bank, that's true. What lordship is absolutely.
So if that be so, why can't we constitute this notice as a notice for this?
My lord, whether this fraud status or the primary satisfaction of the bank has been, my lord, justifiedly done or not, I will show, my lord, one more provision. Then I will come back again.
Because all the things you are saying has to be done. That is only after this reporting of the status on the CRILC platform.
My lord, this is possibly one step ahead. They, my lord, say prima facie satisfaction and prima facie they have seen, my lord, involvement of fraudulent activity. Prima facie, an account has been declared as suspected fraud. So it will have a great impact because I have to get the money from the investors.
But 8.944, does it help you? Because this is the first reporting. Not that.
My lord, this is not an initial decision. This is one step ahead. They have issued me a straightaway show cause. Yes. The initial decision to classify any standard or NPA account as RFA or fraud will be at the individual bank level. True. This is not an initial decision, and it would be the responsibility of this bank to report the RFA or fraud status of the account on the CRILC platform so that the banks are alert. Whether this show cause notice will be construed as an information alert on CRILC, I will come back to that.
After they give you the show cause and you give your answer, if you can't give an answer, they will probably just put it on the, they'll report this, your fraud status on the account of that platform.
Yes.
So they have to do it first before the rest of the procedure takes place, isn't it?
My lord, this is one aspect, but kindly, my lord, comes to page 28 once. This is also important. This has to be read with this, my lord, because I showed you the terms. My lord, reason is kindly come to 8.12.3.
Yes.
No compromise settlement involving a fraudulent borrower, assuming their prima facie view is correct, is allowed unless the conditions stipulate that the criminal complaint will be continued. Fraud measures for fraudulent borrowers, 8.12. This obviously, the show cause notice is part of, my lord, the fraud measures. I mean, sorry, my lord, the penal measures for fraudulent borrowers. This is the first step. Now, my lord, kindly, my lord, consider no compromise settlement. Here, my lord, I have entered into a settlement involving a fraudulent borrower is allowed unless the conditions stipulate that the criminal complaint will be continued. If lordship takes it that that's the very basis when an individual bank is entitled to do it, and they are justified to issue the so-cause notice, then what will this provision, where will this provision go?
How does this help you? No compromise settlement involving a fraudulent borrower. You are an allegedly fraudulent borrower.
Yes.
No compromise settlement involving you is allowed unless the conditions stipulate that the criminal complaint will be continued.
Right.
Yes.
So
No, after you are marked as or declared as a fraudulent borrower, your account is marked. After that, there has to be a stipulation that the criminal complaint will be continued.
But I may not refer to the settlement of April 2023.
That says that no criminal proceeding,
yes,
all criminal proceedings as on that date would be obliterated,
yes,
would be set
yes,
aside, withdrawn.
yes.
Now this is a post facto, subsequent. Now subsequently, if you are marked as a fraudulent account,
yes,
then after that, no criminal complaint will be has to be continued. The criminal complaint has to continue.
Lord,
This is after the marking of the fraud.
Lord, I tell you, Lordship, the forensic audit which was conducted,
yes,
that is prior to the settlement of April 2023.
Forensic audit is not a criminal proceeding.
No, that is the very basis, Lord, the forensic audit.
Maybe that does not help you. The forensic audit report may be a basis of several actions. Some actions were done before that settlement, that settlement was arrived at between you, which says that all pending cases have to be withdrawn as on that date. This is a subsequent post facto situation. Here, under 8.9.4, they have taken an initial decision. They want to take an initial decision before reporting it to that platform. They are giving you a hearing on that. Go and answer them so that they are satisfied and they don't refer it to the CRILC platform. This is a subsequent fact.
Milord, I'm just, Milord,
none of these help you in this particular case.
Milord, I'm just putting this question, Milord, to myself. Lordship considers, Milord, then what would be the effect of having a lead bank in consortium, Milord? Without their approval, if Lordship sees only a part of a provision may not be, Milord, if Lordship has to read, Milord, the entire provision. If Lordship reads, Milord, Lordship is correct absolutely with regard to the initial decision. Now, Milord, whether this initial decision can be, Milord, constituted as part of show cause notice or a step prior thereto. This is important.
Have they taken an initial decision in this case?
Yes, that is, Milord, the show cause notice initial view. The show cause notice proceeds on the basis there is prima facie
the
involvement
first sentence
of
of 8.944 has two components.
My lord.
One is the initial decision to classify any standard or NPA account as RFA or fraud will be at the individual bank level. Now, and it would be the responsibility of this bank to report that fraud status of the account on such and such platform so that the other banks are alerted.
Yes.
Now, according to you, the next sentence, whatever is there after that, that has to, doesn't that have to follow this?
Absolutely. That is not there in the next sentence. That
now,
is
here there is, after the next part of it comes, then the subsequent actions take place.
Absolutely.
In your case, they have not yet classified you as a standard account or at least not reported it on the platform.
Possibly they have not.
If they have not yet, then this is the first initial decision stage. They have given you a show cause, they have been kinder to you than the provisions allow. They need not have given you a show cause, in fact.
That they have done is possibly because of the latest judgment of the present Chief Justice, Milord.
Probably.
Or the alterum partem, Milord.
Probably. To take care of all scenarios. Yes,
you take care of it, you
so
give a
that
notice.
It's not set aside on this ground.
Yes, on the basis.
And you have come to court precisely on that ground. No, this is a premature stage.
Milord, may I, Milord, just Milord show
Take
you
all your points in the response to the show cause and go before the bank and whatever steps they take.
Then Milord, let me Milord clarify. Just Milord, Lottie would clarify one thing with regard what will happen with regard to Milord the settlement. 12th April 2023.
This will be irrespective of the settlement, I'm telling you, because the settlement does not say that whatever proceedings is initiated in future, that will also be withdrawn. It says as of today, whatever are the pending proceedings, those have to be withdrawn. Now, if it is settled ultimately, all this goes.
Milord, there is some difficulty, Milord. Just Milord, I bow down to your Lordship. Milord, Lordship would consider about Milord, about this thing, Milord.
Yes.
Settlement, Milord, I had shown to your Lordship, page 80, Milord. page 95, page 85. Thereafter, my lord, certain communications have been made. It may have an impact on this, my lord. Why I say, my lord, page 80, my lord, 88, lordship, my lord, kindly comes to, my lord. My lord, the letter, my lord, this letter, my lord, I have, my lord, written to them, my lord, after that, my lord. I was telling you,
There is no bar for the bank to enter into a one-time settlement with you.
There is no bar. What I say, my lord,
yes.
On one way, they ask for one-time settlement. I comply with that. I pay.
Yes.
Now, if a part of the settlement clause is not complied with by not releasing the mortgage property, how am I, my lord, meet with the liability?
This is independent of your fraud status.
That's true. That's true.
This has nothing to do with that. Suppose there is a willful defaulter identification. Even after that, the company may very well enter into settlements.
That's true.
There is no bar to that.
No, there is no absolute bar. And my lord, just one more thing before lordship, my lord, kindly, my lord, comes to a finding, my lord. Kindly, my lord, comes to my lord, page, my lord, 6 volume 1 document, my lord.
Which volume?
My lord, this is, my lord, the last volume, 6 volume. Right, the last volume. Volume 6, my lord. Kindly, my lord, pardon me, my lord. 797.
Preserve the volumes for your answer to the show cause.
That I know, lordship would be saying, my lord, the moment I annex and invite the court to go into this,
yes.
My lord, my learned junior says,
no, definitely place it.
My lord,
Why
just,
not?
my lord,
Yes.
because I am slightly apprehensive of their conduct. In 2018, you proceed.
Yes, in the same breath, they are proceeding with your
Yes.
OTS and doing this.
Yes, and
That I can
all after
understand.
2000, my lord, all after April 2023. And
that is also another ground you can take before them, which
yes.
will also have to be considered by the other consortium banks if it is done. I mean, your objection will be on record. Your answer now it will be illusory because there is nothing to show what is your stand in the matter apart from this.
That's true. My lord, kindly, my lord, have a look at, my lord, one document, page 797, my lord.
Yes.
The way they have proceeded.
Yes.
My lord, this was done in 2014. I was submitting before a lordship that initially, my lord, the lead bank of consortium declared the account as fraud, and other banks were also requested to participate or come up with their view. At the top, my lord, 22nd April 2014. Now, lordship would find, my lord, here, my lord, Central Bank of India at the bottom, lordship would find.
Yes.
Central Bank of India, lordship would find lead bank informed that they have already issued willful default notice so-and-so in response to the above company has sent the representation to the legal notice issued by so-and-so. And my lord, pursuant to that, they have declared the account as fraud. Now, my lord, kindly see the name of SBI is there. All banks were invited, no action taken. And just one thing, kindly read, my lord, with section, with my lord, page 95 once, the notice. Prima facie, my lord, kindly have a look at, I know, my lord, I have a difficult hurdle to cross, my lord. Kindly have a look at, my lord, this show cause notice, what they have referred to. There is nothing after, my lord, April 2023. Kindly see the factors of fraud angle. First, as per the sanction letter dated so-and-so, kindly see when the letter was issued, loan sanction, 11th November 2009. Next, 13th March 2014.
They say I'm not. You are on page 95.
Yes, 96. I'm sorry, my lord, page 96. Yes. Factors of fraud angle. This compelled them to issue, my lord, this notice, my lord, on the basis of prima facie finding that there are signals of fraud. Kindly see A, as per the sanction letter, loan sanction letter dated 11 November 2009. And they say I have violated the terms of condition, maybe XYZ, whatever the factors are. Then, my lord, next, they say we have received the fixed that is registered on 31st March 2014. Then, my lord, they say borrowers have certain links with other banks, my lord. Possibly this does not stand at all. Then, my lord, again, next, 4. In the financial year 2011-2012, 97.
Yes.
And the last, as per the meteor report of Central Bank. So all they had knowledge, my lord, when the meeting was, my lord, called in 2014. And after all these things, my lord, they came to the settlement. What is the subsequent fact after conducting a forensic my lord, audit, which, my lord, result was absolutely nothing? Again, after April, they issue this on the basis of these facts. My lord, will I be, my lord, subjected to, my lord, give a reply to this? or the court will ask them to file a comprehensive report. And in fact, in the writ petition, I have made a prayer that kindly direct them to produce all records pertaining to the forensic audit which was conducted in 2018. They have not done anything. I have made a prayer to that effect. And how am I supposed to know? Even in 2023, before April, when the forensic audit conducted, I gave all documents to them. No reply. Straight came the notice. One way you say you settle, and the other way, the show cause notice gives about the certain facts which occurred way back in 2011. So why didn't you proceed in 2014? Prima facie, I leave it to your lordship. If lordship directs me to kindly keep all points open. So
I'll extend the day for about a week, so that you can file your reply there.
Kindly gives me 2 weeks time.
No.
It was there, initially fortnight.
You will
1
just
week,
modify the whatever is there.
I will not run away. I will not run away.
No question of running away. So
after entering into the settlement, I will not run away.
Very good. Learned counsel for the petitioner contends that the impugned show cause notice issued by the respondent number 1 bank, that is the State Bank of India, to the petitioner, for the purpose of classifying the petitioner's account as a fraud account, is palpably dehorates the law. It is contended that in the same breath, the respondent number 1 bank is continuing settlement proceedings with the petitioner, and on the other hand, issuing a show cause notice whereby the petitioner has been sought to be classified as a fraud account. Next para. That apart, learned, please take your seats, all of you. That apart, learned counsel for the petitioner places reliance on an offer for settlement dated April 12, 2023, issued by the State Bank of India to the petitioner. Annexed at page 85 of the writ petition, it is submitted that one of the conditions of the same is that all cases filed by the company directors guarantors, if any, against the bank are to be withdrawn. It is submitted that, as opposed to the said clause entered into the settlement terms with the SBI, the agreements entered into in similar perspective with the other consortium banks contain a contrary clause. By placing reliance on the equivalent agreement with Central Bank of India, annexed at page 25 of the writ petition, learned counsel points out that clause 2 thereof provides that the criminal action case initiated in the account would continue, since the account was declared as fraud. Next para. That apart, learned counsel also places reliance on clause 7 of another such proposal for settlement entered into by the petitioner with the United Bank of India, (A) annexed at page 46 of the writ petition, (closed), which provides that criminal case filed to be filed with law enforcing authority will not be withdrawn and will take its own course for logical conclusion. It is submitted that the show cause notice impugned herein would jeopardize the undertaking given by the bank regarding withdrawal of proceedings. Next para. It is also argued by learned counsel for the petitioner that the impugned show cause notice is contrary to the letter and spirit of the master directions on frauds classification and reporting by commercial banks and select FI(s), dated July 1, 2016, issued by the Reserve Bank of India. By placing particular reliance on clause 8.9.4 and clause 8.12.3, comma, it is argued that the procedure contemplated therein is being flouted by the respondent number one bank by issuing the show cause notice itself. Full stop, next para. Learned counsel further argues that in the minutes of a lenders meeting held on April 22, 2014, comma, it transpires that the SBI, comma, being one of the parties to such meeting, comma, did not initiate any action against the petitioner, comma, whereas the lead bank of the consortium, comma, being the Central Bank of India, comma, had informed that they had already issued willful defaulter notice on 23.11.2013. Full stop, next para. It is argued that the premise of the impugned issuance of notice by the SBI, comma, all on a sudden after so many years, comma, is unknown and has taken the petitioner by surprise. Full stop, next para. In view of the above arguments, comma, it is contended by the petitioners that the impugned notice be set aside. Full stop, next para. Heard learned counsel for the parties. Full stop, next para. In view of the limited conspectus of the writ petition and the relevant documents being annexed to the writ petition itself, comma, affidavits are not directed, comma, since the same would unnecessarily prolong the proceedings. Full stop, it is, comma, however, comma, deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop, next para. Coming to first things first, comma, the petitioner has placed reliance on the offer for settlement made in writing by the SBI on April 12, 2023. Full stop, next para. The same clearly shows that an ongoing settlement is going on between the petitioner and the SBI. Full stop, clause small f of the said communication stipulates that all cases filed by the company stroke directors stroke guarantors, comma, if any, comma, against the bank are to be withdrawn. Full stop, nothing hinges on the said clause, comma, however, comma, insofar as the present case is concerned. Full stop, the said clause pertains to cases filed by the company stroke directors stroke guarantors, comma, that is people on the same footing as the present petitioner, comma, filed against the bank, comma, which were to be withdrawn and not which were to be withdrawn, comma, and not the contrary. Full stop, if the said clause provided that the bank is to withdraw proceedings against the petitioner, comma, it might have had a semblance, SEMBLANCE, semblance of relevance in the perspective of arguments of the petitioners. Full stop, however, comma, the petitioner withdrawing all cases against the bank does not help the petitioner in any manner regarding the present litigation. Full stop, next para. In any event, comma, the said clause only pertained to the litigations which were pending as on that date, comma, that is April 12, 2023, and does not pertain to any future litigation. Full stop, next para. Even if the petitioner is classified as a fraud account, ultimately, comma, the same cannot be fettered or circumscribed by any manner by a previous agreement between the parties entered into on April 12, 2023, comma, which were limited to the cases pending on the said date. Full stop, next para. As such, comma, the contrary clauses in the settlement agreements with other banks is not required to be considered at all. Full stop, next para. Insofar as the reliance placed by the petitioner on the lenders meeting held on April 2022, 2014 is concerned, comma, thus SBI, comma, due to its inaction till that stage, comma, cannot be bound by such inaction, comma, from taking out any proceeding for classification of the petitioner's account as fraud for all time to come. Full stop, next para. The master directions on frauds is very categorical on classifying accounts as fraud accounts, and the purpose thereof, comma, as stipulated in the said directions is with a view to provide a framework to banks enabling them to detect and report frauds early and taking timely consequent actions like reporting to investigative agencies. Full stop, next para. The directions also aim to enable faster dissemination, DISSEMINATION, of information by the RBI. Full stop, next para. Although at the juncture when the bank initially was inactive, comma, that is in the year 2014, comma, the occasion for marking the account as a fraud account had not arisen, comma, nothing prevents the SBI at this juncture, comma, if so satisfied, comma, to initiate such proceedings against the petitioner. Full stop, next para. Lastly, comma, clause 8.9.4 of the master directions contains nothing to support the petitioner's argument to vitiate the show cause notice issued by the bank. Full stop. The first sentence thereof stipulates that the initial decision to classify any standard or NPA account as RFA or fraud, F capital, will be at the individual bank level, and it would be the responsibility of this bank to report the fraud status of the account on the CRILC platform so that other banks are alerted. Full stop. The subsequent procedure, that is, in case it is decided at the individual level to classify the account as fraud straight away, comma, is followed by other paraphernalia and procedure, comma, which have nothing to do with the initial classification of the account of fraud by an individual bank out of the consortium straight away at the initial stage. Full stop, next para. In the present case, comma, the show cause notice issued is apparently at the initial stage, comma, for the purpose of classifying the petitioner's account as fraud. Full stop. In fact, comma, the respondent number 1 bank has complied with all norms of natural justice in issuing a show cause notice, comma, thereby being gracious to the petitioner and complying with the provisions of such natural justice. Full stop. No fault can be founded with the said could be found with the said action. Full stop, next para. Insofar as clause 8.12.3 is concerned, comma, the same merely stipulates that no compromise settlement involving a fraudulent borrower is allowed unless the conditions stipulate that the criminal complaint will be continued. Full stop, next para. In the present case, comma, the petitioner's apprehension that the mutual settlement proceedings between the petitioner and the SBI may be hampered due to such clause, comma, is baseless and unjustified. Full stop. The reason is that the clause in the mutual settlement agreement between the petitioner and the SBI, comma, annexed to the writ petition, comma, pertains to the withdrawal of the then pending cases by the petitioner and not the bank. Full stop, next para. Hence, comma, there is nothing in the show cause notice which could prevent the bank from going on with the compromise proceeding with the petitioner. Full stop. Merely in compliance with 8.12.3, comma, no compromise settlement involving a fraudulent borrower, comma, if the petitioner is so classified, comma, would be allowed unless the conditions stipulate that the criminal complaint will be continued. Full stop. Such clause only refers to criminal complaints which are already continuing and have nothing to do with the previous complaints lodged either by the petitioner or by the bank. Full stop. Hence, comma, the grounds for challenge against the present impugned show cause notice are not tenable in the eye of law. Full stop. Next para. However, comma, keeping in view that the present writ petition was pending and the last date of showing cause by the petitioners as per the bank's impugned show cause notice is due to expire today, comma, the time for filing reply to the show cause notice issued by the bank, comma, on the part of the petitioners, comma, is extended till এর মধ্যে হাত ঝাড়া শুরু হয়ে গেল বাবু এইটুকুনি অর্ডারে হ্যাঁ এতবার হাত ঝাড়ছো কেন ঠান্ডা লাগছে বারবার মুখের সামনে হাত ঝাড়লে আমার মনে হচ্ছে তুমি ইনকম্পিটেন্ট ঝেড়ো না ওটা করো না ওটা ইনসাবঅর্ডিনেশন is extended till August 28, 2023. Full stop. It is made clear that this court has not entered into the merits of the allegations made in the show cause notice and or the reply to be given thereto by the petitioner. Full stop. Next para. WPO 1509 of 2023 is accordingly disposed of in terms of the above directions without interfering with the show cause notice at this stage. No address to cause.
Grateful.
Affidavit of service filed today be kept under court. Go রাখতে হবে বাবু তোমার নামটা কি জানো
For hearing item number 3.
Yes.
Before we start, my lord, on the last occasion, as it had fallen from your lordship,
Yes, Mr. Ganguly.
that whether we have the any such power given in the notification to amend or the certificate granted.
Yes.
Lord, may I directly take your lordship
Right.
to page, my lord, 83. I'm sorry, 83.
Yes.
The certificate of registration. Lord, you got it? 83.
Just give me half a minute. Yes. Yes, got it.
My lord, the certificate was granted under the scheme for 4th March 2005. But
Right.
immediately on the next page, my lord, at 84,
Mhm.
the only amendment or the minimum changes that we can do
Yes.
is point 3. The unit should immediately inform this directorate of any major change of the project parameters, employment, investment, etc. Now, only with respect to that, and so far I have checked and my instructions are, there are nothing as such in the scheme for any rectification or amendment that cannot be done, as it has been pointed out by, fallen from your lordship on the last occasion. my lord.
You have been granting that on several.
Well, no, my lord, only once, that is why,
Yes.
as it has been said that too within immediately, this word is very important. And that's why the first changes has been granted, my lord.
Mhm.
That is at page, my lord, if your lordship kindly take up page 87. The same page at 85, that is the amendment that has been, so, my lord, 20th January 2006, they immediately made an application for amendment only with respect to what? My lord, if your lordship
No, no,
kindly-
the date was 19th of April 2004, page 83 date. Yes. Date on the right hand side.
4th March
Oh, 4th March
2005.
okay.
And in
Oh, right.
immediately they made this application at page 86. The amendment for the first time they have sought.
That is 1 year after.
No, well, 2005 itself. And 86 December 2005. 86 is their application.
Oh, acha, acha. Yes.
Within 9 months they made an application, but and that too for
Right,
this particular purpose. What we have amended, my lord, if I may show the amendment sought for is
Yes.
with reference to the subject matter, we wish to inform that we have mentioned the annual capacity of coal gas to be supplied by Greater Calcutta Gas Supply in our application. We once again mention that the annual capacity will be 144,000,000 cubic meter per annum.
Yes.
And thereafter, moreover, in this application, we had inadvertently mentioned the conversion of furnace oil to coal gas. Actually, it is use of coal gas in place of furnace oil. We regret this lapse on our part, and we extremely sorry for the inconvenience caused to you. Well, what is our amendment to this? Well, at page 87, the same at page 85. On 20th January 2006.
Yes.
To that application, we have replied to is with reference to your letter on the above mentioned subject, the following amendment in respect of change of annual capacity of activity. Only we have focused on that. That much we can do. We cannot amend that. Annual capacity of activity of the project is made in the registration certificate number such and such dated 4th March 2005. That certificate what we have granted.
Following amendment that which includes use of coal gas in place of furnace oil.
Well, actually, the amendment is only the annual capacity not applicable. That has been annual capacity to 144.
So
like
you
that.
say that with reference to a letter, the following amendment in respect of change of annual capacity of activity.
Only annual capacity of
But
activity.
you say existing and amended. In under amended, you say item of activity. You change the item of activity. Yes.
Well, item of manufacture that was said. Item of activity as it was there. Use of coal gas in place of
Under
furnace
the
oil.
proposed amendment, you have also shown use of coal gas in place of furnace oil, not only the annual capacity. You say in your first paragraph that yes, the following amendment in respect of change of annual capacity of activity is made into the registration certificate. But then you go on to show in the amendment not only the change of annual capacity, which was not there at all, to 1,44,000, whatever, 1 crore. And you also show the item of activity to be changed.
Well, my instructions are,
yes,
we have taken only actually this line is constructing the difficulty. Actually, what we have mentioned in the first paragraph, that is only we have said that in the following. That is why the first line says following amendment in respect of what? It has been categorically mentioned. The first line, following the amendment in respect of change of annual capacity of activity. Only that one. Actually, the line ought to have been, the amendment would have been the last column. That is the only one that amendment has been done. This item of manufacture still remains piped coal gas. Item of manufacture. That we cannot change. That is why only annual capacity not applicable. That has been amended to this annual capacity of 144, which as they have mentioned. That is my instruction categorically is we can amend only with respect to this one. And so far as the certificate is concerned, actually, there are other benefits and facilities which can be availed, and with respect to one single certificate is granted, whatever the unit proposes, that is done. Well, that appears from page 50. The scheme itself says there are other benefits too. It starts from one page was missing, what I found. The 13 is one of the subsidy. The subsidy starts from page 7, eligibility criteria, and after that, interest subsidy is there, waiver of electricity duty is there. There are several interest subsidy and waiver of electricity duty, and thereby 13 is one subsidy for conversion for use coal gas. Therefore, for this, whatever they mentioned, we used to generate a certificate for that. If they want an exemption under the entirety, any of the exemptions, that will be dealt with later on, but a registration has to be obtained. Therefore, the general registration is this 83, whereby it has been stated that the item of manufacture will be piped coal gas. Now they are asking for a benefit under a particular head of this benefit that has been provided in the scheme, which mandates that that item should be the end product of this.
by using, I'm sorry, my lord, that coal gas has to be used for manufacture of some other end product. For that particular, this benefit can be taken. Other benefits are applicable to as there are several benefits under the scheme. Certificate is in general. Well, that is all the query that has been filed from your lordship.
Therefore, after getting certificate, they have to.
Well, that's why after getting the certificate, they have to get a particular, that whether they are eligible or not of these particular benefits that are provided in them. So this is a general certificate, my lord. So far as your lordship's query was concerned, my lord, my instructions are this much, that we cannot amend. Therefore, we have not amended. We have only made those amendments which is within our domain.
So this is all.
My lord, this is what my instructions are.
So can you file your written notes of arguments then? I'll close arguments. You want to give a reply?
My lord, on 2 points, give me only 2-3 minutes.
No, Mr. Datta, I'll give you hearing. Let us come back on the next date. Come ready with your written notes of arguments. I'll take those and hear you also. Okay.
But in that case, could it be next week? Monday
Yes, yes. Monday, I've already fixed some of one or two.
Tuesday.
I'll keep it on Tuesday, yes.
Right.
Heard learned counsel for the respondents, footstep. For further hearing, let the matter stand adjourned till August 22, 2023. Footstep, learned counsel for the parties are requested to file the written notes of arguments on the next date as well.
My lord, one page was missing, my lord, before 57.
Yes.
From in the writ petition, my lord, may I supplement only 1-2 sections?
Very good. Thank you very much.
One page is missing.
স্যার এর মধ্যে কিছু তুমি দিলাই করছো এটা রেখে দে তাহলে আচ্ছা আচ্ছা ঠিক আছে থ্যাংক ইউ